Right, good morning. It's 10 a.m. I shall resume the inquiry. Just to confirm, it's an appeal made by Wayne Homes Northwest Limited, again under Section 78 of the Town and Country Planning Act 1990, against a refusal by High Peak Borough Council of an application for full planning permission for residential development comprising 92 dwellings, including areas of public open space, landscaping and associated works at land to the south of Dinting Vale, Glossop. For anyone new today, my name is Gareth Wildgoose and I am a Chartered Town Planner and have been appointed by the Secretary of State to be the Planning Inspector to hold this inquiry. This is day 5 of the inquiry and the 4th sitting day because one of the days on Friday was just a site visit. Firstly, before we get into housekeeping matters, can I just, the usual reminders, can people just turn off their mobile phones or turn them to silent, and similarly with any notifications if people are using a laptop, please. Now, in terms of the format of today, typically we'll take a break in the mid-morning and then 1 p.m. Look to break for lunch, and then there'll be a break in the afternoon. We do have a full programme today, which was slightly different to on Thursday, where there was a reserved time for unaccompanied site visits. Again, just another reminder for those who may not have been before, or if you have, in case you forgot, there are sheets just at the entrance, just to put your name down, just for fire procedures, for checks if in the event that there was a fire. We'll go through the procedures in a moment. There's also a sheet there to put your car park, your reg for your vehicle if you've parked in the car park today, so you won't receive a charge. We have had that confirmed from the hotel. Now, can a representative of the council just please explain the emergency procedures and whether we're expecting a fire drill today?
We're not, sir, expecting a fire drill. The emergency procedures as we've got used to last week, out that door. But this time I'm instructed we should turn right to head to the assembly point rather than turning left.
Thank you. Just to confirm before we get into housekeeping, today's programme is the remaining council witnesses. So it's a witness on viability and planning, and then there will also be roundtable sessions by the end of the day on planning obligations and conditions. That's correct. Now, just a recap of where we've been. It is the 6th and 7th witness that's been called. That will be called by the appellant today. We have had 5 previous witnesses. We also had statements on day 1 and day 2 from interested parties. I will give an opportunity for those who may not have had a chance to speak already briefly this morning, but if there are a number of requests that can't, because we don't have a dedicated time in the programme, if we couldn't reasonably accommodate it, we would ask for a spokesperson. But I will go through the request to speak before we get to calling the next witness. Now, again, just to confirm, site visits have been undertaken. So on the afternoon of day 3, I did do an unaccompanied visit, and then on Friday morning, I did an accompanied visit, including some requests to views from neighbouring properties adjoining the site. So, moving on to housekeeping. Things, obviously, we were last sitting on Thursday last week, and we seem to have received quite a bit of correspondence from Thursday onwards. So, do you want me to run through everything as far as I can see it, and then we'll get to anything that needs any particular discussion? So,
yes, and I will sing out when. If what you read out I've got a hard copy of.
Right, no problem. So the first document that I have is a statement from Sarah Bott, which was previously read out last week.
Yes.
We
have that.
And does the appellant have a copy of that?
Not yet. And yes, electronic, yes.
Yes,
but not-
electronic copy.
But I haven't given out the hard copies yet.
Right, not a problem. Well, I'd compile the hard copies rather than keep coming, because I think we've got quite a few.
And that will be a document, presumably have to be given a document number.
Yes, ID 10, I think. I think I'm correct in that. I think we got up.
Yes,
I
the
think we got as far as
9
ID 9.
Yeah, the 9 series.
Yeah, there were series in ID 9,
Yeah.
but they're all ID 9.
Yeah.
Okay, and then the second document that I've received, and it would be a statement from Emma Kane, and again that was it's a written version of what has previously been given during I believe it was day 3. I presume the parties have a copy of that at least electronically. Happy for it to be accepted as ID 11. Sorry.
Yes, sir.
And then the next document that I have is a written statement from a Mr. Rob Davis.
Yes, sir.
I'm not sure whether, obviously I'll take a view as to whether in attendance today to speak, but if absent, happy in any case to accept it as ID 12 if both parties have a copy of it. Yes?
Yes, sir.
And then the next document I had is an inquiry statement from Timothy Bott, who does intend to read it out this morning, according to the correspondence. Has that been received?
That's just been sent to me electronically, so that's okay.
Appellant received it. Thank you. So I'll accept that as ID 13. And then there were a number of emails from Thursday through to this morning received from a local resident, Mrs. Wilson.
Yes.
The comments ranged from general comments on the appeal to procedural matters to photographs and video stills of wildlife observed in the site. Have the parties seen all of those emails as far as they're aware, including, I believe, a couple may have been sent through quite relatively early this morning?
Yes.
Yes?
So we've got them all.
Okay.
Your case officer sent them through to Mr.
Okay. Have the parties got any specific comments? Are they happy that any relevant planning matters will be covered by the evidence by the
Yes.
end of the day?
Yes.
And are the parties content for the emails as compiled as a whole to be accepted as ID 14?
Yes.
Yes, that was sent.
Just to confirm, it isn't my intention today that written statements are going to be read out by others. I did communicate that to the parties, that because of the limited time that parties have to speak, the people who've attended today will be prioritised.
Yeah.
But in doing so, in terms of efficient use of inquiry time, I did say that there would be a cut-off of 12 p.m. today for alternative submission of written statements if unable to attend. I assume with the parties wouldn't have an issue with that, because the intention is to give an opportunity to read over it at lunch, and then obviously the appellant would have the opportunity to recall a witness should it be necessary to deal with anything that may arise from those written statements if not already covered.
So thank you. I think that's very fair. It gives us the opportunity, as we're entitled to the final word and address any issue through my final witness, Mr. Hurrigan.
Yes, I agree. So far as the various emails from Mrs. Wilson are concerned, they relate both to matters of substance in terms of the planning merits, but there are also some procedural fairness points raised. I have seen the response from the planning inspectorate.
Yes.
I'm assuming that will form part of the ID 14 series, or will it not?
The procedural matter in terms of site visits, which you're referring to, which was a direct response, It wasn't my intention to include it in that because it isn't evidence. It was procedural clarification.
I just wanted to double check what was going in.
Yes,
but we have seen those comments.
Yes,
and they are on the record.
Yes,
which is good. There are also other matters of procedure. For example,
I think you may be jumping to the question, my next question, but I will let you.
No. In that case, I will keep quiet because I was about to ask, will you be calling for any comments on other matters of process? And I think you're about to tell me that you're about to deal with it.
That was just what I was about to do. Yeah. So you did precede what I was going to say in terms of the site visit comments. Just to confirm, there were queries with regards to site visit procedure within the correspondence from Mrs. Wilson. Mrs. Wilson's was a property that was subject to a request to view, which was undertaken on Friday. So there were points of clarification around that site visit and the subsequent site visits that took place within the appeal site and the sites in Chinley. The planning inspector has responded directly to Mrs. Wilson on those points. They're not points of evidence; they're points of procedural matters, and as such. That was the intention, not to include it as an inquiry document, because it doesn't assist me in my decision-making process. There is one other procedural matter particularly that was raised, and that was the timing of the withdrawal of the council case and the ability for interested parties to instruct legal representation. And that's just a point that I will welcome comments from the parties on at this particular point.
Yes, sir. The first thing to note, I think, is that there was no request to you to alter the inquiry procedure as a result of that development. There was, for example, no request for an adjournment. There was, for example, no request for Rule 6 status. Which would have been inevitable had Mrs. Wilson wanted to, for example, as she says, instruct a barrister to attend on their behalf. Secondly, there was no request on day one by a planning consultant to be able to give expert evidence at your discretion without formal Rule 6 status. Again, that would have been essential to make good any claim of prejudice arising. So for both those reasons, we say the process that you have adopted has not been unfair.
Thank you, Mr. Richards. Anything to add, Mr. Barrett?
Sir, I'd like to make the point that the process that's been adopted by all the parties, and you, sir, as the person responsible for procedure, has been manifestly fair. The opportunity has been afforded throughout for persons to articulate their views. But can I just begin with a chronological point? The council's case, or at least 90% of it, was withdrawn on the 22nd of April. The part that was withdrawn shortly before the start of the inquiry concerns viability and lack of provision of affordable housing consistent with policy.
Clarification, Mr. Barrett, was it 4 days before, was that right?
4 days before, yes, sir. Yeah. That has not figured largely, that particular issue has not figured largely, if at all, in the representations to you. There was, on that basis, an opportunity, as my learned friend has pointed out, to write to the inspector and say, can we now please have another CMC, at which, sir, you could have applied your mind to how that could have been dealt with. We know that they have, certainly members of the public, and Mr. and Mrs. Wilson, have access to a planning consultant who is no doubt in a position to advise, including the necessity of instructing counsel or a solicitor to represent them. There was, most importantly, is the point that's just been made by my learned friend. No application for Rule 6 status. No application for an adjournment at the start, even before the start of the inquiry. That application could have been made shortly after the 22nd of April. No request for a further CMC, case management conference. Instructions to experts. You have a very, very wide discretion, sir, to admit evidence. A planning consultant, although one would have hoped, would have been able to provide copies of the evidence before they actually attended the inquiry. You would have had a discretion to allow that evidence to be given, even though we weren't on notice of it for 28 days, 14 days, even 7 days before the hearing. That could have been accommodated over the course of an inquiry that lasted just over a week. So the very short point is this: there was ample opportunity in procedural terms to take that case for an adjournment or whatever forward on behalf of local residents. There was plainly an election not to do so. And therefore, in those circumstances, not only has there been no unfairness, the reverse is true, there has been manifest fairness in the way that the inquiry has conducted itself and been able to accommodate local objections made on the floor of the inquiry itself without notice. I'm not making any complaint about that. That comes with the job. But that's part of the fairness, sir, and part of your responsibility to ensure that everybody who wants to speak, wants to be heard, gets an opportunity, a full and proper opportunity to do so. And I've seen no evidence whatsoever of any procedural unfairness in this case. So that would be my response to the generic point made in the correspondence that you have.
Thank you. And just to clarify, that question was asked because it's a procedural matter at this point, rather than something that that really could have been dealt with in evidence. So that's why that's why we've taken it up front. I'll reflect on the views that I've heard. It isn't a matter upon which I intend to make a decision right in this moment. Given we're all here, it makes sense that the inquiry proceeds in any case, and I continue to reflect on that throughout the remainder of the inquiry and potentially beyond.
Thank you very much, sir.
Thank you. Sorry, I'm just working through documents received, and then I'll take those who wish to speak. Okay.
Just a question.
No, I'll take it very quickly now. But yes.
It's just from what I understand, in light of the withdrawal of the objections by the council, I've read in the procedures that if third parties or large groups such as residents would like to appoint a solicitor on their behalf, it can be given the Rule 6 status for that to happen in advance prior to the inquiry. With the council obviously dropping their objections on the first day, the residents would not be in a position to do that. It's not it's not outside of the realms of the residents to do that. They are currently speaking to a solicitor regarding another development that is taking place off Adelaide Lane. I'm just asking how this can be considered to have no impact on fairness when this clearly damages the interests of the residents.
Thank you, Ms. Darroch. My assumption is the parties don't want to add anything further on that particular point, because I'm assuming they considered it was just briefly covered.
I have covered it, but for the avoidance of doubt, I'm glad to hear that access to legal advice has been taken. We know that access to planning professional advice has been taken, at least by some of the residents. Oh.
Can I just ask no interruptions from the floor, please, when,
the point
when someone's speaking?
that I made, the crucial point, is the council didn't withdraw its case on the first day of the inquiry. The elements of the case that the local residents were concerned about were withdrawn on the 22nd of April. Air quality, highway safety, all those issues were withdrawn on that day. The residual matter related to viability, and then only a very narrow issue on viability, concerning how one goes about doing it, where there's an allocation as opposed to an individual planning application. There was, in short, ample opportunity, should that have been considered appropriate, for local residents to instruct planning consultants and solicitors with a view to them being professionally represented, if that was their wish, shortly after the 22nd of April. So the key point that I'm making, sir, is simply I do not accept that that was done on the very last minute by the council. The council's position was clear a few days before the inquiry, but only on that narrow issue of viability. The principal elements of the case, and of which most of the local residents have expressed very clear concern, were decided that would not be defended from the 22nd of April. And that was that committee report that we've looked at now in some detail. So unless I can assist you further, that's my response to that. I simply don't accept.
Thank you, Mr. Barrett. Like I said, I'm going to reflect on it. It's not a decision that I'm going to make today. Ms. Darroch.
Yeah, sorry, I just wanted to make clear that I only speak as myself as a resident. I haven't got access to legal advice. I'm speaking on behalf of myself. I'm only basing my questions on what I have read in the policies and procedures for a public inquiry. And I do have a lot of concerns regarding that, due to the minimum level of awareness that has been made available about, I know you did the 2-week minimum, of advertising the fact that this inquiry was going ahead. But other than that, as a resident, we've had very little notice. So I speak on behalf of myself. I don't have legal advice. I'm literally quoting from that public procedure, and I don't understand how it is fair. And in regards to me coming along as a resident, I literally found out on the first day, whether you see that or not, I found out on the first day, and I'm interested in this, that the council had withdrawn their objections. That's the people that have managed to come to this inquiry. Other people in Glossop believe that this was rejected and that the council will still stand on these points, and it's got no chance of going through. So you have devoided the residents that opportunity to understand that they are the only other voice opposing yourselves, and in that respect they absolutely would have appointed a solicitor, and that is fact coming from the residents.
Thank you, Ms. Darroch. Unless there's anything that Mr. Barrett or Mr. Richards want to add on that point, just the only clarification is that the consultation we have reviewed. I have reviewed it, and I do have the details of the consultation before me. And again, I can take that away and reflect in terms of that evidence that's in place. Mr. Miskell?
Yeah.
Can I just ask that you just come over to the microphone, just in case it's not being picked up?
Respond to
Yeah.
Mrs. Barrett said.
Yes, Mr. Richards.
Just two things. The withdrawal of the first part of the council's case on the 22nd of April was done through the planning committee, went through the planning committee, and therefore local residents' elected representatives were well aware of what was going on. And the position on the viability was also reported to planning committee. But in any event, my point was that there was no application for an adjournment or Rule 6 statement on day one of the inquiry. So far as I'm aware, there is still no such application. I believe that you would have to deal with such an application if it materialised at any point before your decision was issued. But until there is such an application, we should proceed on the basis that there is none.
We weren't aware, can I just say, all these people heavily invested were not aware. We can speak for ourselves.
Thank you. Can I not have comments from the audience? I have heard the contributions and I will reflect on it. Like I said, I'm not making a decision on any of the points raised today. We are here today, so the inquiry proceeds. Mr. Miskell? Only on this procedural point, please. Nothing else.
On board that the brunt of the objections against this proposal were dropped on the 24th of April. But how was that commuted to the wider public? How was that decision passed across to us? Because we only got it through word of mouth. We're not there trawling through High Peak Borough Council's database on a daily basis. We've got jobs to do. We've got a life to get on with. But in addition to that, regarding Mr. O'Brien's statement, that was pulled 4 days before. Now, the wider community pinned their hopes on that. If you've read this document, we thought it had a lot of credibility, and we still believe it has a lot of credibility. And that was dropped 4 days before. So, 4 days before, 2 days of which are a weekend. So in that time, how the hell are we expected to run and find some sort of legal support, some sort of technical support in a 4-day period which covers 2 days of a weekend? And the whole issue has been about, right from day one, there has been little consultation or little information supplied to the wider public who've had a vested interest in this since 2013, other than people going onto the database. And as we've stated, a lot of people aren't technically savvy. They don't know how to access the system, they don't know how to do links. But that's my point. 4 days before, we banked our hopes on O'Brien's statement and still believe his argument is credible.
Thank you, Mr. Miskell. Anything further from the parties before we carry on with other matters? Like I said, just to reaffirm, it isn't a decision for here and now. I've heard everyone's contribution, and it's a matter that I'll continue to reflect upon throughout the inquiry.
One sentence, sir. The position was certainly known on day one of the inquiry. You received no application.
Thank you. We'll move on to other matters because that's a matter I'll continue to reflect on, and we need not keep going round over the same points. I've heard them. Other documents received. Just to run through those, I've received a response from the appellant. So, and that was to my queries on the planning obligation. Now, I'm conscious that my feedback to assist parties in the roundtable discussion doesn't contain evidence. It just queries, but there certainly does appear to be some evidence in relation to presented in terms of the planning obligation. Now, I'm not saying that there's any problem with that, but the question is, as such, should that be therefore included in the inquiry document for completeness as ID 15?
Out of an abundance of caution, I think, sir, that's probably more sensible. I understand it wouldn't normally, but insofar as our response does draw upon evidence, I think that would be helpful.
Yes, I think that's the difference. Obviously, my feedback was to assist discussions. Yeah. The response is obviously to help marshal those discussions, but it does probably, in my view, it probably does cross the line into adding evidence. So I'm assuming, Mr. Richards, you don't have any objection?
That sounds very sensible.
And then the next was a response from the parties to inspector queries on proposed suggested conditions. This one was probably this one's probably a more marginal call whether it includes evidence, but given the cautious approach taken to ID 15 in the interest of consistency, happy for it to be accepted as ID 16?
Yes, sir. I think consistency is the main point on that one.
And then the next document that I received was a cost response from the appellant. So this is effectively the third piece of correspondence. There was the original application was made by the appellant. A written response has been received by the council, and this is a subsequent, I'm assuming, final response, albeit there'll be opportunities for oral updates should that be necessary during the point that we address costs after closings. My assumption is we didn't take, for reasons that were discussed last week, the fact the cost application isn't evidence as part of the plan, as part of the appeal of itself. It's a separate process. It wasn't included as an inquiry document. So my immediate inclination is that we continue that approach for this document, but just whether the parties have got any particular comments on that approach.
No, sir. I think that's a consistent and appropriate approach. We're confining the inquiry document series to those which have at least some evidential content.
Yeah.
Or relationship with the planning merits of your decision.
Thank you. They're all the documents that I'm aware of. Is there anything else I should have received that I've not referred to at this particular point? I'm up to ID 16 at this particular point, just to help
So
the
can I
parties.
just raise one issue in respect of the cost? Miller and Friend and I had a very brief discussion at the start of the day. Normally, sir, you would hear any cost application and response at the very end of the case, after enclosing. The way that both Malone and Friend and I have approached this is to provide you with written documentation throughout. And to save inquiry time, although I think Malone and Friend and I want to have one pretty minor comment on a footnote in my reply, we would be content, sir, that you treat those documents as our submissions without anything to add to save the inquiry time. Unless, of course, sir, you would wish that to happen, and or you had any particular queries over the content of either document.
No, that's helpful to me. I was going to propose to take those written comments as read unless there are any particular updates to it. Obviously, I'm mindful that the remainder of today and closings are to come. So, I'll reserve any particular position and allow the parties to have their position should something arise that necessitates an update on cost. But I was going to take them as read unless the parties had any particular verbal updates that they wish to make. But we will deal with them immediately after closings whenever that may occur. In the programme, the closings are reserved for a virtual closing tomorrow with costs, but it does depend on how we proceed today. If we happen to take them early, we'll see where we are on that particular point with the timetable. Obviously, we do have a relatively full programme today, and there are quite a number of residents in attendance. Now, I am going to prioritise those who have yet to speak. Firstly, and we do have limited time, so I do ask that you try not to repeat anything that I've previously heard. I am aware of the strength of feeling from local residents, both from the amount of written evidence that's before me, including all the representations to the applications, all the representations to the appeal, and the contributions that were made to the inquiry last week. So that's the reason that I'm just asking. It doesn't assist the inquiry to hear the same points repeatedly. I have heard them and I will take them into account. Mr. Miskell?
Yeah, just getting back to the statement she read out the names. I didn't hear my name being mentioned or that matter, Mr. Dave Bennett. And we actually spoke last week and submitted a statement.
I think Mr. Bennett's statement's already listed.
Mr. Bennett's statement of last week is already listed.
Yep.
While we've been here, I've just been informed that there are 2 further statements in the course of being printed that have been received this morning by the council, and they are from
Dave Bennett.
yes, Mr. Bennett.
And Emma Greengrass.
Yes.
Emma Griffiths.
Griffith.
It just says Emma G on the email, I'm afraid.
Okay. But anyway, so there are statements continuing to come in.
And in terms of Mr. Miskell, have you received the correspondence that you're aware of?
I haven't seen one from Mr. Miskell. It certainly wasn't in the list up to IQ 9, which is where we got to at the back end of last week. But we can sort it out. If during an appropriate break in proceedings, whether it's the mid-morning short break or the lunch break, Mr. Miskell has a quiet word with Mrs. De Bruin, if there's been an email to the council that's gone astray, we can seek to find it.
Thank you. I've just received notification that we may have something else that's arriving at the moment, so I'll just respond
Yes.
to that.
Yes, we can find out and trawl the council's email inbox. Of course, we can't trawl the case officer's inbox at PINS. So,
I've asked. It's further correspondence from Mrs. Wilson. I think it's specific to the viability witness that will be taken today, I believe. I've asked that the email sent to parties first. I haven't seen it. It was a question. Should the parties be receiving it right now? So I've just said it should be forwarded to you. I would like the parties to look at it. It may be a case that we do adjourn after we take statements, if that's received, so you can review it before you call your witness, Mr. Barrett. And then you can let me know whether you're happy for it to be accepted at that particular point.
I'm assuming, sir, that your case officer is going to forward it to Mr. Mellons, who can forward it to me.
I've literally just asked,
Okay.
asked that it's forwarded to the council and the appellant to allow you to review it first. Thank you. Miss Darrett?
I've had a statement on behalf of Ross Darrock on dated. I'm hoping he's going to email it over before 12 today.
Okay. So, as far as I'm aware, we're waiting on something from Mr. Bennett, Miss Griffiths, we believe, but we're not sure in terms of the surname. An arrangement with to see what's happened with Mr. Miskell submitting evidence, and Mr. Darrock's statement by 12. Now, is there anything else? Anything else on other procedural matters before we move on to taking statements, prioritising those that haven't been heard previously?
No, not from my side, thank you, sir.
Thank you. In that case, can I just ask those who wish to speak today, starting with those that haven't spoken before? Yes, sir.
My name's John Pate, P-A-T-E.
So, sorry. Can you just come to the microphone just so I can hear it, and then spell it out, and it's so that people at home can hear it as well. If you can just spell out your surname.
Yeah, it's P-A-P-E, Pape.
Okay. And who are you representing? Are you local resident?
Myself and the High Peak Badger Group. It's only a short statement, and unfortunately, I'm only available until 1 o'clock.
I'll take you first. So, what's the badger group?
High
Sorry.
Peak
High Peak
Badger
Badger Group. Anyone else who wishes to speak? Yes, sir. If you can just come to the microphone. When you're giving evidence, we will ask you at the table because I can hear better
That's
the
fine.
evidence and,
Yes.
and the parties can there. But when we take questions and introductions, it's just from that microphone there, please.
It's Jason Gleave, Gleave, local resident.
Thank you. Anyone further wishing to speak?
I know you've read out.
Is it Timothy Bott?
It is, yeah. But I don't want to sort of restrict anybody else if both parties have got the electronic copy of mine. I would like to read it out, but I don't want to restrict anybody else because I know you push for time.
Well, the point of reading it out, and the reason why there's a different approach to making a statement in the room compared to written statements is, if you give a written statement here, there is the opportunity, should you wish to do so, to answer questions.
Right.
And obviously, when evidence is tested through questioning, it can carry more weight than just a written statement alone. So that's why there is a difference. So if we do have time, we will take a statement. But anyone giving evidence today, it's entirely at their discretion whether they do take questions from parties or myself. It's entirely up to you, but that's the point. It can carry more weight because it's tested in evidence.
Right.
Thank you, Mr. Bott. Mr. Miskell?
Yeah, a further statement on behalf of, well, it's numbering over 1,000 petitioners now. Do you just inform me of one or two queries you'd like to be raised?
Thank you. Any other requests?
I think you've got my written statement, Mr. Bennett, electronically, but it's only a short statement and I quite like to read it out, and I'm more than happy to answer any queries in relation to it.
Yeah. Thank you, Mr. Miskell and Mr. Bennett. I will take you both again, but I do have to advise both of you that I won't accept evidence that I've already heard. So you need to be moving the evidence forward rather than repeating what's already been said.
You did ask during my statement, as regards AQ&A, about the periods of blockages on the A57. So basically, it's in this statement, been supplied with the information, just a list.
Like I said, if it's new evidence, that's fine. I don't want to hear the same evidence over and over again.
It actually helps. You will get a better understanding now of the traffic flow's been restricted across the.
Thank you, Ms. Quist. Like I said, as long as it's new evidence, there isn't an issue. I just have to give the warning because efficient use of inquiry time, hearing the same point over and over again, isn't helpful.
Yeah, if you feel it's the same evidence, just feel free to no doubt you will.
No doubt I will. Thank you. Anyone else who wishes to speak? Okay. Right. In that case, are the parties happy to proceed? Happy for us to take statements? Yep. Like I say, we'll work through the statements now. It will involve an adjustment to the timings, but I think we do potentially have the ability to make it up given the work that's been undertaken in advance on the planning obligations and the conditions.
I think that's right. So yes.
So I think it is necessary to take the statements now. This will be the final opportunity to speak. So that's just to confirm, because today is proposed to be the last sitting day. That's notwithstanding my consideration of that procedural matter and any decision I should make in due course. But based on the inquiry time that we have in place right now, it is the final opportunity to speak, because tomorrow's a virtual sitting day and it doesn't involve even me asking questions, never mind any other presentation of evidence. Closings are effectively summary of where the parties have got to at the end of the inquiry time and the evidence that I've heard. Okay, with all that said, I'll move to Mr. Pape, please. Feel free to just make yourself comfortable, Mr. Pape. If you just give me one moment just to make a few notes, things like the time. Thank you, Mr. Pape.
Okay. My name is John Pape and I've lived in similarly Glossop for 35 years. I'm also a member of High Peak Badger Group, which is a voluntary group whose primary role is the protection of badgers. I've been a member of High Peak Badger Group for over 30 years, during which time I've gained a wealth of knowledge in relation to badgers and their habitat. In the evidence given to this inquiry last...
Sorry, Mr. Pape, sorry to interrupt. The only thing that I've got to advise you in particular with respect to badgers is if we can refrain from any comments that identify where sets may be. So
Okay.
you need to be non-specific in terms of where sets may be. Now that is necessary because of the risk of activities such as badger baiting,
appreciate
etc.
that.
So I'll give you a moment if you get the point where you may have been specific to maybe look at that and try and rephrase it so it's not available to public. I've just got to bear in mind we're being live streamed and we don't know who may be observing, so we can't take that risk. Just, sorry, I wouldn't normally interrupt, but it's the same for inspectors in decision letters. We are non-specific on such matters.
It's a little bit difficult because the essence of my inquiries is basically I've been monitoring badger sets in the local area, and the object of my coming here today is really to give evidence that there are badger sets close to the proposed development site, and that, in my opinion, they're coming down onto the proposed development site to forage, and local people have seen evidence of this. But if I can just go back to the statement I've written.
No, sorry, I am really sorry to interrupt you, but that was a very important intervention because I couldn't allow you to continue because you couldn't not unsay it, shall we say so.
So I've covered the fact that I know the badger sets in the area, and that in my opinion they're coming down onto the proposed development site to forage. In the evidence given to this inquiry last week by the ecologist acting on behalf of Wayne Holmes, she stated that based on survey information, badgers are not present on site. Many of the locals, including myself, were dismayed by what they heard, and some have seen evidence to the contrary. And in the interest of fairness and clarity, I feel obliged to respond. I've covered the fact that I know that the badger sets in the area, and these have been in existence for as long as I've lived in Glossop, and probably they were there a long time before. I've monitored the sets in the area for many years. And the main set in the vicinity of the proposed development site. I visited as recently as the 17th of June this year. Found this sector very active. It's a set that I've monitored regularly over the years. It's continually active throughout the year, as opposed to other sets in the area that may be sporadically occupied by badgers. I don't know the extent of the ecological survey that was carried out, but you don't have to venture far along the path which leads from the proposed development onto the railway embankment to find evidence of badgers. As I said earlier, I have no doubt that the badgers will be coming down from the embankment to forage in the field subject to this planning application, and that the paths described by the ecologist as mammal paths are in fact used by the badgers. Mr. and Mrs. Wilson, who live in the house immediately adjacent to the field, have video footage of them in their garden. They've also been seen on the cricket field at Dinting and the back gardens of houses on Simony Lane. Anyone who knows the geography of the area will know that the badgers would have to cross the field in order to get to those locations. Badgers are resilient creatures, and I have no doubt they will survive. But with the ever-increasing building of housing developments on greenfield sites, badger habitats are continually being squeezed, and with the government-sanctioned culling of tens of thousands of badgers each year, We can ill afford to lose any more. Whilst it seems to be accepted by Derbyshire Wild Trust that this development will not have a direct impact on the badger sets themselves, it will undoubtedly have an impact on their foraging grounds. If this development is given approval, then I dare say it won't be long before we start getting complaints that the badgers are digging up people's manicured lawns. Well, I'm sorry, the badgers were here first, and you're living on what was their territory. And that concludes my statement. I'm aware of the time constraints. I just have one additional comment.
Yes, Mr. Pape.
I'd just like to add that I think High Peak Borough Council have acted shamelessly in basically leaving the local residents to fight this planning application on their own. I followed the progress of this planning application throughout and attended the meeting on the 24th of October at Buxton when this planning application was unanimously rejected by the Development Control Committee, made up of local councillors elected by the residents of High Peak to represent them. It was obvious at that meeting that High Peak Borough Council were keen to push this planning application through, and that no doubt is because they have a piece of land adjacent to this site that they're also keen to develop for housing. It seems High Peak Borough Council have done everything within their power to overrule the decision made by the Development Control Committee, resulting in them withdrawing all of their objections. To me, this makes a mockery of the planning system and also the democratic process of electing our local councillors. Thank you.
Just catching up. Thank you, Mr. Pape. The only point of clarification, I've not got any particular questions. Obviously, I was trying to be very careful in terms of identifying set locations, etc. And I think it was suitably vague on that particular point. But the one point you did raise was Mrs. Wilson's correspondence. Now, just to confirm, in ID 14, those stills of the video have been submitted, and I have them before me. So just to clarify on the evidence you referred to it, I have seen those stills that were provided. Nothing further from me. Are you happy to take questions from the appellant?
I am, yes.
Thank you.
Yeah.
Mr. Barrett, whenever you're ready.
Thank you. Mr. Peake, I may have misheard, but I thought you had said it had been reported to you that my clients, the appellants that is, had not noticed or not noted the presence of badgers on this site.
No, I didn't say that. I repeated what she had said in her evidence to the inquiry last week, I believe, that it's a direct quote. Based on survey information, badgers are not present on site.
Well, that's not so, is it? Because you have seen the report, a bespoke report that dealt with badgers. It's core document 1.39. Are you familiar with that document?
I'm not familiar with that document.
Let me read you out what my clients have actually said. In that report, and I'm very conscious of the fact that the inspector, quite rightly, has said we should avoid identifying the sets of badgers. Paragraph 1.1, this follows the completion of an extended Phase 1 habitat survey undertaken in November 2021 by TEP, which identified the presence of badger activity within and immediately adjacent to the site. That exactly conforms with your advice, doesn't it?
It does, yes. I was responding to... I haven't read that core document, but yes, I agree that confirms that the badgers are present.
Now, 2.3...
But I was responding directly to what the ecologist said last week.
No. The appellant hadn't said that at all.
No, she'd said, based on survey information...
Mrs. Wilson says that's what the appellant said. That was wrong.
No, I've listened to the ecologist who gave her evidence last Thursday, and she says, based on survey information, badgers are not present on site. That's exactly what she said.
That's what Mrs. Wilson said.
No, that's what Rachel Kerr said.
There's no sets on site. And that's right, isn't it?
Badgers are not present on site. So she's virtually implying that badgers don't use that field at all.
I'm sorry, she refers to, in her evidence, CD 1.39. Anybody reading her evidence
I haven't read that
would see that.
Can I just pause everyone there? Can the witness and the barrister please don't talk over each other, and please, when questions and answers are being given, can the audience just refrain? Because I've got to concentrate on the question and the answer, and so it doesn't assist me when there's noise taking place all over there. Those who are giving evidence, you will get your opportunity to provide it. Mr. Barrett, please resume.
Paragraph 2.3.2, I'm going to read out from this report, under the heading Badger Survey. The Badger Survey area was surveyed for evidence of badger sets. Any sets recorded were classified according to the published criteria. Evidence of badger such as paths, hairs, latrines, footprints or sign of foraging were also recorded. Descriptions of signs of badgers have been provided in Appendix B. Can you agree, Mr. Pave, there is no badger set on the appeal site?
I could agree with that. I think we all accept the badger sets in the area, but the particular point I'm addressing is that in her evidence this inquiry last week, the ecologist implied, and correct me if I'm wrong, that the badgers were not coming down onto that. There's no evidence of badgers coming down onto that field to forage. I'm
Thank you, Mr. Bennett. I think I've got the point. I think I've got the point of where the difference is, and I think Mr. Barrett's question was leading to clarify if there was any misinterpretation of that particular point. I can't ask questions from the audience at this particular point.
And
Sorry.
And just for the inspector's note and for your information, Mr. Pate, the Badger Survey, CD 1.39, actually provided, by reference to a map, the evidence that there were mammal paths on the appeal site within the red edge and within the margins of the red edge as well. And that has been taken on board in the design of the scheme. I'm not sure you're aware of that, are you?
Well, I think they were conveniently referred to as mammal paths to avoid actually saying that they were badger paths.
The evidence was that that's what the badgers are using. That's the purpose of a badger report.
Yeah, she used the term mammal paths, I believe. I mean, obviously, badgers are mammals, and it encompasses the badgers. But it is more than likely, in my opinion, that those paths are paths that are being used by badgers. Badger paths have distinctive signs. They tend to go in straight lines, and they travel from. They use the same paths every night when they go on their foraging trips.
Mr. Pate, I'm sorry.
They go underneath fences where other animals wouldn't be able to go.
Now, I understand you haven't seen this badger survey. Is that right?
I haven't read it in detail, no.
Have you read it at all?
I don't think, no.
Were you aware of it before you gave your evidence? Were you aware that my clients had actually produced a bespoke badger survey?
Well, I assumed it would be included.
Were you aware, Mr. Payne, that we had done the work?
Well, obviously I was aware that an ecological survey had been carried out.
It's not an ecological survey, it's a bespoke, specific for badgers. Were you aware of that?
I haven't read all the documents, no.
And even if you'd read the ecology proof of evidence, it's one of the documents that was listed on the face of the evidence, wasn't it? If you look at it.
As I've told you, I haven't read the document. The purpose of me coming here this morning is to respond to the ecologist's evidence that was given to the inquiry last week, which I felt was misleading,
Right.
and so did many of the locals who had seen evidence
Can't
to
take
the
question,
contrary.
Mr. Miscon, sorry.
I'm not going to take that any further, but so that the factual position is absolutely clear, the appeal site doesn't contain a badger set, we can agree,
I can agree.
and it has been acknowledged in the evidence of the appellant in respect of a specific survey that badgers are using the appeal site. Correct?
You know, I accept that because the evidence given here by the ecologist, there was no mention of badgers using the appeal site.
I read out,
She referred to them as mammal paths.
if that's your position, Mr. Pape, so be it. I have no further questions. Thank you, sir.
Thank you, Mr. Pape. Thanks
Thank
for
you
your
very
evidence.
much.
I don't have any
Do I
further
need to
questions
give
on
my copy of my statement to...
that. If you can, the council happy to take it and then it to be circulated from there. We'll deal with additional documents after the break if we've got anything before we call witness. Thank you. I'll take Mr. Bott next, please.
Good morning.
Whenever you're ready, the same principles apply. I will ask you whether you wish to take questions after you've given your statement, if that's okay. Okay.
Thank you. Good morning. My name is Tim Bott and I am a resident of Adderley Place and have lived in Glossop for 30 years. I would like to make a short statement in opposition to this planned development. Any questions contained are either rhetorical or aimed at the inspectorate to consider. I apologise if some points go over same ground, but I was unable to attend earlier in proceedings. Firstly, is the topography of the site factored into the traffic and emissions estimates? As previously stated, families where one or both parents or carers are working are likely to drop their children at school on the way to their place of work. With this in mind, and all other journeys occupants would take, is there a software model that calculates the increase in journeys made by car in relation to the gradient to the routes that are to be travelled? The appellant states, this quote, "The site is located in close proximity to shops and services promoting sustainable means of travel." But when you visit the site and consider the new access road, the footpath at the side of the cottages and Adderley Place itself, you will clearly see that it does in fact do quite the opposite and will do nothing but encourage increased car journeys. The fact that one other example of this level of gradient was permitted shouldn't be a reason to allow it here. Two wrongs don't make a right. Secondly, I would like to outline my concerns regarding access to my property. Wayne Homes are fully aware and have declared that they cannot prevent our legal access via PROW 50. There has been no consultation with residents about how this will be achieved, especially during the construction process. I directly emailed Claire Campbell to inquire about this very matter, and all she would say was that access would not be restricted and we could continue to use the lane. It was only in the revised plan after initial rejection that Wayne Homes offered any form of solution, still without consultation with those impacted the most. Whilst Wayne Homes have provided residents with, as they say, a better option by allowing us to use the new access road, how do they propose to build this road without obstruction? I am not convinced by the solution Wayne Homes have offered. Consider the scenario. My child has a place at Simmerley School and I live on the lower part of the estate. To pick my child up is fine, but when Sorry.
It's fine. Go ahead.
To pick my child up, I drive either from my place of work or from my house using the new access road, turn right onto the A57, right at the roundabout, up Simmerley Lane to reach the school. Coming home, I drive down Simmerley Lane and do not wish to sit in congestion on the A57 outside Dinting School, so I turn onto Adderley Place, go straight across the raised table, turn round in the residence car park and travel back to the raised table, turn left to my house, avoiding any traffic. This is just one example. It could be used similarly by delivery drivers. In addition, let's imagine the A57 during the construction phase of the access road. It only took for Dinting School to hold their sports day on Friday afternoon to completely block the A57, which led to police being called. Yesterday, PCSOs were outside the school ensuring traffic could move freely. My wife is a deputy head teacher at a local school, and she has spoken to Lynn Elliott, the head of Dinting, about the development, and Lynn has given her permission to read out the following. The proposed housing opposite the school, along with the bypass and increased traffic through Glossop, all adds to the pollution outside Dinting, which I believe is impacting negatively on my numbers. You may have heard about the traffic problems yesterday's sports day caused, which resulted in police attending and more bad press. My governors are opposing these houses. I've got a copy of that if anybody requires it. In conclusion, when I try and understand why this site has been chosen, the only answers I can find are the increased profit of building properties in an affluent area and the potential for the development in the adjacent council-owned land. All we can ask is that the inspector looks at this site and considers that if another development of this size is needed in Glossop, does this one add to the town more than it would take away? If in your wisdom you decide to grant permission for the development, where is our recourse when the inevitable issues raised here with you become our reality? Thank you for your time. And can I just mention or ask a question about the statement that Mr. Pape has just given? Can he provide or explain the location of the badger set privately? Because I'm sure that this shows that the development site is very crucial to their environment.
No. No, there isn't the opportunity for a closed session to give that evidence, and I'm not, based on the evidence that's before me and what I've heard, I feel that I have an understanding of where they may be.
Okay.
To the extent that it isn't something that I could particularly report in the decision notice in any case. So the value to me in terms of understanding the precise location doesn't assist the decision that I ultimately make. The broader point that's been given and the responses to the questions, together with the evidence that I've got, I feel that I've got an appropriate understanding of the activity that's occurring or otherwise in that particular location.
Okay.
Thank you.
Thank you. I think I've stated at the beginning that any questions were rhetorical and aimed at yourself to consider, so I wouldn't like to take any questions.
Okay, if you don't wish to take questions, that's absolutely fine. Obviously, you've heard the point that it's effectively treated similarly to a written statement in that context. But okay, thank you very much.
Thank you.
Mr. Barrett, I trust in the absence of questions that if you feel it necessary, your planning witness will pick up anything that you feel necessary to cover. Should you consider it necessary in the absence of questioning?
Thank you, sir. That would be the position. Mr. Hurrigan would be my final witness, and he can deal with it.
Yes, thank you. Can I take Mr. Gleave now, please? Thank you, Mr. Gleave. Whenever you're ready.
My name's Jason Gleave. I'm a resident of Adley Place. The following data and survey was compiled by my wife, Julie Greengrass, and I'm going to read that on her behalf. She's going to send over all the data that she's compiled later on.
Thank you. By 12, if that's...
Yes,
if
she's aware.
Yes.
She sent me a message.
Just to reaffirm it, that cut-off date is necessary. It's to allow myself and the parties the
Well,
opportunity to
she's
review
watching
it.
now, so
Yes.
she will have heard that.
Yes, that's
so
fine. Thank you.
You heard that, Julie. Right, background. So since 2016 and the late addition of Adley Place to the local area plan, it has always met strong objection from residents of Glossop. After a recent review, a requirement for a minimum of 30% affordable housing has been classed as outdated by the local council. This decision has been unpopular with residents. It has not helped the council meet their annual housing targets, only achieving them twice since 2016. The most recent data from the High Peak Borough Council local plan, which was on the 23rd of June 2022, illustrates this decline. And again, the figures are on the hard copy that's the electronic copy she'll send over. Despite additional building in the High Peak, the council is still not meeting the housing needs locally, which is surely what a local area plan should be about. Land and housing development. Land in the High Peak available or suitable to build on is finite, yet the housing targets appear to be infinite. It is crucial that designated land is used efficiently and to meet local needs. There is a concern that developing properties that are too expensive or not right for the type of local market could be considered an improper use of scarce land. It is counterproductive for the council to accommodate development plans from developers who claim that infrastructure costs make a project unviable, especially when it results in a shortage of the housing needs in the area. Survey insights from local estate agents. In a survey conducted of local estate agents, which is in a separate document, many indicated that the balance between property supply and demand in Glossop is skewed. The housing plan submitted by Wayne Homes does not address these issues effectively. Estate agents provided key insights to the housing market in Glossop. Firstly, the need for more bungalows. There is a significant need for more bungalows. Larger 4 to 5 bedroom homes are not moving in the market because there is no suitable downsizing option for empty nesters such as 2-bedroom bungalows. Demand for 2-bedroom houses. Young couples, especially those moving from nearby towns in the city, are seeking 2-bedroom terraces priced between £100,000 and £200,000. Increasing stock in this category could help young couples get on the housing ladder for both inside and outside Glossop. Issues with flats and apartments. Although there are 2-bedroom flats and apartments available on the market, first-time buyers are often deterred by high service charges. Additionally, these properties tend to sell slower in a sluggish market. Properties over £400,000. There is a notable difficulty selling properties priced over £400,000. Many homes in this price range are being reduced due to low demand. Ageing population. The population in England is ageing with significant increase in the number of older adults. In the last 40 years, the number of people aged 50 and over has increased by over 6.8 million, which is a 47% increase. Those aged 65 and over have risen by more than 3.5 million, a 52% increase, now making it up to 18% of the population. Projections indicated projections indicate that the number of 65 to 79-year-olds will increase to over 10 million, a 30% increase in the next 40 years. The fastest growing segment are those aged 80 and over, which is expected to double to over 6 million. And that information is taken from the Centre for Ageing Better, and Julie's put the link on the electronic copy. This demographic shift aligns with the local estate agent's observations that there is a growing need for housing suitable for older adults. Local challenges. Several issues have been identified with recent housing developments. The concern is that these issues could also affect this development. Unadopted roads. In many new housing estates in Glossop, roads have not been adopted by DCC, leading to desperate problems for residents. For example, Croft Park has residents paying to complete the tarmac following the bankruptcy of the developer, and Charlestown View has unfinished roads with raised manholes and improper drop curbs. Construction and land stability issues. Developers like Ecotech on the Glossop Road face land stability challenges with unfinished houses requiring demolition to meet building regulations. In conclusion, the current housing development plan for Wayne Homes does not adequately address Glossop's housing needs. The lack of suitable and affordable housing options is a significant issue. There is an urgent need for more bungalows for older residents looking to downsize and to free up larger family properties, affordable 2-bedroom terraces for young couples, better management and completion infrastructure in new housing estates, contingency plan to meet costs and development and future management of the site, with the instability of an election and war potentially affecting interest rates in house purchases. Confirmation that the management company that can maintain the estate to a high standard, especially the access road, should the property sales prove to be slow. Developing properties that meet local needs rather than meeting profit and cost targets of the developers, and only appealing to incomers will help avoid exacerbating existing issues, such as the strain on local infrastructure, including leisure facilities, the swimming pool, the leisure centre, and the oversubscribed Scouts and Girl Guides, and the slow sell-through rate, ensuring that new developments align with the actual housing demands of the Glossop community is essential for sustainable growth, high-quality estates, and resident satisfaction. That's it.
Thank you, Mr. Cleave. I don't have any specific points of clarification on what I've heard. Are you happy to take questions?
I can take questions. I'm not entirely sure how well I'll be able to answer them because, I didn't put the survey together, but I can give it a start.
Good morning, Mr. Cleave.
Morning.
Quick question. My client's proposal is a full application, so that you will be able to tell what proportion are different bed numbers.
Yes, we have that information.
Yeah. And you will know from that information that 30% will either be 1 or 2 bedroom properties.
Are those the affordable houses that you don't want to build?
Those are the properties that my clients are proposing.
Okay.
30% 1 and 2 bed. And can I just read you a paragraph from the committee report, which is core document 3.1.
Certainly.
Having set out the proportion at 7.35 of the mix of houses, they refer to a document that is known as the HELNA, which is the Housing and Economic Land Needs Assessment, which sets out the proportion of housing needed in Glossop.
Okay.
I don't know if you've had access to that document.
I personally haven't.
It is a public document, but I'm not surprised if you say I haven't read it from cover to cover. Having done that exercise, the conclusion of the report to Planning Committee is the above data analysis, this is 7.312, the above data analysis indicates that the indicative mix is broadly in line with the requirements, that's of the Hellner study. Use of the market adjustment scenario for benchmarking is considered preferable, as this takes account of the increase in demand for larger properties in response to post-pandemic working patterns and related home working requirements. So in short, the officers of the council considered the mix that was being proposed as entirely appropriate for Glossop and High Peak, didn't they?
Can I just ask a question before I answer that? What percentage of the, I don't have the figures to hand, but my wife did show them me. What percentage of the build are within the £400,000 that are struggling to shift in Glossop at the moment?
Well,
sorry.
No, that's fine. It's fine as an illustrative that you don't have the answer to that. I can't, unless Mr. Barrett really wants to assist on that point. He's asking the questions and he's not giving evidence. So unless he has it to hand as part of the passage that he's referred to, there can't be really a reasonable expectation.
The only way that I can answer that is my wife went to a number of estate agents in Glossop on her own time, interviewed them and just asked what was selling, what was needed. And that is what this is based on. And what those estate agents said is that the housing, I realise that you're saying that there are some smaller properties which, Glossop needs, but from my memory, I say I can't pick out the percentages, a lot of the percentage falls within the housing bracket that the estate agents within Glossop are struggling to sell, which is the 400,000 plus houses. If that answers your question.
I just wanted the inspectors to be aware that the number of 4-bedroom properties in the mix are a total of 15 out of 92, less than 20%.
Right, okay.
Yeah. Mr. Gleave, I have no further questions. Thank you very much.
Thank you very much for your time.
Thank you, Mr. Gleave. Mr. Bennett? Whenever you're ready to make your supplementary statement, Mr. Bennett.
Thank you very much, sir. Yes, this is a very short statement, and in part, some of the queries that I have actually also been raised this morning by Mr. Bott around access onto Adderley Place and Simondley Lane. But I just wanted to confirm, really, that the verbal statement that I gave at the inquiry on day one did actually endorse the written comments that I'd already submitted to the inspector, confirming my objections to the proposal. Now, I note this morning there has been some discussion around the weight given to the issue of affordable housing on the property, on the development. In my objection, I did specifically state that I felt that the lack of affordable housing was a real disadvantage to the merits of this development, and that to not be able to deliver one affordable housing out of 92, I think, is a dire statement in terms of the viability of the site overall. So affordability, I think, is an issue, even though it has not been concentrated on at this inquiry due to the other pressing matters that have been raised.
Yes, just to confirm, Mr. Barrett's yet to call his viability witness or his planning witness who will have the opportunity to cover those matters.
Okay. In addition to the statement I made on Monday, I'd like to draw the inspector's attention to the categoric assurance that was given by the Wayne Homes expert David Roberts, I think, that it would not be possible for a vehicle leaving or entering the development from the main access road to and from the A57 to turn onto the unadopted road that serves Adderley Place and to leave the development via the road onto Simondley Lane. I think he stated this at around 5 hours and 20 minutes into day one.
It's very precise.
Well, I've looked at the video. After further review of the evidence given by Mr. Roberts on day one, and around 6 hours and 27 minutes into the inquiry, again from the video, it would seem that It would be possible for delivery vehicles, I think has already been said this morning, or other vehicles, entering or leaving the development on the main access road to turn west towards the houses in Adderley Place to make deliveries. It would therefore also be possible for cars from new houses to do the same and to turn at the west end of Adderley Place and then approach the junction, the Bollard Junction, and carry on across it to the east and then to access Simondley Lane. This would negate the purpose of the bollards and make it possible for cars to use the unadopted road as a rat run. In view of the desire to avoid this possibility, if the developer were to succeed with this appeal, it is essential that a planning condition be imposed to avoid this possibility, so that the development cannot be completed until it is shown to be impossible for cars leaving the development to use the unadopted road as a rat run. Thank you.
Thank you, Mr. Bennett. I believe I've heard a similar. Just for clarification, I believe I've heard a similar issue in the evidence from Ms. Greengrass. So obviously, if you look at the video, you'll see that issue has been raised about being able to turn west and use the turning head or informal turning head on Adderley Place for vehicles to turn around and go down Simondley Lane. So I have heard that. Okay. I've heard that point. Are you happy to take questions from?
Yes. Certainly.
Mr. Barrett.
I've no questions. I'm going to rely upon Mr. Roberts' evidence and expertise.
In that case, thank you, Mr. Bennett.
Thank you.
I think we have time before a break, as long as the advocates are happy to take a supplementary statement from Mr. Miskell. And I think that may be the last that we've got. Or would you like to take a break?
No, let's crack on, I think. Probably.
Yes, Mr. Miskell, I believe that is the last, unless anyone corrects me. So, Mr. Miskell, if you want to make your supplementary statement now, please. Thank you, Mr. Miskell. Whenever you're ready.
Yeah, Mr. Philip Miskell, representing petitioners who objected against this proposal, currently standing at 1,000. Mr. Walgers, you asked about the period of closures to the A57, as the point was made that the reduced traffic flow as a result of the closures, it would follow that there would be a reduction in adverse air quality readings over that period, and it was established that such gaps in the data had not been factored into the AQMA model. So basically, I've got a list of the dates of when it was closed. It's quite.
Bear with me one sec. Caught up. You can just go slowly and give me all the dates, please.
Well, I can pass this to you.
No. Don't pass me any evidence at this particular point. If you want to read it out, obviously there's a cut off for written evidence of 12 p.m. today.
Right, eastbound carriageway, February 2022, closed 1 month due to landslip.
Thank you.
Closed 1 month, August to September 2022, for major repairs.
Yep.
May 23, further landslip, road closed, and again in August for 1 month.
Yep.
Proposed closure October 2024 for 1 month for major maintenance.
Yes.
Throughout this period, and it's still in force, the A57 has been subject to the barring to the transit of heavy goods vehicles and subject to a 20-mile-an-hour speed restriction. You may have seen highway signs informing drivers and notify them of alternative routes to travel east. They're actually intermittent along the A57.
I've seen them.
Yeah. Right. In addition to this, we spoke about the problems on the westbound traffic over a certain period. So westbound, April 2022, the A57 was subject to a 5-month blockade to permit a major gas pipeline upgrade.
Sorry, what dates were those?
April 2022, and that was continuous for 5 months.
And purpose, sorry. I'm just trying to...
To allow the upgrade of a major gas pipeline. That was on Mottram Moor, A57.
Yes.
Again, this was admitted by the appellant's expert that blockages east or west were not factored into the traffic AQMA model as an indicator for reduced levels of nitrogen dioxide. To date, the restriction east has drastically reduced traffic counts, which can only realistically be recorded once the A57 is fully open. And just to give you an indication of the volumes we're talking about going east, in Derbyshire County Highways own database, it states there are 30,000 journeys a week over the A57 towards Sheffield.
You're not waiting for me, Mr. Miskell, are you?
I am actually, yes.
Oh, no, that's okay.
I'm usually interrupting there. I'm trying to be...
I'm ready. No,
I mean, it's the last day of this appeal, and I'm finally getting it right. So, right, the council fully intends... This is a mix of questions which I've had to cobble together, which have been put to me from people who have signed the petition and put their views forward. The council fully intends to develop the council land on the back of this application, if approved, and intends to add another 30 to 40 houses, proposing to use the A57 access. So the reality is, we are talking about 130 plus houses, which has always been the case. It's not hard to reason that the results of all the current highway service traffic plans, 106, CILs, the effects on the AQMA, or any other data submitted, despite being argued they are as robust as they are based on 100 houses, are now, to my mind, degraded by this proposal. In effect, we're talking about whatever figures were submitted, 30 to 40% over and above once these houses are put forward, or if they do come to fruition. Indeed, the council have had a long-standing relationship with the appellant, which goes back to 2020. And it's disconcerting to read officer comments that contain the access is achievable through the development and is crucial to maintain it. Or the case officer noting trees in the middle of 2 spur roads, which could inhibit council access to the site, has always been about the delivery of 130 houses. In line with the local policy, the site has always been about in line with the local policy. The site, hold on, lost my thread. The site has always been about the delivery. Yeah, right. Nerves.
It's fine.
As I say.
It's fine. Just take your time.
I look big and gruff, but I'm not. I'm a cute teddy.
Just take your time. If you've lost your thread, take your time to find where it is.
Just go back a step.
Yeah, have a moment.
Really dry mouth. Typical male. Who's to get the wife to open this for me?
Whenever you're ready to resume, Mr. Miskell.
Right, no worries. Indeed, the council have had a long-standing relationship with the appellant, which goes back to 2020. And it's disconcerting to read officer comments that contain the access is achievable. The access must be achievable through the development and is crucial.
or the case officer noting trees in the middle of a two-spur road which could inhibit council access. The site has always been about the delivery of 130 plus houses. In line with local policy, the site that isn't all about inclusivity, those of impaired mobility, disadvantaged by the gradients to the site, or facilitating the ageing population, and to the detriment of young families hoping to get on the housing ladder. 130 houses, but shamefully, no affordable housing. The residents of the Wayne Homes development, if approved, may bar access from the council site if their roads are private. Indeed, the issue of the non-compliant gradients of the access road, if not adopted by DCC Highways, which looks to be the case, as they will not allocate public funds to a road which, if residents decide to bar use to non-residents. Therefore, this has a major adverse effect on sustainable travel, but I believe that document is now discontinued. But it also shoots in the foot the idea that it would be a benefit to the residents of Adderley Place. They could directly access the A57 from their own premises, or in the case of Ms. Greengrass, that safe walking route, lit walking route from the A57 up to her own house could potentially be taken away if it was barred to the general public. Also, as well, in the case of, I think it was Miss Kane, no money towards a cycle path, you know, a body she represents. I may add that the people of Glossop find it shameful that our council officers pulled their objection, inclusive of expert witness, to this appeal at the 11th hour, and left the community who oppose this appeal in significant numbers to flounder. Had we been forewarned, there are those amongst the community who would have gladly helped in providing funds to engage our own independent expertise against what appears to be a one-sided exercise. So much for the council's community involvement. As I have stated earlier, the people of Glossop turned out in significant numbers during the consultation process prior to the adoption of the local plan to object and show their anger to the inclusion of Adderley Place. 10 years later, that sense of anger has not abated, but recent developments have done nothing but to compound that anger. No, 440 plus objections, a petition that attracted 500 signatures in the first week and now stands in excess of 1,000 and growing, as surprisingly, word is just getting around about the appeal. And I'll finish on that point.
Thank you, Mr. Miskell. Are you happy to take questions or leaving it as a statement?
No, I'm more than happy to take questions.
I've got no points of clarification, Mr. Miskell.
I forgot my closing bit.
Go ahead.
Just typical male. Wife gives me a shopping list and I still forget items on that. I was talking to, in correspondence with Mr. Kerr Brown, and he suggested bringing hard copies of the signatures of people who've signed the, and also they've got comments on it as well.
Have you got a copy available for the appellant and the
No, but
council?
I don't know if you've got access to a printing machine. I'm more than happy to have these printed, or ideally I could email the figures to you. I've got them electronically as well.
If the council's happy to take a copy and does have facilities to make a photocopy, so that both the appellant and myself can have a copy of that, we can then reflect on that in terms of whether it's accepted as an inquiry document at that point in time, Mr. Miskell. So if you can just liaise at the break with the council.
Yeah, I did check during the appeal process prior to the termination date to get your objections in with the inspectorate, and they said petitions were acceptable. Yes,
I understand, and Mr. Kerr Brown has contacted me regarding your inquiry on this particular matter.
Yeah, it was just a double check.
It's just ensuring that the parties have a copy of it before to review it. That's all. So if you can liaise with the council, if they've got the facility to photocopy,
no problem.
It can be circulated during the break to the parties, and then it can be put before me before we start to call witnesses, and we can take it as an additional document should that be necessary.
Yeah.
I hope that is satisfactory for your query on that particular point.
As Mr. Barrett quite rightly said, and just going back to this point, the brunt of the objections were pulled on the 24th. But people looked at the statement Mr. O'Brien had made, and we thought it carried a lot of weight. We thought it was credible. And we could not believe that 4 days before the inquiry, for whatever reasons, this report was pulled. So, with the Chair's permission, I'd just like to read the closing comments.
You need not do that. But I still have it in evidence before me, the closing comments that are proof, so you can just direct me to it. That's absolutely fine.
Can I just ask the question, why, to the council, is that correct? Can I do that?
You can.
Or should I call them to the Chair?
You can't call them for evidence. You can make a comment, and if it need be addressed in evidence, it can be done so.
Just basically, we've not seen the arguments on a document which seems to carry such amount of weight, which everyone who's read it seems to agree all the points are pertinent. They back up the feelings of what the general public feel, the people who pay their taxes, the people who pay monies towards the council, and hopefully get some response or some form of representation. So, as I say, 4 days before this inquiry, inclusive of two days a weekend, we're expected to find, and it's the reason why we didn't ask for or didn't seek legal advice, legal support.
Yes, Mr. Biscoe, I've heard that as part of the procedural matters. I've heard the strength of feeling on that particular point.
And I'll take that point on board because it did say, tell me. Well, it just beggars belief. I won't say any more of it.
Yes, no, I've heard that point on that procedural point, and I've been quite clear that I'm not going to make a decision on it today. I am going to reflect on it and take it away. The inquiry proceeds because we're here and it proceeds to do so. But there's no decision made on that point. I'm reflecting on what I've heard from all parties. So,
one last question. As I've alluded to, the council have had, a long-standing relationship. I'm not saying it's not been above board with the appellant. And that, going back to 216, you can go back to 216. The purpose of this site has always been 130. So you've got a developer here who's come along. We've got issues with viability. So I would assume, correct me if I'm wrong, the more houses you can build on a site, the more viable it becomes. And yet, there's been no, has there been cooperation? Has there been conversations with Wayne Homes to bring the council site forward? And if there wasn't, why not? It's a perfect opportunity. It's stated in your own councillor's office comments. It's crucial that the access is maintained to the council land so they can access the 57. So that's always been in the back of the mind. So we've got an issue, and it beggars belief that we had an opportunity to deliver 130 plus houses, and we're at a stage where we get 106 agreement for an off-site rented property. And John made the point, it's shameful. It's disgusting.
Thank you, Mr.
That is the view of the people of Glossop.
Thank you, Mr. Miskell. I think I've heard the points that you've raised already on that particular matter. Obviously, the council, the appellant does have witnesses to call to come that will address potentially some of the matters that you raised if they've not already been addressed already. But if you're happy to take questions, now's the time for Mr. Barrett if he's got any further questions.
I'm sorry if I feel a bit irritated, but it does make
I understand the
really
strength. I understand the strength of feeling, but I do have to avoid points being overly repeated. Thank you, Mr. Barrett.
Mr. Miskell, 3 points. I think the first point is I must have got this figure wrong, but I think you said from county highways the figure per week on the A57 is some 30,000 vehicles.
Yeah, that's on their site.
Well, that can't be right, can it? 30,000 vehicles is
when
that
it's fully open, yeah.
Per week.
Per week. So I mean, if you take into that, you can break it down over 7 days. So 30,000 divided by 7, 2 trips there and back divided by 2.
Let's do the maths. I thought I'll use a 5-day working week, so I'll divide 30,000 by 5. I get 6,000. I'll divide that working, that's 6,000 per day, divide that by an 8-hour working day, that's 750 per hour, divide that by 60 minutes, you get 15 vehicles per minute.
It's on Derbyshire CEC's highways. They give you a brief history and background as regards the A57 when travelling from Glossop east towards Sheffield.
Do you agree?
They also give you a history.
Mr. Niscott, just
I'm just asking you the maths.
question, so he's just.
I
he's
asked
just
you
clarifying
whether
the maths.
30,000 vehicles per week was right, because it struck me as being nowhere near enough.
Well,
And so I did the maths, divide that by 5 days of the working week, so I'm ignoring all the traffic on Saturday and Sundays. So I've got 6,000 per day for the 5-day working week. I use an 8-hour day rather than a 24-hour day just to cover the working day, and that's 750 per hour. And divide that by 60 to get how many vehicles per minute. It's 15. The maths is right, isn't it?
the maths is right, but if you protract that, you know, the A57 is open 24/7. So we're not talking about an 8-hour period when vehicles are passing through it. A lot of companies now class weekend working as part of the working week. So if you factor that in as well, it reduces that 15 times a minute of vehicles passing.
You're absolutely right. So the figures that I put to you are actually much more conservative, because I've ignored 2 days of the weekend, and I've only used 1/3 of the number of hours that would be available to use the A57.
It's a moot point. I've got that information from Derbyshire County Council. So if you need to query that information, I'm not the person. This is what they're putting out on a public website. So if you feel that there's a problem with the data which is being put out there, take it up with Derbyshire County Council. But the point I'm making is, obviously, there's been a drastic reduction on the A57 due to the landslips, the ongoing restriction to HD vehicles, the 20-mile-an-hour speed restriction, and the fact that the council put out signs to divert everyone away from the A57 onto alternative routes when going towards Sheffield. And the reason that point was made was it undoubtedly has had an effect on the AQMA levels outside Dinting School, a fact which was bore out by your expert, who admitted that the blockages had not been factored in to the model. So,
Thank you, Mr. Miskell.
I
I
would
think
like
Mr.
to
Barrett
know-
just has another question on that point. I think I'd got the point that you made there, and I understand what you're saying. It correlates with the response that you gave in your evidence last
yeah,
week.
but I don't
as
know
well.
why I'm being questioned on a figure which has been put out by the experts, Derbyshire County Council, as regards traffic movement between A and B over a weekly period.
Thank you. I think Mr. Barrett might illuminate me on why you're being asked that question with his subsequent questions.
Well, the next point is that you gave the inspector specific dates as to when the A57 was closed. What's the source of that information?
Derbyshire County Council highways, also, which you can check. There's a blockade planned again for 2024 of this year. BBC news reports, local news reports, which detail when the closures happened. Obviously, it's news, and it has been news. It's been a major bugbear with local residents, these ongoing restrictions.
Thank you. So
some more documents. We now have, or I have, printed copies of Ross Darroch's document, which doesn't yet have an ID number.
Okay, we'll start with that one first. Ross Darroch gave evidence last week, so I'm assuming
it was read by his wife.
Yes, written statement last week. Happy to accept it as ID 17.
Yep. Then we have Mr. Bennett's supplementary that he read this morning. So that'll be 18.
As long as it's accepted, yes,
Yeah.
Mr. Barrett.
And then we've had the email that was described as being from Emma G, but we didn't know what the G stood for. Do you remember that, sir?
Yes, that one.
Yeah.
Yes.
So we've got that. And that would be 19 would be the next number.
Happy to accept it. Have you seen it?
So I've also got copies of the documents that we have previously given numbers to and which are now on the website,
Okay.
which are 10, 11, 12 and 13.
Okay.
If you're monitoring the website, you will have seen that all up to 16 are already up, apart from 14, which is the Mrs. Wilson Compendium,
Yes, I understand.
which is still being assembled.
Yes, I believe that'll take time, but I think it's the appropriate way to do it because it's across multiple documents. I'd like to accept it as one compendium. And the one thing that I would ask on that is, I don't know whether the parties have received an email very recently, an additional one from Mrs. Wilson with respect to questions specifically for Mr. Heathcote.
Yes, I have seen that.
Have you? Yeah.
And is that included in ID 14? Mr. Barrett, have you seen that?
I have seen it, and so has Mr. Heathcote. So we can deal with it in evidence, but I haven't got the inquiry numbered ID document.
But it will be part. It will be part of ID 14.
Yes, I think all the correspondence received up to 12 p.m. today, which was the cut-off deadline for some written submissions, will be compiled to that particular person's.
Okay.
Because we only accepted it this morning, so ID 14.
We have also received an email from Julie Greengrass, but is not yet printed.
Okay, have the appellants received that yet? No.
No.
Mr. Mellon may have, I haven't.
No.
Well,
you've only just received it.
Okay.
Should if you can share that with the appellant, and we'll deal with it immediately after lunch.
Yes.
In housekeeping then.
But so far as we are concerned, sir, we have now reached the cut-off point.
Yeah.
Yes, that's the cut-off point. I've been quite clear in correspondence prior to today and during the inquiry that 12 p.m. was the cut-off date, because in the interest of fairness for the parties to be able to respond to it during this inquiry time, and also the ability for me to read the evidence and make sure that I'm aware of it before it's dealt with in evidence. That was the necessity for the cut-off today. I think, in my view, the opportunity has been given on 4 days now for statements to be given, and we've taken statements in writing. So I believe that that's the appropriate approach that we take during the inquiries, unless the council assists me.
The only other matter outstanding was a missing email from Mr. Miskell, which you'll recall he said he'd sent, that nobody had referred to yet. Rather than trawl through the council's system to try and find it last week, he sent it to us again.
Okay.
My solicitor's satisfied that it was a forwarding of the one he sent last week rather than a newly generated one. Okay. So we're proposing to ask you to accept that.
Okay.
But that is it.
Yes. Well, apart from Ms. Greengrass's one that we'll deal with after lunch.
Yeah. Now.
So that I'm just for confirmation, I'm accepting that as ID 20.
Right.
Mr. Miskell.
Oh, right. So,
email.
So Ms. Greengrass, that's an inquiry document?
That'll be reserved for 20. 21 will be reserved for Ms. Greengrass.
Thank you, sir.
So Mr. Miskell, ID 20. Yeah. Now, that's a very good thing that you've imposed a cut-off, because the hotel has imposed a cut-off at 1 o'clock for us printing.
Yes, so that's rather helpful.
Yeah. Thank you, sir.
Thank you. There's nothing else that I'm awaited. Very quickly, Mr. Miskell.
It's a quick point. I just missed that because we're trying to send emails. Just for clarification, you have received a copy of my statement from last week, so you're just waiting for today's statement.
No, we've received the copy of last week.
Right, but you're just waiting for a copy of today's statement.
The cut-off was 12 for any written evidence. I did make it clear at the start of the day that 12 p.m. was the cut-off.
Yeah, but for some reason I cannot access their system. It's took me the best time. Half an hour, and I'm still getting nowhere with it. Every time I put in Nicola's email address, it's just not going.
Right.
I've only received, sorry sir, I've only received one statement from Mr. Miskell,
Yes.
which I believe is the one from today.
Well, I'll leave you to
Leave it with
leave you
us.
to liaise over the lunch break with Mr. Miskell, and then if we return immediately after lunch to deal with the situation at that point. I can't take it much further, Mr. Miskell, at this point, but
Just point out this, Mr. Garrett's sent his half an hour ago, and there's no confirmation that it's actually been received.
we've got Mr.
We've got
Darrett.
Mr. Darrett, we've mentioned it.
I mean, further than that, Mr. Wells, I can give you a copy of today's statement. We stated we've got last week's, and that not being photocopied or...
Yes, we'll deal with it at lunch though, and I do want to move on. Thank you. No, that's fine. In that case, Mr. Barrett, are you happy to call your next witness? I know we're slightly delayed, but I think it was necessary this morning.
Oh, no, I agree. I agree. My next witness is Richard Heathcote. He has produced a written proof of evidence, main proof of evidence, a rebuttal proof of evidence. The following documents you might need at your elbow. I'm not proposing to refer extensively to these documents, but the CD 219 is the viability assessment. It's an addendum because the original viability assessment related to 100 houses. The addendum, which is the relevant one, applies to 92.
Thank you.
CD 6.2 are the sales particulars, the CBRE sales particulars for the council-owned site, which is the subject matter of some discussion in the viability appraisal. CD 6.24 is a letter from the council's own viability consultants. CD 612...
Sorry, Mr. Barrett, can you just give me the reference to CBRE again? I don't know
CD 6.2, sir.
6.2. Thank you.
CD 6.24 is the Bruton Knowles. Well, it is one particular letter from Bruton Knowles, which is essentially the conclusion of their viability assessment. CD 612 is the 2014 local plan viability appraisal.
Sorry, can you just repeat that one again?
6.12, sir.
6.12
is the 2014 High Peak local plan viability. Had an acronym, but it's basically the viability assessment of the local plan proposals.
Yes, Kepi Massey, White Young Green and Arab.
That's the one, sir.
Yes.
Yes. Right. Mr. Heathcote, let me introduce you to the inquiry. Actually, I just noticed that you list the core documents that your evidence refers to at the start of your evidence. But turning to PDF page 3 of your main proof, you hold a degree in urban land economics, and you've got more than 20 years' experience in preparing viability appraisals and reports for planning purposes, acting for national house builders, private developers, district councils, and housing associations. Is that correct?
That's correct.
So both sides of the fence.
Yes.
You've got more than 30 years' experience in the commercial and residential property market, specialising in viability, development, site acquisition and agency, and you've been directly responsible for viability assessments in a significant number of schemes, including those on part of allocated sites. And you tell us that you're instructed to act on behalf of the appellant in respect of viability matters, and particularly the ability of the scheme to produce affordable housing provision and other financial contributions and obligations. Is that correct?
That's correct, sir, yeah.
And as you tell us at 1.4, your evidence is true. It's provided in full compliance with the Royal Institution of Chartered Surveyors practice statements that you list in paragraph 1.4, your evidence. Is that correct?
That's correct.
And you tell us at 1.5, the assessment that you've produced is considered to be in full conformity with planning policy guidance on viability and all other prevailing guidance, policy and best practice arising from planning decisions, including those determined on appeal. And you tell us that the opinions expressed in your evidence, based on your experience, are true and they are your genuinely held professional opinion.
Correct.
Now, looking to your main proof of evidence first of all, you set out at 2.1 the original reason for refusal, and embedded within that is a failure to provide for affordable housing, notwithstanding the viability appraisal. Is that correct?
That's correct.
You then, at the end of 2.1, refer to the council's statement of case, in which consideration of the council was put on the basis that the viability of the whole of the allocation, DS4, should have been assessed rather than that part belonging to the applicant. Correct?
Correct.
You tell us that that's effectively a new reason for refusal. And then 2.3, you set out the history of this matter. Can I ask you to go to CD 6.24? This is the letter dated 12th September 2023 from Bruton Knowles.
Yep. Got that.
There is an element of disagreement that we can see from the correspondence. They considered that there was some 773,000 surplus that could be available for SIL-compliant contributions or affordable housing, correct?
Correct.
Not something you agreed with, but the point that I'm asking you almost is what isn't contained in that. Did Bruton Knowles criticise the approach of the appellant in proposing a viability appraisal that's solely related to its own site?
No, they did not.
Have you ever seen a criticism based upon a bespoke planning application criticised for not providing, in the context of that site being within a wider allocation, a viability appraisal for the whole of the site?
Sorry, Ms. Barker. Can I just stop you on the question there, and I'll ask you to repeat it. Someone's got a phone with a notification going off. Can you just make sure if you can turn it off, turn it to silent? I couldn't hear the question because it was distracting. And I understand it's distracting to you as well. So if we can go backwards.
I was asking you, and you answered my question. No criticism from Bruton Knowles. I just wondered to what extent, if at all, other viability consultants have said, notwithstanding your red edge is part of an allocation, what you need to do is a viability assessment across the whole of the allocation.
I've not had that in my experience, no, sir.
We can put that to one side now. That's going back to your evidence, if you would.
Yep.
Now, you tell us then in section 3 that you prepared the viability assessment and the update of it, CD 2.19, referenced in paragraph 3.3 of your evidence.
Yes.
You tell us that Mr. Emerson of Bruton Knowles was appointed by the council. He completed a detailed review. We've looked at that letter 6.25. Was he assisted at 3.4 by quantity surveyors, Townsend and
Correct.
Renadon?
Yes, he was.
And they would have provided a contribution to the assessment relating to build costs, I am assuming?
Correct, yes.
Yeah. And we've just 3.5, 3.6, the conclusions that we've reached, the 773,000 that they refer to was not the subject matter of agreement. but in the hope that this would resolve the matter, your client was willing to go forward on that basis.
Correct. Yes.
Right. 310, you refer to the council statement of case towards the end of April 2024, introducing this notion that the 4.14 acres of council-owned land should have been included within the assessment.
Yes, that's correct.
In 3.11 onwards, you explain why that wouldn't be appropriate. Can we just deal with some of the headlines? Insofar as it's council-owned land, your clients and yourself, in advising your clients, don't have access to the council land.
Correct, and we have no access.
Can you obtain detailed information from it in terms of what house types are being proposed, or even the number of houses?
No, we had no details of that nature, no.
In the absence of knowing what number of houses, the quality, the build quality, and therefore build costs, can you go about doing a PPG compliant assessment?
No, you can't do a full PPG compliant assessment without that additional information and data and reports.
At 3.13, you reference the viability test report, which is essentially the local plan's viability assessment. And you tell us you're offering no criticism of that approach. Can you just draw a distinction, if you would, between a bespoke planning application viability assessment and the viability test report used and deployed in local plan?
Yeah, a local plan viability assessment is, by its nature, based on some high-level assumptions, both in terms of form, density, and types of dwellings that are appraised, and also, obviously, there's a lot less technical information relating to sites at that stage. It could be anything from a site that's just been put forward by a landowner with a red edge round that they consider, or it could be literally just a generic assessment of typologies, which doesn't even relate to a specific site at all. So there's a distinct lack of detail in a local plan assessment, whereas in a site-specific assessment, clearly we have a detailed proposal here. It's a full application with full set of house types and a full suite of technical information that was utilised to provide the assessment.
So let's join those threads together. The 2014 document was fit for purpose, for the purpose, that purpose being to inform the local plan process.
Yes. Yes, that's a typical approach. That's a typical approach for a local plan. Yes.
Whereas when you come to a planning application where you know the number of houses, you know the build type and build costs, would it be fit for purpose? Could you use the 2014 document to inform that application?
No, you wouldn't be able to inform it for a detailed application.
Then specifically at 315 and 16, the document obviously is a product of its time, could not have foreseen Brexit, COVID, war in Ukraine, all of which you tell us affected labour availability and rates, material prices and interest rates.
Correct, yes.
So even the assumptions that it could use would have to be revisited. Is that what you're telling us?
Yes, if you were doing a local plan review now, you would look at some of those inputs in a different light, clearly.
Yeah. And you also say at 316 there's a further consideration, certainly since the introduction of the Environment Act 2021, BNG now has to be taken into account, which is often going to involve a cost to development.
Yes, that's correct. Yeah.
Okay. Now, you list in 319 the sort of level of information and technical data that you would need to be able to inform that. You see that?
Yes.
Can I ask you to go to the CBRE sales particulars? That's CD 6.2.
Yeah. Yes, I have those.
And I think if we orientate ourselves, it's quite clear from the aerial photograph on the front sheet that this 1.6, 1.7 hectare site is edged in yellow, and we can see the appellant site also.
Yes.
Right. there seems to be considerable amount of tree cover on the council-owned site. Is that your understanding of the position?
Yes, I revisited site a couple of weeks ago, and it is still highly densely covered with trees, yes.
And if we go on a couple of matters, if you go, there's a section that has a heading planning on the PDF page, so it's page 5 of 6.
Thank you.
Yes, I've got that, yes.
Right-hand side, the opportunity has the capacity for the delivery of 45 to 50 residential dwellings and falls within an area which is allocated for residential development. We see the remaining land within the site is in third-party ownership, not included within the sale. That's client site.
Correct.
The site is capable of small-scale development with access from Kestrel View, however, is considered most suitable to help deliver biodiversity net gain through enhancement of habitats. In terms of that, the guidance you can access immediately by a link there, the reference to small-scale development. Is that how you would see the site being developed if and when it comes forward?
Yeah, it's a highly constrained site. It extends to just over 4 acres. So the initial implication in there that it could be for 45 to 50, I think is highly subjective and probably unrealistic. That would be required to, I would imagine, to remove the vast majority, if not all, trees on that site to achieve that kind of numbers. It's also constrained by access, topography. There are services running, I think there's a culvert running through the site. So the actual developable area of that site I would just expect to be significantly limited, and therefore I would agree with CBRE's comment that its scale of development would be small scale at best.
Do we know something of the previous history of that site? Do we know whether it was ever used for...
I believe it's previously been used, at least in part, for landfill as well.
Yeah.
So.
Would that require you as a viability consultant to apply your mind to the question of whether there's a contamination costs or a contamination risk to be addressed?
Yeah, there's likely to be contamination in terms of material on site. Depending on what material's been used, there may be issues in terms of requirements for gas monitoring, and obviously it would also potentially impact on foundation solutions if, depending on the type of fill, you may be into an expensive foundation solution such as piling.
And without that information, and you see, I'm going back to your proof of evidence at 319 now.
Okay.
Without that information, could you really do a planning policy guidance compliant assessment that would have credibility and weight without knowing what is actually under the site?
No, you wouldn't be able to. If you had an application, detailed application for that site, you would need that information to do the assessment, and we haven't got it.
Nevertheless, you in your evidence, in an attempt to respond to the council's statement of case, undertook an assessment. Is that right?
Correct.
And that assessment then is set out in your section 4.
Yes, that's correct.
And at 4.2. You tell us what you were doing, basically. You were looking at the allocation as a whole with such information as you could put together, credibly put together, going forward with a viability assessment.
That's correct.
And we can see that some of the assumptions that you made, 4.3, a series of reasonable but broad assumptions, basically you using the Wayne Homes development as a precedent in terms of the quality of the site, the build costs likely to be associated with it, and other assumptions. Is that right?
Yes. Obviously, it's immediately adjacent, and therefore it would be reasonable to assume that the form of development would be similar, the materials would be similar, and therefore the base cost would be of a similar level. And then again, obviously, in terms of abnormal costs, we assume that you would hit a similar range of abnormal costs for the site as on the Wayne Home site.
And 4.5 then, there are some specific matters. You've had to take into account biodiversity net gain now, because any application on this site would actually engage with the statutory requirement to achieve it.
That's correct, yes.
a minimum of 10%, and you say this is a site that's likely to attract quite a high score as it currently stands.
Yes, that's true.
That's not been taken into account. Third bullet point, then you look at build costs. You use BCIS, General Build Cost Index, that's been updated to the present time. Is that correct?
Correct, yes.
You've also then over the page looked at financing costs because of the war in Ukraine and, well, let's not be controversial, because of certain decisions made in government, interest rates have changed.
Correct, yes.
You attempt to address on-site infrastructure, highway costs because of the topography of the site, quite frankly.
Yes.
And you've just had to make assumptions about archaeology or contamination.
Yes, the assumption is the site would perform no worse than next door.
Yeah. So you've just taken across the assumptions that you've made about the subject site.
Correct.
The subject site has never been the subject matter of landfill.
No.
Okay, you do that, you look at 38 dwellings so that one gets the local plan figure of 130 dwellings of the combined site, is that correct?
Correct, yes.
You make exactly the same assumptions, 0 affordable housing, 0 106 contributions. You look in at the sales revenue for the 38 additional dwellings, and that adds to the sales revenue of about £11,150,000 in round figures.
That's correct, yeah.
But then to that then is all the costs to be added that you've set out 420 and following. Future home standard will have to be achieved.
Yes.
You based yours on the 20% profit on GDV, same as your initial report.
Correct.
Increase in residual land value, you kept the same benchmark per acre, is that correct?
Correct.
The additional council land extends to 4.14 acres and could therefore attract an additional benchmark land value of, well, £560,000 in round figures.
Yes.
And that increases the benchmark land value across both sites to £2,155,000.
Yes.
And then you set out a table in your section 5 that actually worsens the viability if you add in the council's own land.
Correct, yes.
So again, drawing those threads together, and with all the qualifications that you make, in terms of the best evidence that's available to the inspector, what can he conclude about the ability of looking at the whole of the allocation and an ability to make contributions to affordable housing or Section 106 SIL compliant obligations?
The assessment we've made is conservative, and even on that basis, the overall allocation does not improve the viability and the ability for that site to deliver any of the Section 106 or the affordable housing obligations.
And then you set out other informed correspondence, including the RICS Residential Market Survey, your 5.6, April 2024, as recently as that. They talk about the recent recovery in buyer demand stuttering slightly.
Yes, I think that's a fair summation, and I think remains the case as of today that the market is uncertain at the moment.
And those figures are then developed. 513, taking everything into consideration, the lack of house price growth combined with a continued growth in construction costs and higher finance costs will only serve to make the achievement of viability in this case significantly more challenging for both the appellant site and also the council's land that makes up the wider allocation.
Sorry, Mr. Barrett. Can I just?
I'm sorry, sir. That was 513.
There's 3 513s.
Oh, I hadn't noticed. Yes, you're absolutely. It's the last of the 513.
The last 513, right? The last.
Actually, there's 3 513.
Yes, there's 3. There's 3. There's one on page 15 of the PDF and 2 on page 16. It's just numbering.
Yeah, for your notes, sir, it is PDF page 1618, the final paragraph of the evidence, whatever number that is.
Apologies.
Okay, sorry I was interrupting. I'll hear the answer again. So.
Right, let's go back to 513. You drawing the threads together here, taking everything into consideration, you've got a lack of house price growth over the period, combined with continued growth in costs and higher finance costs, will only serve to make the achievement of viability, in this case, more challenging for both the appellant site and the council site that make up the wider allocation, DS4.
Correct.
Yeah. And so doing the best you can and assisting the inspectors is your duty. Would there be any criticism of my clients for not proposing affordable housing in terms of the viability position that obtains in respect of the development of their own site, and or with the council site brigaded with it and brought forward together?
No, they would not, sir. No.
You deal with a very brief rebuttal, so I'm content that that be read in view of the circumstances that have obtained. And so I will just point out, if I may say so, the position of Mr. O'Brien is one entirely consistent, Mr. Heathcote, with his professional duty to this inquiry, as you understand it. Is that correct?
Correct.
Yeah, and he's made that clear in open correspondence. Is it the position that before the council declared that position, they had sought the advice again of their viability consultants and informed, no, we haven't seen it, but no doubt informed Mr. O'Brien what their position was with regard to your evidence in terms of viability of both the appeal site and brigading with it the council-owned site?
The Bruton Knowles position on our own, on the appellant's application was agreed, and my understanding is that they've looked at the overall allocation and again concur with the findings that I reached in my proof of evidence.
I just want to make sure I've covered everything that I needed to.
So just for your note, on that last point, it's paragraph 7 of the council's opening statement that makes that clear.
Yes. I agree with that, but
there was reference to correspondence that hadn't been seen, but the information before the inquiry is quite clear. Paragraph 7 of our opening.
I knew it was in the opening, but I hadn't seen the document. That's the only point that I'm making.
Yes, thank you.
Okay. I think that's it, Mr. Heathcote, for me. Is there anything that you would wish to add in to your evidence?
No, thank you, sir.
Thank you very much. Thank you, sir.
You're happy to take questions?
Yes, sir.
From the public and
yes,
yourself?
Sir. Yeah.
Any members of the public wish to ask a question? Mr. Miskell? If you can come to the mic so we can hear it.
You state that you've taken into account houses potentially which will be brought forward on the council land. Even with 130, this whole site as an aggregate would not be viable, would still not be viable, even with the inclusion of the 30, 40 council houses to be brought forward.
So, sorry, Mr. Miskell, can I just clarify the question, because it'll assist me as well as the witness? Are you referring to the affordable housing component?
No, I'm talking about the site as a whole. I think, if I'm right, what I heard was you did an assessment as regards viability, inclusive of council land, so we're looking at a potential of 130 to 140 houses. On that number, was the site still unviable?
Any question? Any answer?
Yeah, I would refer to my proof of evidence as where I did an assessment of 130, which is the number within the allocation, and there was a detailed methodology of how we reached that assessment there within the appendices to that report. So on that basis, the overall viability position of the whole allocation is not improved, and actually the deficit is slightly increased.
Right. In light of that, I would imagine there was a viability exercise done back in 2016 to ascertain the suitability of Adley Place going into the local plan. And I would imagine at that time, it would have been identified that it could not satisfy the policy of DS4, various other policies, but mainly the main one, the main driver of the local plan, was the delivery of 30% affordable housing. Surely at that time a similar exercise would have been done, and they would have realised we can't deliver the affordable. Is this an acceptable site? And may have been subsequently taken out of the local plan at the consultation stage.
Thank you, Mr. Miskell. I think based on the proof of evidence and the evidence in chief provided, there was coverage of what your views were in terms of the 2014 report, which is the one that informed the 2016 local plan. That, just for clarity, it was when we're referring to the 2014 report, that was the one that we're referring to. So is there anything additional in terms of beyond what I've already heard in response to Mr. Miskell? I'm not asking you to repeat your answers that you gave to Mr. Barrett on that point, because I understand the evidence that you've given.
Right, okay, yeah. All I can say is the local plan was, as just explained earlier, is a high-level assessment, and at the time that that was done, there's limited information in terms of details of scheme and abnormal costs. I believe in the Kepi report, the site was found to be marginal in viability at that time on the assumptions that were made. Clearly, we have significantly more information of the site now, and the site does carry a significant burden in terms of abnormal costs, which is why we're in the position where the viability is challenged in this site.
So from my understanding, what would those kind of additional costs that may not have been factored in be?
Yeah.
So could it be things like additional foundations?
Yeah, I think in terms of the original viability report, there were some small number of allowances made in that local plan for viability abnormal costs, which I think would have totalled somewhere in the region of about £6,000 per plot at the time. And that is contrasted by the assessment that was agreed with Bruton Knowles, where the abnormal cost there for the applicant site was £45,000 per plot. So there's a significant difference when the detailed work has been completed.
Thank you, Mr. Heathcote. Anything further, Mr. Miskell?
Just one more question. In relation to the council land, in your estimation, it's only suitable to deliver 20 to 25 houses?
Is that a question to me?
Yeah, sorry.
Yes, it is through me, but I am allowing a bit. I am allowing a bit of discretion. I am allowing a bit of discretion.
No, my assessment assumes up to the full allocation number on top of the appellant site. So the appellant site is 92, the allocation is 130. The assessment I made is for an additional 38 dwellings, and based on the average dwelling size from the appellant site for each one of those dwellings, and therefore the average value and average cost.
I don't know if the question has any bearing. So you've treated both sites exactly the same, using the same methodology to get to those figures. And you were saying you had limited information as regards the council site. Was you not aware that they did a soft marketing exercise? I think it was 2019, 2020, where they went in and checked soil condition, what was in there. I mean, you made the point that there could be onerous substances buried within the site. Environmental health came back and said there was nothing in there which the public can be concerned about. So exercises have been done within that land and probably were available to you at that time, the results of, to make you come to a more informed decision.
Just I'll add to the question on that, because to assist me. So if those reports exist and you weren't aware of them, and I'm not casting any assertions whether you were or you weren't at this particular point, would those investigations likely have such an influence that it's likely to change the significance of in terms of the conclusions that you've reached?
No, sir. I haven't been had any access to that further information if it exists. And in terms of the assumptions we've made, I have not made any further, more onerous assumptions than what apply to the client side. The client side wasn't subject to widespread disposal of material on site, and therefore we haven't loaded additional costs onto the council land. If that makes sense.
Yes, it makes sense to me, and what I'm hearing for you, and correct me if I'm wrong in that sense, is that you consider your assessment may be conservative?
Correct, yes.
Mr. Miskell?
Just one last question.
Last one, yes.
And excuse my ignorance. We're talking about costs, and if I'm correct, it would be not really cost effective or generate more monies by developing the council site. But surely Wayne Homes are taking the brunt of the cost as regards the access road, which is the main cost of the item. That's where all the monies are going. So therefore, in my mind, once that's built by Wayne Homes, surely allowing the council land to come forward, they've got reduced costs. They're just talking about breaking into 2 spur roads as opposed to submitting monies towards, breaking into the A57. So I would have thought, the council site in that respect was more viable.
Thank you. Yeah, keeping the question, but to add to it, can you just explain whether or not any costs attributed to the highways beyond the connection to existing highways were included, just for my understanding and to assist answer the question?
As I say, all we've done is apportion the abnormal costs from the Wayne Homes site. The Wayne Homes site's list of abnormals, which is in my report. I could perhaps refer you to that, sir.
Just clarify which of the report, the core document number, if that'll help me, please.
Right, okay.
Or is it the proofs?
Yeah, the core document would be in my viability assessment addendum 21st of June 23, which is core document 2.19.
2.19?
Yeah, and there's a full schedule of the abnormal costs there that were considered there, which did not include for additional costs for highways. So we've just apportioned those costs onto the council land. Therefore,
yes, so
we haven't added costs in for that road.
Yes, so you've separated the highway costs out and you've not added a cost in.
Correct.
Thank you. Thank you, Mr. Miskell.
Thank you.
Any further questions? I do have some written questions that were received as part of ID 14. I'm just going to have a quick look through those. And I know it's still being compiled, but I do have a copy of that particular email. So I'll just check. And I'll do those written questions just before my own. We are closing in on one. I hope parties I assume parties are content to overrun slightly. We will take a bit more time after 2. In terms of lunch.
In between witnesses.
Yes.
Yeah.
So the first question, and I am going to paraphrase because I'm not going to read the question out completely because I know that the appellants have already received that correspondence and read it as previously confirmed. So the first question was why prepare the report if the report on the council land or as a whole, if you considered that you didn't need, if you considered that it wasn't necessary. I've heard the explanation in response to Mr. Barrett's comments, but if there's just anything in particular to add. purpose of doing that?
Yeah, well, the purpose of doing that was in the absence of any assessment by the council, and it was there really to assist and inform the inquiry.
Thank you. The second question, limited. I think we've covered that with Mr. Miskell's question in terms of third-party land and the availability reports that you might not be privy to. I believe I had an answer to that, so I'm not going to ask that question specifically because it'll be repetition.
Okay, thank you.
The third question was, in your view, given the CBRE report and its preference for where its suggestion that it may be suitable for biodiversity offsetting, and I'm paraphrasing the question rather than stating a position that's my own. Is there a reason that you're aware of why the appellant didn't pursue purchasing that site rather than the Chinley site instead? It may not be a matter particularly that you can answer, but it may be something that the appellant's planning witness can alternatively pick up.
No, sir, I wasn't party to any discussions between CBRE and Wayne Homes on the potential purchase or not of that site.
Yes, I believe we dealt with the next question. That was question 4, which relates to access and the assumptions that have been placed in. I think we've had an answer by Mr. Miskell's questions. And then the final one's just a general comment of not being able to compare the assumptions, the broad assumptions against the of adding that together. But again, I believe that you, in answering Mr. Barrett's questions, you've cross-referred me to the table, in particular in your proof of evidence. So I'll reflect on that position and all the evidence that I've heard. So I've nothing further to take from those points, unless there's anything that you believe I've missed from Mrs. Wilson's questions to Mr. Heathcote.
No, sir,
that weren't already
I had
covered.
rather hoped that I'd covered all the aspects in that email, but thank you for that. I think we've covered everything.
Yes, I've just got a few questions of my own just to finish before we break for lunch.
Yeah.
So, based on your evidence and having regard to core documents 6.24 and 6.25, it appears that the agreed position of 773 available for planning obligations, which is now not in dispute in terms between the council and the appellant in terms of the 106, but it was seemingly founded on a compromise position between taken forward by the appellant rather than obviously an agreement between respective viability consultants. That's correct?
Correct.
And just for my understanding, and obviously you may summarise it, just were there any precise methodological inputs that were the particular points of dispute? I've noticed that through the thread of correspondence between yourself and Bruton Knowles, which were the council's viability consultants, that there's some it's summarised, but obviously some of the negotiations took place it isn't abundantly clear where those particular differences are.
Yeah.
So I just wonder, in terms of if you can shed a little light on what those differences.
give you a flavour of that, sir. Yes.
Yes, please.
I think in terms of the reason we ended up at that final difference, there was a small, and it was a small difference in terms of the total gross development value of the site. I believe our last assessment was about £296 a square foot on average, and Bruton Knowles was somewhere just around £301 a square foot.
So Bruton Knowles were 301.
Yeah, we were 296
per square foot, and you were 296.
In broad terms, about £5 difference, which in valuation points is pretty close.
Yes, it just but it extrapolates. Up.
Yeah.
So the bigger the site, the more cumulative difference it
Correct.
becomes.
Yeah. So it's a small difference in terms of where we were, which we could have gone back and further refined and perhaps reached an agreed position on, but we didn't. There was again a small difference in the overall costs when you take in what we call normal costs and all the abnormal costs, and there was some movement in terms of how some of those costs were categorised between the QSs in their discussions. But the final position resulted in the Bruton Knowles report having a slightly lower total construction development cost of about £260,000. Again, in the context of the figures involved, it is a small difference. And there was also small differences in the allowances for sales and marketing, 3.25 versus 2.75%, and a small difference on finance costs, 9 versus 8.5%. But as you rightly say, sir, those accumulate, and the nature of residual valuation, that's where you end up with the difference.
Yes, understanding viability,
Yes.
and it's not, and it's fair to say it's not an absolute science in
Correct,
that.
sir,
It's value judgments that's
Correct.
given to it. Yes, it's helpful to me, but it's also helpful for the inquiry overall and the understanding that why professionals, particularly on viability, can reach different positions. But in the overall, as far as I read it, the overall packages that there are relatively small differences, even though the actual figure that actually extrapolates out is actually what could be considered significant. A small change to some of the assumptions can extrapolate into something rather big.
Right. Without boring you too much detail, we did have a very long discussion about build programmes and things like that, which again, depending on what assumptions you make on that, it seems fairly trivial but can have quite a significant difference.
Yes, and understandably, it's based on scale of site, it's based on all those particular inputs.
Yeah, and the amount of work you need to do to get to your first plot, which in
Yes.
this case is quite significant.
Yes, understandably, yes, because the infrastructure's front-loaded.
Correct.
Because you have to access to construct, basically.
Yes.
Okay, and then just a couple of points that we may not have covered, or you may have touched upon, but I've not picked it up.
Okay.
Just differences on benchmark, any differences on benchmark land value and how it's calculated?
Yeah.
Is it existing use value plus landowner premium?
Yeah. Again, and that is equally as judgmental in terms of some of the other points you were talking about, if not more so. But yes, I think there was an agreement on existing use value. The difference in terms of the absolute benchmark land value was predominantly Bruton Knowles discounting some of the land out of that calculation, which I maintain is erroneous, specifically when you look at the amount of land that's actually needed at the front of the site to access the site. And a far lower premium was placed on that by Bruton Knowles than I thought was appropriate.
And again, those differences do then extrapolate out.
Correct.
And would be the understand. The question really is how your conclusion and Bruton Knowles' conclusion can be different, and the appellant can decide to pursue it in any case. Is that the variance, although they may seem small in some of the numbers, can be enough that someone else may apply a different judgment, and it doesn't necessarily call into question the actual conclusions that you've reached. It's just a difference of opinion.
Correct.
Yeah, the other one I had was abnormal costs, but I think we've covered.
Thank you.
I think we've covered abnormal costs. So the final one, I did have a final question, but it may have already been covered by Mr. Miskell's question and the questions from Mrs. Wilson. So I'll just read it to myself, and then if there's anything that I need to ask on that. Yes, I think you've already covered that. The question was, what was the driver, in your view, overall of the concerns around the council ownership and the outcome, driving the outcomes on the council ownership? Because I do understand the questions that were raised of you by interested parties in terms of a natural logic is that the site's bigger, more houses put on it. It doesn't have the same overhead costs for infrastructure that's being borne off the appeal site. That for someone who isn't necessarily an expert, the immediate logic would be that it could be potentially have more residual land value to contribute to planning obligations. But you have given me quite a bit of evidence specific to that council land. The real question was just what's the specific driver? Is it the tree cover? Is it the land conditions, or is it a combination of everything?
I think it's a combination, sir. If the additional council land had been the stereotypical ideal site, flat, no constraints, then there is the potential for the matter to improve. But clearly, it's not that. And also, what impacts it is it's relative to the size of the applicant site is significantly smaller. So it would need a, relatively speaking, abnormal free larger site for that to suddenly make the overall result significantly more positive. Does that make sense? Because of the nature of the residual appraisal.
Yes, yes, I understand. But to put it in simple terms, building out that site's going to have all the same requirements of it.
Correct.
And it has less space and ability to accommodate those than the appeal site does. Yes. So
using the BNG as an example on this site, so clearly starting from quite a high level of credit, and to get the replacement off-site, I would imagine there is going to be higher than the applicant site, and we haven't actually factored that in at all. So there are elements of the council site which would actually be detrimental to it, relatively speaking, to the applicant site, which we haven't taken into account.
Yes, I don't necessarily want to open the box of evidence that we've already heard on ecology and biodiversity, but I can take that into account in terms of obviously what I've seen and the evidence that I've got before me in terms of the ecology of the appeal site, and what's proposed as part of the application, and we'll get into that. We'll potentially get into that as part of planning obligations in any case when we get into the round table. I anticipate that the appellant via the planning witness evidence will cover some of those judgments relative to the viability evidence and in terms of why the council land wasn't considered suitable for that offsetting approach. In later evidence, because I appreciate that you've not been privy to those discussions, so can't be drawn upon it. So that's all the questions I had. We have run over a little bit, so we will adjust lunch accordingly. Thank you very much for your evidence, Mr. Heathcote. The time's now 1:15. We'll adjourn for lunch until 2:15. Thank you. before we call witness the next witness. Just to confirm, this morning it was reported that there was a short outage on the live stream. I've been given assurances from the audiovisual team that that it was an issue out of their control. It was related to the server to do with the upload. Now the recording still took place, and that recording has been placed on the website uninterrupted. So it is available. Just to confirm, any interruption to the live stream, that part of the evidence given can be reviewed via the recording. Okay. In terms of the documents, is there anything that I should be aware of that's been received?
There's a flurry of activity to my left. Yes, we are now just collating individual sets of documents all the way up to ID 21.
Yes.
Except that we do not have paper copies of IQ 15 and IQ 16, which are the comments on the draft conditions and 106 documents.
Okay.
And we don't have 14.
At the moment, we don't have 14, which is the Mrs. Wilson email, photographs, etc. Questions?
Yes.
But we have agreed the contents of ID 14 with the other side, and that is currently being produced. So I think, touch wood, that we will be on track at the next housekeeping. I mean, I could give you a full a partial set now, but I guess you'd probably like a full set all at once.
I'll have it all at once to take away, I think.
And we'll do the same for the appellant. So that'll probably be with some concurrent activity to my left at the next housekeeping point, or if not, certainly before we leave here today.
In terms of 15 and 16, I have an electronic copy. So my intention would be to run. I've made my own comments on both documents, so I'll be running through my comments with reference to those documents. So if the parties just have a copy of them available to them on screen when we get to the round table, I'm assuming that'd be suitable, because my intention for those round table sessions, obviously, they're without prejudice to any decision I reach, and it doesn't mean that I've made up my mind. But so the intention isn't to run through every single condition or every single clause of the planning obligation. That was the intention of the work undertaken during the inquiry, to direct those discussions to things that, without prejudice to the decision, if I were to consider them, I needed answers on, or needed potential alterations to consider them. My intention is, in those sessions this afternoon, that I will just focus on those areas where I haven't had answers, or where I have remaining questions, or where there may be actions for the parties to submit revised versions to me after the inquiry is closed.
So the position is that we won't produce paper copies of 15 and 16.
Yes.
I'm also told that we cannot now produce a paper copy of IQ 14 because it's post 1 o'clock. When the printer...
Yes, as long as the contents of that are agreed between the parties, and the agreed documents are put to me.
We can do that.
Yes,
we can do that. At the
via Kerr Brown, sorry, if it's emailed to Kerr Brown.
And at the moment, we started off the day with IQ 9D being the last document on the website.
Yep.
10, 11, 12, 13... 15, 16, 17, 18, 19 and 20 are now on the website.
Yes, I can see them before me.
And 14 and 21 are being worked on by the web mistress.
Thank you. And then just to clarify, IQ 20, that now includes Mr. Miskell's both statements?
Both statements, 18th of June and the 24th of June.
Correct.
Thank you.
Oh, and one last statement. You'll recall that Mr. Pape had a statement that he was going to read which included sensitive material.
Yes.
And then he told you he was, he would adjust what he read to exclude the sensitive material.
Yes, and I did put him on the spot to do so. And
what he is now going to produce is a desensitized statement for you to have as an aid memoir, and which would become IQ 22 if you're agreeable to that.
I'm happy to reserve that. The one thing I would say is I'd want the parties to review it to make sure they consider it's an accurate representation of what was said.
It was, so we've already had that conversation to
Yes.
make sure that it's not taken as an opportunity to make further points.
Yes, that's that. Obviously, we're past the deadline now for submission of written statements and making verbal contributions because of the nature of where we've proceeded to in the inquiry at this particular point. And that's notwithstanding my reserved judgment in terms of the procedural matter that was mentioned this morning. But you know, we must try and stick to the timetable in terms of the availability that we've got. Anything further that I should know about in terms of documents? I've not received anything over lunch that I was aware of.
No, I think they've been loading onto the website, and then what we will probably do is send a job lot to Kerr Brown.
Yes, that's absolutely fine. I'm not saying that I need to receive them now. I'm just saying I've not received anything from Mr. Brown specifically that would suggest that there's anything particularly missing that I shouldn't be aware of. Mr. Miskell, you got your hand up?
Yeah, sorry, I just. Mr. Brun, have you got the copies of the electronic versions of the petition?
Yes, I sent a petition that Mr. Miskell mentioned when he...
Oh yes, we haven't talked about has it gone into the other side as well?
Yes.
Yeah.
Do you have the copies?
Yes.
Yes, the petition that was being referred to by Mr. Miskell, we have got an electronic copy of, and we've sent it to the appellants. We're just waiting to hear back from them.
Can it be added as part of ID 20? Because it seems to me that it's relevant in ID 20. It could be prefixed as ID 20A if that helps.
Yes. Yeah, that's what we're getting. Yes, we will upload it as ID 20A.
Yeah, in a similar manner that ID 9 was treated, because just so that it's all together, so I can read it in context when I return to it.
The only issue about it is, I haven't opened it yet, but I assume it contains an awful lot of personal data / information.
The name.
But anyway, we'll have a think about it, and we won't have an argument now, but we'll have a think about it and maybe come back to you after the next break.
The alternative to it, obviously, it's before the parties.
Yeah.
If the parties can agree with themselves a statement of how many verified signatures there are on there, if there is a data protection issue with it being published publicly, because I understand. Sorry, Mr. Miskell, before you ask the question, my understanding from the data protection is if the council publish it on their website, they become then the owner of that material, and that's the reason why there's a potential reluctance to publish it in that form as an inquiry document. For my purposes, I'm happy. I'm happy for signatures or personal details to be redacted, if necessary, provided the parties are in agreement that there's how many verified signatures on there.
Yeah. We don't know, whether they consented to their data being made public or whatever, but we will give it further and better thought, and including speaking to Mr. Miskell.
Yes,
outside the inquiry.
I think the discussion should be with Mr. Miskell in the break.
So we will do that
as the appropriate format, rather than too much discussion.
My name and town you live in. As regards the position itself and permissions, it does actually state on the form. Are you happy for details to be?
That's fine. Okay, we can.
Okay.
We'll discuss it.
Yes, I'll let that discussion go on, and we'll return to it. We'll return to it after the final break, and then it is being accepted, Mr. Miskell. It's just in what form it has to be accepted.
It's just that I won't be here for the discussions in the final break, so I won't be here.
Okay, well, the council's heard that, and if necessary, you'll take that point that's already been raised by Mr. Miskell in terms of the caveats that are on the petition. So I'll let the council review it, and then we'll obviously deal with it within inquiry time, so it will be available on the live streaming recording, so you will have the opportunity to see the outcome of that if you're unable to be here.
Right, no worries. Thank you.
Thank you. Anything further?
No.
In that case, I'll move to Mr. Barrett, if you can call your final witness.
It's Mr. Harrigan. for your note. We have Mr. Horrigan's main proof of evidence, a short rebuttal. There are two parts of the local plan in core document 4.4, which is policy DS4, and core document 410, which is policy H4. I also have CD 3.1, the officer's report, and CD 6.1, which is the inspector's report on the local plan. So I think we've been to that paragraph, so I'm not suggesting that we need to pull up the document, but I think in the course of our discussion we will reference it.
Thank you.
Mr. Horrigan, I'll begin in your section 1, your relevant experience and qualifications, page 3 of the PDF document. You're Mark Horrigan, you have a Bachelor of Arts with Honours degree, a Bachelor of Planning degree, and then you're a member of the Royal Town Planning Institute.
That's correct.
You're a Chartered Town Planner and have been so for 27 years. You're a Managing Director of the Chartered Town Planning practice known as Horrigan Planning, that's based in Manchester and operates throughout the United Kingdom. In 2023, the practice was a finalist in the Royal Town Planning Institute's Award for Planning Excellence in the National Small Planning Consultancy category. And on the 20th of May 2024, the practice had reached the final in the Royal Town Planning Institute's Award for Planning Excellence 2024 in the North West England Small Planning Consultancy category. All that correct?
That's all correct.
Before then, establishing your practice in 2009, you held senior positions up to director level in a number of international property consultancies, including CBRE and Colliers International. Part of your career has also been spent client side, where you worked at a senior level at David McLean Homes Group. Is that correct?
That's all correct.
Your work now involves assisting clients with major housing and employment developments across the United Kingdom. You have previously been called to give evidence, expert witness evidence in the field of town planning at numerous planning inquiries across the United Kingdom and in relation to major housing developments. In the borough of High Peak, notable planning inquiry cases have concerned land at North Road, Glossop, and Forge Works, Chinley. And for the past 18 years, you've lived within 5 kilometres of the appeal site. You are therefore familiar with the town of Glossop, the immediate surrounding the appeal site, and the appeal site itself, which you've visited on numerous occasions. And at 1.8, you provide a professional witness declaration that your evidence is given in accordance with the strictures of the Royal Town Planning Institute, and it's produced irrespective of who your client is, and that you confirm that the opinions expressed by you are your true and professional opinions. Is that correct?
That's all correct, Mr. Barrett.
We've got a lot of ground to cover, but I'm proposing to take a great deal of it read, because at this stage of the inquiry I think most people are familiar with the issues. So can I ask you to turn to page 23 of the PDF file? Actually, it's page 3 of the document, so it's 24, where you deal with the proposal itself. You give an overview in your paragraphs 4.1 and 4.2, including the description of the development. Access, as we all know, is proposed from Dinting Vale, the A57, in line with the allocation. Is that correct?
That is correct.
And this was recognised to involve a substantial engineering operation, given the existing levels. Would that be quite apparent on any site visit by, for example, the inspector seized with the responsibility of reporting on the local plan?
Yes, of course.
Yeah. There's then a description of the housing mix. We looked at this earlier today. There's a range of 1, 2, 3 and 4 bedroom properties, totalling 92, is that correct?
It is.
And at 4.9 you point out that the council is satisfied that the mix is broadly compliant with the requirements of the Housing and Economic Land Needs Assessment. that was produced in September 2022, is that correct?
Yes, that's correct. It's also covered in the Statement of Common Ground.
Yes, and there's no reason for refusal in relation to the housing mix?
None whatsoever.
The scale of the proposal is set out. We know from the history that the application as originally formulated was for 100 dwellings. That was reduced during the course of the application to 92. Was that following discussions with officers?
Yes, it followed extensive discussions with officers and an iterative process regarding evolution of the scheme.
Can I actually now to turn to PDF page 28, the development plan? You set out section 38, subsection 6 of the Planning and Compulsory Purchase Act 2004 that gives a special status, does it not, to the provisions of the development plan?
It certainly does. The decision is to be made in accordance with the development plan unless material considerations indicate otherwise.
Okay. Just broadly speaking, how long have we had a plan-led planning system in the United Kingdom?
For as long as I can remember, and certainly all the time that I've been a chartered town planner.
Right. We then took look. The statutory plan consists of the High Peak Local Plan. Is that correct?
It does.
And we'll look at the policies in a little more detail in due course. But I just want to get a feel for its consistency with the National Planning Policy Framework and the weight that ought to be given to it as a statutory development plan. Is the High Peak Local Plan, in your view, up to date?
It is, yes, save for 3 policies, I think it is, but those policies aren't in dispute in this appeal.
And in particular, has the plan been revisited following its adoption in 2016?
Yes,
to determine whether it continues to accord with the framework?
Yes, it was. For your notes, sir, paragraph 5.6, my proof of evidence, sets out the review that was undertaken by the council in June of 22. And at that time, it identifies the policies that were shown to be out of date, those being S3, S4 and H4 in part, H4 being out of date because it contains the provision for 10%, sites of 10 dwellings or less to require affordable housing. That's not in accordance with the framework. And importantly, policy DS4, which is the site allocation policy relating to the appeal site, was not deemed to be out of date, and neither were any of the other policies that I mention in chapter 5 of my proof of evidence.
You revisit that on page 35 of the PDF page, at paragraph 7.6 under the heading weight to be given to the development plan policies. Do you not?
I do, yep.
So although the council's review looked at policy S3 and H4, they were content that the remaining part of the plan was up to date.
They were.
A view that you disagree with?
No.
No. You then draw attention to the case of Wavendon and the basket of policies and the assessment that you have to do in terms of compliance with the framework.
Yep.
That exercise having been done, are the policies as a whole up to date and attract full statutory weight in the determination of the appeal?
In my assessment, they do, yes.
Right. At 7.10 on page 36, you touch upon viability, drawing attention to the evidence that's been provided. The council's case in respect of the site itself through Bruton Knowles was some 700 and odd £1,000 was available, and whilst that was the subject matter of dispute, the appellant was quite content to go on with that basis in the hope that a planning permission would be forthcoming.
Yeah, the position is that the appellant reluctantly accepted that position in order to move the application along positively, so that in the hope that it could be determined positively at a local level. And of course, we got a recommendation for approval, but unfortunately, members decided to refuse the scheme.
And we go now to page 37, 7.15 under the heading of paragraph 11 of the framework. You tell us there that the appellant's principal case set out in the statement of case is that the proposed development complies with the provisions of the development plan, and as a consequence, paragraph 11C of the framework applies. Can you briefly just tell us what 11C of the framework says?
Yes, it tells us effectively to determine the application in accordance with the development plan. That's not to set aside the statutory provisions of section 38(6) and to approve permission for schemes found to be in accordance with the development plan without delay.
Right. I then want to turn to some of the more controversial issues that may be in the mind of others following the council's case. Would you go to paragraph 817? 817, off-site contributions.
I have it.
You tell us there that the level of tree removal necessary to deliver the proposed development is outlined in Mr Tavendale's evidence, together with his observations on how compensatory off-site contributions had been calculated. Take that as read. You will recall that on-site replacement will be, well, virtually 1-for-1. 101%, I think, was Mr Tavendale's evidence. There will then be an off-site contribution. There's one factual matter that the inspector, I believe, would like some assistance with. We have a site, an allocated site immediately adjoining the appeal site. What investigations were made in terms of whether that site could contribute to the ecological balancing that was required under the BNG provisions?
Yes. As I understand it, and having spoken to my client's ecologist, I understand that she sought advice from Derbyshire Wildlife Trust, that being the appropriate body available, dealing with biodiversity net gain matters. That site wasn't one that was listed as being available to the appellant.
Even if it was made available, what was the prospect of being able to deal with, in particular, in addition to the tree issue, the translocation issue?
Yeah, as I understand it, that site wouldn't be suitable. As you know, so you've seen it. It's covered in trees. Translocation is to do with grassland, and that translocation is to take place at Chinley, where there is a different type of land that is suitable for the translocation. But the adjoining site that's in the council's ownership is effectively woodland. We wouldn't be comparing apples with apples, so to speak.
Right. Can you now turn to section 9, page 42 of 65?
Sorry, could you say that again, Mr. Barrett?
Page 42 of 65, section 9 of the evidence,
yep,
which deals with, well, it's a heading responding to the council's case.
Yeah.
In terms of policy DS4, we've already mentioned the access off the A57. Can you just reference, if you like, look at the policy if you think it would assist? I think you'll probably know it by heart by now. The 30% affordable requirement. Is that to be consistent with the application of policy H4?
Well, policy DS4 is quite clear that the policy has to be read in conjunction with other policies of the plan. So one must read H4 amongst other policies to be able to apply policy DS4 properly.
And if one applies policy H4 then, does that allow consideration to be given to viability of the schemes?
It certainly does.
And if the consequence of that assessment, well, first of all, upon whom is the burden of proving a development not viable?
The applicant or the appellant in the case of an appeal.
And is that subject then to the council considering whether there is robust evidence to support that conclusion?
It certainly is, and in my experience, there's very few authorities that would do that assessment themselves. Most authorities would go to an external consultant with specialist skills in dealing with that, and that's exactly what happened here with the council employing Bruton Knowles to independently assess the viability, and also a specialist quantity surveying practice, whose name escapes me, but that was also instructed by the authority.
So you then deal on the following pages with your assessment under policy H4, which we've just summarised. So the overall position, although there isn't 30% affordable housing, which is something that is in DS4, policy compliant, yes or no?
Most definitely, yes, because policy H4 contains a viability provision, and my evidence is that read in its proper terms could mean that the provision could be nil, where a viability case is proven, which is where we are today.
Section 10 then of your evidence, you turn to the case that was that of the council at the time of your preparation of this proof of evidence, is that correct?
Yes.
And in particular, consideration of the viability in the context of the allocation-wide development site, if I can call it that. Is that correct?
That's correct.
You rely upon the evidence of Mr. Heathcote in that respect.
I do.
The conclusion of which would be what if we applied policy DS4 and H4 consistent with the approach that you made earlier? What would be the outturn?
That the site's not viable.
Right. Section 11 then, your response to third parties. I'm hoping that we can take this as read, because people have had this now for 28 days or thereabouts, probably more. You respond not by named individuals in the main, but by themes.
I do, yeah. I thought that was the most effective way to deal with the points that had been raised, because many of them are duplicated.
A lot of the objections that have been made, and this goes back to the point we were discussing earlier about the development plan, object to the very principle of residential development of the site. Is that an approach that, in view of the allocation, is one that you consider ought to be given weight?
No, not at all, sir. The site is in an adopted development plan. We have a plan-led system. I think I drew attention in chapter 1 of my evidence to the Secretary of State's letter of September last year to all chief planning officers. I might just take it up if I may.
Yes, please do.
It's 1.4. Just bear with me. Sorry, I'm struggling to find it, sir, but it is in chapter 1 somewhere. But attention was drawn to the plan-led system and that allocations should be approved unless there were good reasons not to do so.
We now need to deal with, I believe, one further matter, and that's the Adderley Place scheme that was devised following the reason for refusal 4, and the evidence that we have now provided to the inquiry in terms of how that would work. In terms of coming to a view on that, is what Mr. Roberts put forward some time ago now, last week, is that a scheme that can be worked up further?
Yeah, it is. It is the scheme that appears in the evidence was a response to the council's refusal of planning permission. As you'll know, sir, officers recommended to their members that the matter was capable of being the subject of condition, and where we are now, that's plain. Notwithstanding the scheme that's in the evidence, there is also a proposed condition for the Adderley Place vehicle discouragement scheme, which we'll discuss in the conditions section.
I do want to go back to early in today when Mr. Bott was trying to describe in words how it might be accessed and the system abused by visitors to the site. Can you just talk us through whether that's really a credible scenario?
I just don't think it's very likely. We heard earlier in the inquiry from local residents who described Adderley Place as difficult to drive down because it's full of potholes and what have you. And I think someone said that they've a particular type of car and they don't take it out very often because of the state of Adderley Place. I just can't see why anyone would want to drive down Adderley Place given the condition as it's acknowledged by the residents. And sorry, just just pausing there, do you mind if I give you the reference for the Secretary of State, sir? Because it was tabbed in the proof, but it's 1.46.
Okay, thank you very much.
1.46, sir, yeah, thank you.
I think we must now come to the planning balance. You've obviously set out your conclusion that this accords with the statutory development plan. Planning permission may be refused if there are other considerations that indicate otherwise. In section 14 on page 57 of your evidence, you provide a planning balance.
I do.
And in terms of what other material considerations there are, would they tend to go in the benefit side of the equation or the disbenefits?
They go in the benefits. They all point and support my evidence that permission ought to be granted.
And you set out in a table on page 58 onwards the positive effects of the proposal, housing benefits, delivery of various types of housing, energy efficiency, design, biodiversity contributions, economic, active travel, trees, etc.
Yes.
Table 4 then is neutral effects. And you include, as a neutral effect, for example, sustainable travel monitoring. That obviously going to be a means to enforce the travel plan, isn't it?
Yeah.
Air quality monitoring, healthcare, etc. Because you are going to provide, or the client's going to provide, 82,800. This is on page 60 of 65 under heading healthcare.
Oh, yes, healthcare, yes, beg your pardon. Yes.
You may recall at
Mitigation.
an earlier point of the inquiry, somebody had mentioned, I think it was the officer's report actually, had said the contribution was going to be 40,000. The
Yes.
requested contribution is 82,800. The full quantum is going to be provided, is that right?
Yes, the appellant will provide 82,800, which is the full quantum required by the NHS, yes.
Yeah. And these are categorised as neutral effects because although there would be harm without to healthcare if there was no contribution, a full healthcare quantum is provided.
Yes.
And the logic of that is applied in respect of libraries, off-site tree planting, affordable housing, public transport, etc.
Yes.
All of which are dealt with in that way.
Yeah. Could I just point out, sir, chapter 14, footnote 7. So when we're talking about neutral effects...
Can you just direct to the page?
Oh, sorry, it's 56 of the proof of evidence,
Right.
not the PDF.
Right, I'm just going to go to it.
Yeah.
Okay, yeah.
Yeah, so page 56, bottom of the page, footnote 7, when we're talking about mitigation, generally speaking, you will find those in my evidence at neutral effects. I've put an asterisk on some of them, but some of those have a sort of passive benefit, so to speak. So they are mitigating the impact of the development, but for example, and just take the libraries contribution, for example, a stock-only contribution. Well, clearly, not only residents of this development will access that stock, other residents or users of the library will benefit from that stock being in place. But I've just placed it in the neutral effects. I haven't put it any higher than that.
I think you then draw the threads together in your conclusion. Essentially, you draw upon the statutory duty of decision maker to follow the plan-led approach, consider the application in that context. You reference the determination of the application. The professional planning officers of the council, as we now know, made a very clear recommendation, CD 3.1, the officer's report. Is that correct?
Yes, Mr. Barrett, it was very clear. It followed a long, intensive process of negotiation and amendment to the scheme for the officers to be comfortable professionally that they could recommend approval.
You then, on page 63, deals with what was then considered to be the remaining issues between the local planning authority and the appellant. Is that right?
Yes.
And your concluding remarks appear at page 64, 63 of the hard copy, 513 onwards, where you tell us that you're firmly of the view that the proposed development complies with the development, and paragraph 11C of the framework therefore applies. That means planning permission should be approved without delay.
I certainly do.
Yeah, okay. That's all I propose to ask. I'm just going to make sure. Is there anything else that you would wish to ask? I believe in terms of assisting the inspector, we've dealt with the point about the adjoining council-owned land and the Adderley Place displacement scheme.
Yes.
Thank you very much.
Thank you, Mr. Mayor.
Thank you. I do have some questions.
Yep.
You have covered some of the things that I was going to ask, but there are still some questions outstanding. But I'll reserve those to see if there's any questions from interested parties first, because they may cover those points as well. So, any particular questions, Mr. Miskell?
Yeah.
To the mic, please.
The proposal offers no contribution to the delivery of affordable housing. Is that not in breach of local policy DS4? The document still carries, a significant amount of weighting in the local plan.
Policy DS4 does indeed carry significant weight in the determination of this appeal, Mr. Miskell. But the policy is to be read in accordance with other policies in the plan, and that's stated very clearly in the preamble to the policy. And if you take up policy H4, that very clearly states that viability is a relevant consideration. And the position is viability is agreed. This site is not viable to provide affordable housing. So there is no breach of development plan policy in that respect.
Well, you could argue the site is not being treated in line with local plan allocation, and the proposed development breaches the requirement of local plan policy H4 in that it fails to maximise the affordable housing delivery across the local plan area.
Is that a statement or a question?
In the form of a question. I think what Mr. Miskell's trying to say is that the local plan had a policy that's specific with the allocation, and it's his view that it's not in line with that. And is it a breach? Am I interpreting that?
Yeah.
Interpreting that, or conflict? If we were to put it into different words.
There's no conflict. So you have to read the plan as a whole. You have to look at DS4. It tells you to look at other policies. You look at policy H4. It expressly has a viability aspect to it. That viability case has been proven. There's no dispute with the authority. The site is not viable, and there isn't a breach. There isn't a conflict with development plan policies. Mr. Miskell might have a different view. That's his position, but my position is there is not a breach with policy.
Yes, and ultimately that difference of opinion is for me as decision maker to decide what my view is on that.
Yes, of course.
And I am hearing from both sides, but yes,
I have to ask questions based on my opinion.
No, I'm not saying.
Or on behalf of
I'm not saying the ability to question is the wrong one. What I'm saying is that I'm hearing the opposing views. Ultimately, that judgment will be for me. So, yes, I welcome the question. Further question, Mr. Miskell?
Yeah, policy EQ9. The proposed tree replacement scheme fails to provide the replacement of a sufficient number of lost trees at a required ratio of 2:1, and therefore breaches the requirement of local policy plan EQ9. We've been told it's going to be 1:1, and I don't understand why.
Well, that's not correct, sir. If you just bear with me, I'll just pull up the relevant sections of the proof. That's right.
Is it worthwhile pull
Chapter 8, sir.
Chapter 8?
Yeah.
Thank you. I was just wondering whether it was worthwhile pulling up the policy as well. Just bear with me 1 second, I'll just get the policy up as well. I thought I had it up, but obviously not. Core document 4.7?
Yes.
All right. Yes. Okay, yep.
Do you have it, sir?
I've got the policy up for me, thank you.
So, Mr. Miskell, you say that the proposals breach EQ9. I disagree. EQ9 needs to be read as follows, sir. Paragraph 815 of my proof of evidence, where I produce an extract. The policy says, amongst other things, requiring new developments, and then I've highlighted some text which says, where appropriate, to provide tree planting and soft landscaping, including, where possible, the replacement of any trees that are removed at a ratio of 2:1. So that isn't telling us that 2:1 is cast iron, the requirement. The words, where appropriate and where possible, have to be considered. Those words are part of the policy, and they can't be ignored.
Before Mr. Miskell asks a further question, just to assist me, because it's in the realm of your answer now. In your view, in your professional opinion, what would be the reason for putting, for want of a better word, caveats of those nature in the policy wording?
It's quite often seen in development plan policies, these sorts of caveats. And those sorts of caveats are for circumstances where there are particular issues with the site, whether it's viability, it could be other matters. But the policy isn't binary, so to speak. It requires a level of interpretation. That's why it's got words such as where appropriate and where possible. And that is quite common to see in policy, in development plan policies, because decisions aren't just made in very neat little boxes. There are often other material considerations that are at play. So the policies are worded that way to allow them to be applied flexibly.
So just to pick your word up, applying the policy flexibly, or there's flexibility in the policy?
I beg your pardon. Yeah, flexibility in the policy. Yes. Yeah, because they are accounting for circumstances that perhaps can't be foreseen at the time that the plan was adopted. And obviously the plan is a 20-year plan. So at day one, one can't always see what's going to happen in 15 years' time.
Mr. Miskell?
Yeah, can you explain the reasons as to why you believe it's not possible or practical to deliver a 2:1 ratio?
Well, it's viability, Mr. Miskell, and I draw attention in my proof of evidence. Well, the viability is the answer. Okay. I've also drawn attention, sir, in my evidence at 819 to 823 to a nearby site, major site considered by the council, where a planting ratio of 1 to 1.15 was deemed acceptable, 820 of my proof. And that concerns a site in Dinting, probably less than a kilometre away, where the council considered that ratio was acceptable.
That's land north of Dinting Vale.
Yeah, it's near the station, sir.
Yes, because I referred to this one as land south to distinguish between the two.
Yes, yeah, that's right, sir. And in that case, interestingly, there were no viability considerations, but the replanting ratio of 1 to 1.15 was deemed appropriate. So that signals to me that the council isn't applying the policy strictly on the basis of 2:1 replacements. It's considering other factors. Now, it didn't reply to that evidence that was put. The council was given forewarning that that case was going to be referred to, because the documents are in the statement of case. But there's been no response to that in the council's evidence.
Thank you. I'm caught up. Mr. Miskell, further?
Yeah, I've just got a couple more. The scheme makes no provision to meet the criteria in a local plan as regards the delivering of affordable housing or local plan policy H3, and in turn fails to contribute towards meeting the council's affordable housing requirements at a time when published data demonstrates a strong need for affordable housing within the plan and the identifiable in the plan area and identifiable in Glossop. So therefore it's a conflict with policy H3, which I think the state was
No.
Complain?
No, Mr. Miskell, that's not correct. Again, the policies aren't to be read individually. The policies all have to be read together. So you can't, we comply with policy H4, that's the provision for affordable housing. It relates to viability. We've met that test, so there is no conflict. So,
In your opinion?
well, I am here to give expert planning evidence, Mr. Miskell.
Yes. Can I just ask the parties not across through me? Sorry, I was just completing the note on that particular point. Yes, it is. Yes, it is an opinion, and I take that into account. Obviously, I've been clear. I ultimately will be the decision maker in this case, assuming the possibility of no calling by the Secretary of State. On that basis, it'll be a matter of my judgment. So I'm just here to hear the different views. Obviously, the opportunity is to ask questions of Mr. Hurrigan, and I appreciate what your position is in that context, but just make sure it's framed in the form of a question, please.
Right, no worries. Sustainable travel plan. We're talking about 106 agreements. So in relation to the cycle path down to the access, there's an issue with, I apologise if it sounds like a repeat question, with Derbyshire Highways reluctant to put any monies towards a cycle path because they're not looking to adopt the road. They find it unadoptable to the gradient. So in effect, is the sustainable travel plan seriously compromised?
Just through you, sir, I think Mr. Miskell is referring to the, rather than the sustainable travel plan, I believe he's referring to the off-site link. Can I just ask that through you?
Yes, you can ask that through me. Just for clarification before he makes his answer, is it the off-site link that where in terms of what was being negotiated over the planning obligation? Just to understand.
Oh, yeah.
Yes.
So we're talking about the link from the southwest corner of the site to the Transpennine Trail.
Yes, that was my understanding. But for clarification, your answer is clearly directed at the question.
Yeah, the words travel plan were used. And
yes,
that's something else.
I think there's slight confusion in terminology. I think it's referred to as a sustainable travel link rather than plan. There's a travel plan as well, so it's just to avoid. I appreciate.
And as I've discussed, we're all laymen.
No, and that's why I asked you to clarify so that the answer wasn't misdirected away from what the question actually was.
Yeah.
So, are you happy to answer it now?
Yes, of course, sir. Yes, I'm happy to assist you. So you have an explanatory note dated the 7th of June. And this was produced by the appellant, and it was produced to answer some of the criticisms made about provision of the off-site link, if I just refer to it as that.
Core document?
It isn't a core document, sir. No, it's the explanatory note, the appellant's position following receipt of further statements from High Peak Borough Council and Derbyshire County Council on the 31st of May.
It's on the website.
Yes, it's on the website. It's just not a core document.
So I'm just going to answer your question, if that's okay. So the first thing to note, sir, is that the appellant can only do so much within the confines of the land under its control. We're going to have a session on the planning obligation and compliance with the SIL regulations, but the appellant made it very clear during the application that it was concerned about the SIL compliance of the off-site link. Notwithstanding that, it undertook to provide the monies requested by the County Council. And that's the basis upon which the appeal was submitted. And that remains the appellant's position because provision has been made for the off-site link in the Section 106 agreement.
Yes, but that's notwithstanding the concern. Document, the concern and the document that was submitted today about the in terms of the planning obligations. So it's ID 15, which we will discuss in the roundtable session.
Yeah. So the appellant has committed the funds to provide it. We're concerned it's not SIL compliant. As I understand it, where the 106 is now, is that we're paying the money to the Borough Council, and the Borough Council is going to progress the discussions. If the money can't be used for that particular initiative, it may be used for other sustainability initiatives in the vicinity of the appeal site. And if all of that fails, it will go into the pot of money for the tree contribution.
And yes, I did have a query on that.
Yep.
I'm assuming we'll cover that in the planning
Yes, sir.
obligations.
Yeah.
How the reason for that mechanism
Yeah.
and the justification for doing so, and obviously
Yeah.
without prejudice to your position
course.
set out in
Yes.
ID 15.
Yes. Now, as to the position on adoption of the highways, that's a matter for the County Council. And I have to say so, sir, that the County Council's position seems wholly inconsistent with that which they adopted at Linglongs Road in Whaley Bridge. And so when you look at the explanatory note and you look at the dates of the correspondence between the Borough Council, and I levy no criticism of the Borough Council in these answers, sir, because they've worked with us tirelessly to try and resolve this matter. But if you look at the dates of the correspondence between the Borough Council and the County Council about concerns raised about this matter, they are concerns raised after the Borough Council members had refused permission. Now, the fact of the matter is that in our view, the County Council's position is inconsistent when looking at Linglongs Road, and the Section 38 adoption agreement, I think, was signed in that period towards the end of October. So I can't see how, and we've talked about comparison of gradients with Mr Nichols, the appellant's engineer, and I'm struggling to reconcile why the County Council has taken such a position when at the same time it was raising objections to my client's scheme in terms of gradients. It was signing a Section 38 agreement on Linglongs Road. I think the position rests with the fact that the County Council could adopt the highways, but for reasons known only to them, and they've not appeared at this inquiry before you, sir, to answer these questions, but for reasons known only to them, at this time, they are saying that they won't adopt the highways and therefore they will have to be managed privately by the appellant.
Yes, and and without wanting to get into too much detail on the 106, there is the alternative for either option, either adoption or a management company to take on that responsibility.
Yeah, so in the event that the County Council doesn't come to the table at a later point in time, should the appeal be allowed, then the residents and the neighbours can be assured that the appellant will form a management company, and that management company will look after the roads and the gritting in the winter for the benefit of the neighbours and also for the new residents to the development.
You say for the benefit of the neighbours, i.e. us,
Yeah.
with it being a private road, could the residents on the new development not turn around at any time and say, stopping access, mate, we pay for that?
Well, that would be a civil matter. It's not a planning matter.
It's something we'd be left with at a later date.
Well, that's not something, sir, that's in the scope of my evidence.
I mean, sorry, another question. As regards footpath 50, I'm pretty sure it's stated on a Horrigan email or document sent to the council that it was recognised it would be virtually impossible to install the crossover point on the footpath without obstructing residents' right of 24-hour access. And the only thing available or practical at the time would be signage. That's on the document.
Do you want, well, through you, sir, if Mr Miskell wants to direct me to the document, I'm happy to take it up. But obviously the construction of the site is going to be the subject of a construction management plan. We've already established, because the residents have said so, they've taken legal advice about their private rights of access over Adley Place, and I believe they're in some form of dispute with the owners of the development site at the junction of Adley Place and Simmerley Lane over access. It's certainly not my client's intention whatsoever, sir, to block access for the residents of Adley Place. Should the appeal be allowed, they will communicate with the residents of Adderley Place as to how construction is going to be taking place, and that they won't be looking to block their access along Adderley Place for its full length. And we are going to have a session on conditions, sir.
Yes.
And in respect to the construction management plan, I think there was some suggestion earlier in the inquiry. Could we have some form of prevention of construction traffic coming from the junction of Simmerley Lane and Adderley Place along Adderley Place? The simple answer is yes, sir. We propose to write that into the condition.
Yes, and I believe my comments were of that nature as well, to say how I asked that question in my feedback on the condition. How would that be secured? Because I did have a broader question to clarify, which was it's questionable in some circumstances whether routing of vehicles can be enforceable. Yes. But in that case, obviously, because of its relationship to the site, the appellant believes that it can be, and has put a proposition to me about that being a condition that the access is meant. The construction vehicles aren't routed down FP50.
Yeah, I think from memory it says no construction vehicle traffic shall access the site from the junction of Simmerley Lane and Adderley Place. So it's sort of negatively worded. It's very, very clear. I'm also instructed, sir, because as Adderley Place is a private road, there would be insurance implications for my clients and their plant and construction vehicles were they to use that road for construction access. So it's not in my client's interest to do so at all.
Conscious of that, yeah, I answer that. Perfectly good statement. But from experience, we were told all surveys, plant machinery, whatever, would be at the initial outset, would be access off the A57. And then we wake up one morning to find a digger being brought up the footpath, supplied on site, and then we had a big argument with the guy who'd supplied the vehicle over the trailer. He was refusing to take it back down Simmerley Lane. Cost him too much, didn't want it being pinched. Our argument was it's actually obstructing our vehicle right up and down. So on paper, that sounds all fine and dandy. In reality, it doesn't work. There were a number of surveys done on that site which required plant machinery of a significant size, and it was brought up by Simmerley Lane.
Yeah. I don't know the details of the event that Mr Miskell refers to, sir, but what I can say is that were the appeal to be allowed, there's a construction management condition that the appellant would have to adhere to. And of course, once development starts, its staff will be on site during construction, through the entire period of construction. So you will expect to see banksmen, you will expect to see briefings given to construction personnel, not to use Adderley Place, and the intention is obviously to construct the development from the A57.
Yes, I believe I asked that specific question of Mr Roberts. It is approaching a week ago now, but I believe I asked that particular question because this concern was raised previously. And the evidence that I received from Mr Roberts was that it would be feasible and necessary for the construction, for the access from the A57 to be constructed first.
Yes.
And then that would give the options of maintaining the access in some form for residents, either via the new access or along Adderley Place while the works continue. Now, it's not a planning legal matter. Mr Barrett or Mr Richard may correct me on this. As far as I know, it's not a planning legal matter in terms of the right of access and any covenant. And obviously, negotiations may need to take place with those who have any legal rights in terms of how those may be conferred, but through non-planning rights in terms of access. But my understanding is there is a feasibility that access can be maintained to all properties along Adderley Place, so that those legal rights won't be breached. That's the assurance I've been given in the highways evidence, both in terms of access for residents to and from the property and emergency vehicle access.
Yes, those are my instructions, sir. Effectively, the development will be built from the A57. Trees will have to be felled. a whole road built along the alignment of the proposed road, and that's how they will get up to the development platform.
Yes.
Yeah.
Yes. Because that's the only possible way to do it without using Adderley Place.
Yep.
Yes.
Yeah.
One final question. I think we've alluded to this before, and I apologise if it sounds like a repeat question. In the construction of this pad, effective, and when it's complete, basically, you've got school children, parents with young children, parents pushing pushchairs, effectively walking through an open building site for the next 2 to 3 years. In relation to the pad itself, there's also going to be major conflict between access or right of way when we're competing against, and it'll be significant commercial traffic going from to the development. Also, as well, I'm concerned about the risk with school children. They run about, they gather about, they don't look at what's coming. And how will you safeguard the children who will be permitted to walk through this site?
Of course. Well, I think that's a perfectly legitimate concern that Mr Miskell's got, sir. So I'm just going to go back to the construction management plan. Obviously, from a health and safety perspective, it's in my client's interest to make sure that routes are appropriately fenced with temporary construction fencing. That crossing of the, shall we call it the access road to the development and Adderley Place, my instructions are that there will be a banksman in attendance there.
Just explain what a banksman is.
A banksman is someone that directs construction traffic in the interests of health and safety.
And in those circumstances, would they give priority for ensuring residents were not in conflict with those vehicles and basically allowed to move before the construction management?
Yeah, my clients would ensure that the residents' legal rights are protected. There's just no intention to cause any problems with the residents. If permission is granted, yes, we're going to have to build a major site here, but there isn't any intention to cause any upset with the residents, and Wayne Homes will speak to them, and they will put safeguards in place to make sure that people's safety is protected.
And just, I'm assuming you said that was your last question. Is there anything further, Mr Miskell?
No one wants to upset the resident, and with the best intentions, that won't happen. But from experience, it has. We've been obstructed right at the initial outset of this application.
Yeah,
I think we've taken that in evidence already. It isn't really a form of a question. It's just it's a question, and I appreciate its experience, and I do understand it, and I understand the strength of feeling.
It's not a bit in my mind, but obviously.
No, I think that I'll take the question on now, because I think in terms of it's more about the construction management plan. And the thing that I need to understand, taking on Mr Miskell's concern there, is through the construction management plan, would there be all the condition that had to be? We may be preempting a discussion, but I'll do it now because it seems relevant.
Yeah.
The construction management plan, in theory, could include some sorts of timing restrictions in terms of accessing the site that could potentially avoid the drop off and pick up times at the school.
Would you? Yeah, I think there are 2 time limited conditions in the bundle that we have. One is about piling.
Yep.
And avoiding sensitive hours. Piling conditions are usually phrased to avoid sensitive hours from an amenity point of view.
Yep.
And I think there is a construction timing condition. But you're asking, sir, if I may just clarify, I was just a more fine-grained matter.
Yes, I was wondering. It struck me that the condition is on for the construction management plan is relatively generic. The one that's a residential amenity-focused ones in terms of timing of construction.
Yeah.
I was wondering whether whether it's feasible or enforceable and meets the test of a condition to limit construction traffic during a particular times, which to my mind would be at the time when the schools pick up and drop off time.
I would need to take instructions, sir, on that particular point. If it's something we can pick up at the at the conditions session, I just wonder whether the matter would be better served by way of, as I say, having a banksman there, you know, to deal with these things. But I mean, say I'd have to take instructions.
Yes, I'm not compelling that. I was asking the question really whether it would meet the tests and is a feasible option, or whether there's alternatives there that could give comfort to local residents. Because I have heard the strength of feeling about the highway conditions along the A57, particularly at pick up and drop off time, and I have undertaken an unaccompanied visit, notwithstanding the inquiry document about the social media activity. I have done it a number of times, and obviously observed those conditions. So I recognise the strength of feeling about that. I haven't reached a particular view on that, so that shouldn't be interpreted as me saying that I consider that there are issues or harm with the access. I'm just saying, is there something that could give residents comfort on that, and would it meet the test of a condition?
Yeah, okay.
Just one note. I asked that you good self takes on board that the police were actually called out to Dinting School Friday and again on Monday to try and ease the chaos or get traffic moving. And it's unfortunate on the day of all days you're up at Chinley.
One thing I can say to you, Mr. Miskell, to confirm, is I was at Chinley, but the route that I took back was past the school when the sports day was operated. So I did observe members of the public stood all along the footway watching the sports day in Dinting Primary School. Thank you. Thank you.
Thank you.
Any further questions? Yes, Mr. Gleave.
Hopefully I won't work around too much. It's just been brought to my attention by Julie, as part of her research that she did through the estate agents. None of the new build estates in Glossop are being adopted by Derbyshire County Council. It's not just a slight inconsistency as you made out. What are your thoughts on that?
Well, the inconsistency that I highlight is to do with the County Council's rationale for resisting adoption, which is purely about the gradients. The scheme has been designed to adoptable standards, so it will be safe. But the point I make is that they are being inconsistent because their reason for resisting adoption is a gradient issue. Now, I don't have any information about the other sites in Glossop as to why they haven't been adopted. That's not in the evidence as far as I'm aware, sir.
Yes, it's a particular point that's been drawn, a consistency with it's
Linglongs Road, which is in Whaley Bridge, so yeah.
Yes.
Yeah.
None of the other estates in Glossop that have been adopted don't have any gradient issues, so it's not a gradient issue with them. I think that's the only issue that you're suggesting with this one. But okay, you've answered that question. So I've just got a few more.
Sorry, sir, for your note. Yes, there is no evidence before the inquiry on those particular sites. That's just a statement about other sites. We've not been given details of the sites, where they are, what the discussions with the county council are. None of that evidence is before the inquiry.
Mr. Gleave?
Yes. So during your statement, you went through the good effects of the development, you went through the neutral effects, but what negative effects did you highlight in your report? None.
I haven't highlighted any negative effects in my evidence, sir, because I don't believe there are any that aren't mitigated for by way of condition or obligation.
Sorry, correct me if I'm wrong. There's a very minor. It's not listed in the table, but I think in your proofs there is a very minor suggestion about effects during construction.
Yes.
But you don't consider it runs to harm.
No.
Just for clarification.
Yeah, of course. Yes. No.
Answer.
Fair enough. But that would be dealt with by way of condition. It doesn't go to harm, as you say so, sir. Yeah.
Yes, it was a point of clarification because I read that. I read that little paragraph earlier, and I just
got to be fair and reasonable.
Yes, I need to be fair on that particular point.
No, that's fine, sir.
My final question. All the way through, we keep hearing about how this site isn't viable. So if it's not viable, why is it still being considered as a development?
well, it's not viable to provide the full suite of obligations that is sought by the council. It's a slightly different point.
But as a layman,
Yes.
why is it still, if you can't meet those standards,
Yes.
why is it still being
It's
considered?
because planning policy allows us to put forward developments where there are viability problems that can then be shown to be compliant with the development plan.
That's it. I'm
Thank-
trying to keep it short because Phil's gone already.
Thank you, Mr. Gleave. Thank you. Just picking up that point, and it's touching upon the viability evidence and the questions that I had on that particular point. Obviously, there are matters of dispute of remaining on viability between the council's consultants and your own witness. Was there any, given what the questions I asked and of the viability witness in terms of how slight differences in variables when extrapolated outwards can result in difference in figures. Was it a matter of judgment for you to pursue the site with the planning obligations and agree to the obligations on that basis, that an understanding that, you know, think there may be movements in the financial figures that may make it work to the extent that the council finds it, in terms of the position of difference between the two viability consultants? Because it isn't always a typical position that a developer decides to pursue against the evidence that has been submitted. So it's just an understanding of those kind of value judgments that placed on it, and an assurance to me that were the appeal to be allowed and planning permission granted, and this is without prejudice to any decision I ultimately make, that the site will be deliverable.
Yeah. Those differences between consultants are quite normal, as you say. The small differentials on multiple issues can lead to a large figure in difference. The appellant or applicant, as it was at the time, took a judgment call, sir, to be perfectly honest. It was faced with the prospect of a refusal locally without coming to the table with the council's position. It sought to work with the council throughout the application and didn't want to end up at this appeal.
Yes.
And from an appellant's point of view, and just being perfectly candid about it, so obviously appeals are risky to appellants. So a commercial decision was taken to reluctantly accept the council's position in the interests of progressing favourably at a local level. We are where we are now. The appellant wouldn't have expended the significant sums required to pursue an appeal of this nature if it wasn't confident that were you to grant planning permission, sir, that it would deliver this scheme.
Thank you. So my understanding is that it was within the tolerance of reasonableness
Yes.
in accepting, despite the differences.
Notwithstanding.
Notwithstanding the differences,
Yes.
and not conceding your position.
No.
Ultimately, you found the council's position to be within the tolerance of what you considered the development may be able to bear if
Yes.
if the assumptions and different assumptions when
Yeah.
you build out were proven to be
Yeah.
more favourable.
Yeah. If I could put it like this, sir, and excuse the bluntness, my clients are in the business of house building and they want to get on and build some houses, good quality houses. And so that was a commercial position they took, notwithstanding the difference of opinion between the two respective experts on viability.
Thank you. I don't want to go too far down the line of commercial decisions, etc. Because that's for the appellant themselves.
Yes, of course. Yeah.
How they choose to do that.
Yeah.
It was just from my understanding, because yes, there are differences on viability.
Yeah.
Sometimes, more typically, we find that parties stick to the guns on these things rather than. So it was just understanding that the kind of thought process and giving me an understanding of where we're likely to end up on that.
Yeah.
Are there any further questions from the audience before I run through mine, Mr. Bennett?
Thank you. Yes, I just wanted to explore with you in a little bit more detail your understanding of your statement in relation to the access from Adderley Place down the unadopted road onto Simondley Lane. And I think you said that in your view, it would be most unlikely that anybody from the new development would make a conscious decision to take advantage of what may be provided, and we've talked about the possibility of conditions, of the possibility that someone could actually turn into Adderley Place and go west and turn round and come back all the way along the road and along the unadopted section onto Simondley Lane. Are you saying that on the basis of your professional opinion or on the basis of some sort of knowledge of data of how people behave when they're faced with the possibility of a traffic queue?
Yeah, I was basing it on the evidence given by Mr. Roberts, but also on the observations that, and forgive me, I don't know whether it was you that made the statement earlier in the inquiry about the state of the road of Adderley Road. You know, so you've walked it, as have we all. It is potholed. I just don't understand why anyone would seek to use that, knowing the state of it. So that's as high as the statements. But
well, through you, sir, there's always the possibility that that road could at some stage be improved by the residents. They may choose to carry out repairs as they have done so in the past. I'm just wondering about the situation that perhaps you may have witnessed at the end of last week when there was the sports day. I didn't witness it myself.
I did, yes.
But I would expect that in that situation, you would have standing traffic literally outside at the bottom of the A57 where the new access road comes. So I wonder how long you would expect people to be prepared to sit in a queue from the new estate when they had the option of just going up another 50 yards, turning around and then coming out through Adderley Place onto Simondley Lane. I don't think it would take many people long to establish if that was an option, and that would mean basically they would be faced with standing traffic on the A57. Like they wouldn't choose that option. They may go quite slowly down Adderley Place, avoiding the potholes and trying to avoid any damage to their car. But they would then come to Simondley Lane as the exit, which is a totally unsuitable exit to access safely onto Simondley Lane from Adderley Place. And they could end up going up Simondley Lane over High Lane, or they could choose to go left and then go right and then disappear off up the Snake.
Thank you, Mr. Bennett. Just before Mr. Hurrigan replies, just my understanding what I'm getting at, and Mr. Hurrigan can answer the question from me and Mr. Bennett as one, is it's technically feasible to turn into the western spur of, or what would be under the current proposals, on the western spur of Adderley Place from the access road, to turn round and to go down Simondley Lane. But what I'm hearing in the evidence, both from Mr. Richards and from yourself so far, is that as a matter of convenience, typically people wouldn't do that because, for want of putting it any better, you've got a perfectly good access road that gives you an access outwards, so why would you do that unless there was a constraint to actually go out? Now, I'm hearing the constraint that Mr. Bennett's referring to. I'm just wondering, because having been familiar with the site layout, is there any visual obstruction that would actually mean that, unless the queue was all the way up to Adderley Place, would you actually be able to see it at the junction? Because my understanding is it curves. It does actually curve round. So it would, unless the queues were severe all the way up to Adderley Place, which, based on the highway evidence I've received, suggests that would take a quite significant period of time to actually occur. Would you actually see the queue to incentivise yourself, for want of a better word, as I think you're alluding to, Mr. Bennett, in terms of seeing the queue, right, I can go that way instead?
Yeah. No, I don't think you would, sir. It's a very fair observation that you make, because effectively the road is winding. But not only that, there's a very significant difference in level. And I don't think you'd be, if you were sat effectively at the junction of Adderley Place and the road in an average car, I don't think you'd be able to see down the hill to the bottom of the A57. So what would happen is you would go down the access road and its snaking manner, and you'd get to the bottom towards the junction, and you'd wait because you wouldn't then turn round.
Yes, my understanding is because obviously the highway construction, how it's talked about with the ramp and then the increasing gradient, it might be a difficult manoeuvre to turn round once you're actually in that queue.
Yeah.
I'm asking the question. It's not a statement of fact. I'm just wondering whether it would make it a rather difficult manoeuvre.
Yeah.
Because we're talking about matters of convenience and what a reasonable person would do.
Yeah. And also, I think it's fair to say that, people who live at this development, whose children go to the primary school on Dinting Vale, the site is so conveniently located for them to walk to school. And given that we've segregated the footpath as well, there would be an incentive to walk down to school.
Okay, thank you. Anything further, Mr. Bennett?
Well, I was just going to say, I don't know whether you use Google Maps at all, but a lot of people, as soon as they get in the car, they will switch on Google Maps and they will look to see where the red lines are on the roads. And they may well see a continuous red line on the A57 at the bottom of their new development road. That's one point, really.
Yes.
And the other thing is, I don't have a great deal of confidence in the moral basis for delivery drivers. And if delivery drivers have got to make a delivery on a new development, and then they've got to go up to the new estates in Simondley, I'm sure a lot of them would choose to travel west, turn round, and then go straight down the unadopted road. And they're not so worried about the condition of their vans quite often.
I think we have touched upon the delivery drivers before, and I did ask a question of Mr. It was either the civil engineer or Mr. Roberts, with respect to whether that would increase the number of delivery drivers actually moving along FP50, because obviously residents of Adderley Place will already get delivery drivers, and we did have a discussion talking through the manoeuvres that it might be more convenient for delivery drivers to go down turn onto the western spur to do the deliveries rather than going all the way round. So you may reduce the number accessing via FP50, but the ones going outward along FP50 would be broadly the same, because people typically would then go straight on if they'd done the delivery there, or they may turn left if they had deliveries that were elsewhere onto the access road.
But the point I was trying to make was that if people are delivering to the new development, then which is 92 homes, and if it's Amazon or whoever, or any of the many stores that do home deliveries, then coming off that estate, they may actually take advantage of the possibility of turning left to go down Adderley Place, which I think is possible, to the west side, and turn round.
It's technically
and then
feasible,
come
yes.
all the way down the unadopted road, because they need to go up Simondley Lane to make deliveries in Simondley, rather than going down the new road, trying to get to turn right onto the A57 to the mini roundabouts, then coming up Simondley Lane.
Thank you. That's helpful to clarify, because I'd heard the evidence about link trips, and I think what I'm hearing the evidence now is someone that wouldn't be delivering to Adderley Place, but the new development might use that to go there. And I think it may be broadly the same. What you've already said about the access, you may not want to say. I do want to pick up on the point about the Google Maps, though, and people seeing that in that particular point, and whether there is a concern about that.
Just to go back to the delivery point first, sir. My experience is somewhat different, because I actually live on an unadopted road that's probably twice as long as Adderley Place, so it's very narrow. And my personal experience is that delivery drivers are very precious about their vans because most of them rent them. If they damage them, they have to pay a large excess, all the damages. And again, I just return to that point. I just don't see why they would use it, given it's the state of the highway and the discouragement scheme that that the appellant has put forward, which is also going to be subject to further conditionality to get the fine grain of that scheme right.
And the Google Maps point?
They might look at Google Maps.
Yes.
We can't discount that, but
So there is the occasional possibility.
I think there must be, sir, to be fair and reasonable about it. And I think also that the point that Mr. Roberts made to you in evidence about queuing, I think that has to be, the Google Maps point has to be considered in that context.
Yes, and then yes, I take that point, and we can pick up the discouragement scheme and the extent to which that can be conditioned and modified in the conditions session. Yes, sir. You can ask a question. I don't think I've taken your name previously.
I'm Rob. And
Sorry, what's your surname?
Holt, H-O-L-T. I live on Simmerley Lane.
Very brief point of clarification because you haven't given evidence.
Yeah,
so yes.
I know, but I want to make a personal observation on this because I've heard what Dave said, and I've lived there since 1993. As we know, there's a scout hut halfway down Adderley Place, the unadopted road. And when my son was young, about 95, 96, we used to go down to the scout hut, and we used to walk down, and we used to walk along. And in the middle of winter, we had to wear bike lights because of all the parents that wouldn't walk down. They lived very close, but they wouldn't walk down, and they drove along the rough road, and they queued, and in the middle of winter, the fumes were terrible. I went into the scout hut and said, can they not walk here? You're a scout group. They couldn't stop it. This was on, the road was rougher than it is now, so they made a conscious decision. The other thing is, where I live, there's a full-flown cricket pitch. Now, the entrance comes down an unadopted road near where we live, and I can see from my back garden the chaos every time there's a waymarsh into a small private road with garages. They're going into the garages rather than into the main. Now, this estate is going to be behind the other side of that cricket pitch. Now, I don't know what the cricket pitch is going to do, whether they'll put another gate there, but if they don't, all those parents bringing their kids on Friday night to play cricket on the local ground are going to be driving along Adderley to turn right.
Is there a question for the witness, Mr. Holt?
No, I'm just making this personal statement of following up from what Dave said.
Okay, I'll take that as a statement. I'm assuming you don't want to. Do you want to answer questions or not?
Yeah, I'll make it as a formal statement. Yes. Okay.
Thank you, Mr. No questions, Mr. Barrett. No questions. Thank you. I think if there's no further questions there, I'll run through my questions briefly before we take a break. Is that agreeable to the parties? Thank you.
So can I just help you with, no, there was a discussion about trees, one-for-one replacement and financial contributions. So can I just ask you to note paragraph 8.5 of Mr. Hurrigan's evidence, 3865 of the PDF, so that presumably is page 37. He explains one-for-one replacement. Council's arboriculturalists wanted 136,000 plus for off-site planting. On the viability assessment, the one-for-one plus 72,400, together with a maintenance contribution, was what was ultimately agreed. It's just set out there quite succinctly, sir.
Okay, yeah, I've made a note. I'll refer back to it. Thank you, Mr. Barrett. Okay, just in terms of my questions, first to Mr. O'Regan, just on the plan-led approach, just for confirmation, we're referring to core document CD 412 in terms of the review of policies. We skimmed over it quite quickly. You answered Mr. Barrett's question,
Oh, yes,
but
sorry,
I was
yeah,
just
the
making
review.
sure I'm looking in the right place in
Yes.
terms of the review. Yeah.
Yeah.
Just to follow up on that, the wider scope of that document, amongst other things, identifies policy H4 relating to affordable housing being deemed out of date for development management purposes. You did mention about the thresholds, etc. I'm just wondering, with respect to this particular scheme, whether policy H4 and by extension policy DS4, which takes a similar approach in asking 30% and doesn't have any particular thresholds of itself, is relevant for the purposes of decision making in this particular case, given the quantum of development is outside of the potential scope of what that actually found.
Yes. Yeah, it is relevant, sir. I think I drew attention to the fact that it had been found to be not to be up to date because of that 10-unit threshold.
Yes.
I think the framework directs us that sites that are not major development, which is 10 units, shouldn't be providing affordable housing except in certain designated areas.
Yeah, I think the question for me was obviously that becomes a more pertinent matter for schemes of 10 and below, but this is for 92.
Yes.
So in theory whilst I'm not calling into question the fact that the council has declared it out of date,
yes,
there is a nuanced kind of look as to how that policy is applied to a scheme where that threshold isn't affected.
Yes, and it would still be applied today, is my evidence, sir.
Yes. Thank you. And then, and I know we've not really touched upon these policies, but this was one of the reasons why there was method in my madness to ask for these documents to be added. I think they became IQ3 potentially, or something like that. The extracts.
Yeah, I've got them. So
policies S2, S3, and H2 of the local plan. Note they're not a matter of dispute, and that policy S3 of the local plan is considered to be out of date by both parties. And that's on the basis of the housing requirement set out in the plan being more than 5 years old, and therefore the local housing need calculation in accordance with the framework and planning practice guidance kicks in, for want of a better word. In that respect, the most up-to-date calculation that I had was the core document 6.3, and that was suggested a requirement as at 1st of April 2023 of 258 dwellings per annum.
Yeah.
And then I asked for an update, and that was IQ7 in terms of removal of the buffer. So by virtue, that number reduces. You didn't give me the precise figure, but it doesn't really matter in that context because you've got an agreed position anyway.
Yeah, the council had received the 22 HDT results.
Yeah.
And the 5% buffer was removed.
Yes. And that the point on that I was looking at on that is the evidence in 6.3 was at 258 dwellings per annum.
Yes. 5%
reduction on that by removing the buffer takes it below. We don't have a precise figure, but that isn't the material to what I'm asking. That's still significantly below what the local plan was looking for, which is 350.
Yes, minimum
per 350 per annum.
Per annum over the plan period.
So just for my understanding, in those circumstances, I know that becomes a long question, but I needed to set the scene on this. I just welcome your view whether even in those circumstances you consider the broad distribution of development in the settlement hierarchy in S2 of the local plan and the sub-areas identified in Table 3 and therefore the allocations in policy H2, namely the site being one of them, remain relevant for the consideration of the proposal, even with a reduction in the housing target.
Yeah, they certainly do, sir, because those policies have not been found to be out of date by the authority during its review. Just bear with me a moment while I pull the policy S3. Glossop sits at the, just in terms of that settlement hierarchy. That's right. bear with me a moment, sir.
Yes, no, that's fine.
Yeah, so Glossop Dale, just referring to that policy S3, Glossop Dale, was to take the one of the largest shares of dwellings, new dwellings on sites, 27 to 35%, just slightly behind Buxton. So I don't think it affects where Glossop sits in the hierarchy. Glossop is a sustainable town that would be expected to accommodate further growth in housing numbers.
Thank you. Then on to DS4. Let me just have a read. We may have already covered it.
Yeah.
So, yes, I think I was looking at the interaction between DS4 and H4, which you've looked at in detail. The one area you didn't cover was the relationship of policy CF7. So just for completeness in that respect.
So CF7. That's right. Yeah, I think this was a policy that I referred to in my evidence. It wasn't one that the authority took issue with in its decision notice. I think I just drew attention to it because of the reference to viability. Just bear with me a moment.
Yes, I'm just pulling up CS7 as well. It's the broader planning obligations and community infrastructure levy, as the community infrastructure levy was expected at the time.
Yeah, that's right, sir. And it's the third paragraph of the policy, which talks about an assessment of development viability and infrastructure requirements. And I just highlighted it because I thought it was relevant just to highlight that policy as a policy relating to obligations and SIL and viability, but I put it no higher than that, sir.
So you consider it to be it's relevant?
Yes.
Thank you. And then affordable housing specifically. Your evidence and your proof refers specifically to the weighting to be applied to non-provision of affordable housing.
Yes.
Without prejudice on any views I may reach in terms of policy compliance in my decision, just welcome some further explanation just on that point in terms of the weighting.
Yes. Just bear with me a minute, sir. Yeah, just bear with me a moment. I think it's in the affordable housing section. Yeah, I said that no positive weight could be ascribed to the absence of affordable housing. It's slightly unusual affordable housing in that the need pre-exists. So if my client's proposal doesn't provide any affordable housing, effectively the community is no worse off than it was before my client's development. So rather than, I think as was put initially by the council, that harm arose due to the absence of affordable housing, I disagree with that. It's just that no positive weight can be ascribed to the absence of affordable housing. It's slightly different to when one looks at traditional mitigation in the forms of, for example, off-site highways works. Those works would be required to mitigate some level of harm.
So my understanding of that position is that your proposition is that affordable housing is a benefit.
Yes.
It's a benefit, albeit a policy compliant benefit, but it brings forth a benefit that accrues positive weight. But the absence of it is effectively neutral if you have an otherwise policy compliant development.
Particularly where there is a viability issue, as is the case here.
Where there's allowance in the policy for that.
Yeah, which the policy allows for in H4.
Yes, but you say the community's no worse off. I just want to explore the avenue, and I think it's been raised by others during the inquiry.
Yeah.
That it's an opportunity lost to deliver affordable housing, or is that the wrong Is that the wrong position to take because of viability?
I think it is, sir, because we're talking about not just delivering affordable housing. There is a need which is established in the plan for all types of housing. So we are delivering, or propose to deliver here, 100% market housing, a range of house types, a range of sizes of dwellings, from 1 to 4 beds, but principally more the smaller types of dwellings. Now, when those types of dwellings are provided, obviously supply and demand, that frees up other opportunities within the market for people to access housing. So I recognise we're not providing any affordable housing, but that's fully justified under the terms of the policy.
So the proposition that, as I understand it, is that it's either, because of the viability, it's either the houses come forward in this form or they don't come at all, and in your view, affordable housing, it's a theoretical proposition for the purposes of this site that isn't borne out by the evidence.
Effectively, I mean, it's the need for affordable housing exists. It's not disputed, but those provisions don't apply to this development due to the viability issue. So I say that, you know, don't say harm arises, because I don't genuinely believe harm does arise from the absence of affordable housing where there's a proven viability case, but rather no positive weight could be ascribed to that. And it's a slightly different.
Yes, no, I think I understand it, and obviously I need to reflect. I need to reflect on that position, but it isn't an unfamiliar argument that's heard by inspectors in these particular circumstances. I just wanted to explore that point about the community benefit and to understand where that statement was coming from, because I appreciate on the live stream and also for my consideration, hearing that in isolation when as part out of context, may be read differently. So I needed to understand what the rationale for that statement was. Okay. Just in terms of the viability point, just checking on how I should read it against the framework. My understanding was it really is without prejudice to the cost application that you've made in any response that I'm ultimately going to hear in this point. The argument that I've obviously heard the respective arguments from the parties with respect to whether the reason for refusal and the issue raised about the allocation being considered as a whole on a viability basis was reasonable or not, and that's for something for me to reflect upon. But I'm asking this question because I think it's necessary to ask it, notwithstanding that the costs application is. There is a paragraph 128 of the framework. There is a focus on that decisions should support development and make an efficient use of land. This taking it into account, amongst other things, includes the identified need for different types of housing. So to support development in that context, I'm asking your views as whether it is necessary to look at the allocation as a whole in terms of how it would be brought forward, to avoid the possibility of sterilising another opportunity or parcelling off land to avoid contributions. Now I understand that there is evidence before me to demonstrate that is not the case in this particular instance, but the query that I have is, did the committee at the time have that? Would they have been aware that wasn't a possibility of parcelling the land off because the council was a landowner?
Forgive me, sir.
Sorry,
I don't quite understand the question. I was at the committee, so
yes,
and I did listen to the debate, so I can probably assist you in some respects.
It's the paragraph 128 requires the efficient use of land. The application is for part of an allocation. So what safeguards at the time of the decision were in place to give assurance to at the time of the decision, that it wasn't an exercise in parcelling off part of that allocation or sterilising the possibility of the remainder coming forward.
I think in the committee report, I'm just going to bring it up, so I just need it on another screen. I think there was a provision.
That's why I framed it, because it does touch very closely to the cost application, and it's not a reflection on any judgment I've reached. It's just the paragraph 128 point is necessary to understand in that context.
Yeah. Just bear with me a moment.
Is everyone happy for me to proceed? We've hit 4 o'clock, so I'm conscious that we've been going for about an hour and 45 minutes. I think I've probably got about 5 minutes left, if everyone's happy to proceed, and then to a break. And I do think we potentially, with a 15-minute break, could still finish by 5 o'clock in terms of the programme that we've got today, based on my questions at least.
I'm very happy to say it's best to break when the witness situation
is
best fit.
I was just checking at this particular point.
Yeah.
Yes.
CD 3.1, sir.
Yes.
Page 62 of the PDF. The recommendation under the section 106 heading included securing a link to any future development to the east. I understand that to be the council's land, effectively.
So in that respect, you're satisfied that they were aware that an efficient use of the allocation could be made at that point?
Yeah, I think so, yeah.
Thank you. The next one's on developer contributions SPD. That I had. Now, I saw some correspondence that suggested it may be added as a core document, but I don't know whether was it ever actually added as a core document.
I think it's in the bundled. Let me just check.
I must confess, I did a search of. I did a search of the inquiry website to try and see if I could find it, and
I think it's 6.27, possibly.
6.27,
possibly.
Yes, that hasn't made it to the email, the website.
Okay.
It is on the
Yeah. Shall we email that to Kurt Brown?
Yes, please. So that I've got it before me. I believe it may have been in the bundle of the original application.
It was
the original application bundle, but it didn't carry through. So I have seen it, but that was the query that I had, just to make sure that it becomes a core document, because I'm asking a question of it.
Yeah. Okay. Just in terms of the chronology, sir, it wasn't listed in the council's decision notice.
Yes.
It became adopted between the time that the members resolved to refuse permission and the decision notice materialised. So had the council considered there was some conflict with the SPD, I would have expected them to have highlighted so in the decision notice. They did not. And then I think it was either in the statement of case or Mr. O'Brien's evidence, there was some reference to it, so it was included in the bundle for your reference.
Are there any specific... Sorry, Mr. J, I will come back to you. Go ahead, actually.
It's document number 442.
In
the original bundle.
The original bundle.
Yes. So it's CD 627.
Yeah.
Yes.
And in the original bundle it's 442.
Yeah.
And just in terms of the paragraphs that I should be looking at of that particular document, are there any particular paragraphs on viability that might assist me?
Sorry. Just bear with me a moment, sir.
I don't have it up on screen, which is why I'm asking. I will read them later.
Yeah, just bear with me.
But it's reading the guidance around that wider point, noting the chronology of what you've given me.
Yeah. So there's a specific section. It's page 10 of 30 of the PDF on viability. I think it goes to the points that you asked earlier, actually, I think Mr. Barrett asked me in chief, where does the responsibility lie for proving viability? Lies with the applicant at an application stage, so that's where we did there.
Yes, and then the weight to be given to it falls on the decision maker.
Yes, sir. Yes, of course.
Thank you. I've nothing further on the SPD. I'm happy to go away and read that. I was just making sure that it was procedurally it was in the right place.
Yep.
Housing land supply. I know I've got an up-to-date position agreed between the parties. I just wanted to explore very briefly that rationale in your proof that you considered the document published in November 2023 to be out of date. I know.
Yeah. Okay. Yeah, that materialised in response to points that were put in the council statement of case about housing land supply. For my sins, sir, I've spent what feels like an age going up and down the country arguing about housing land supply. And one of the constants about housing land supply is that the requirement part of the calculation and the supply element of the calculation need to be in balance. So the document you have before you at the moment, CD 6.3, has a base date of 1st of April 23.
Yes.
Obviously, we've now passed that base date. The council is in the process of preparing a new document. As they do so, they will need to ensure that the supply position, as of 1st of April 2024, and that will be different to what the supply position was at the 1st of April 2023, because hopefully some permissions have been granted, and of course some permissions will fall out of the suppliers as sites are built. But the two things need to be in balance. And what we say, what I say at the moment is that it is not that most CD 6.3 isn't the most up-to-date position, because we've passed the 1st of April base date 24. The new document, when it materialises, obviously is not before you, sir. What I do say about CD 6.3 is that with regards to my client's site, the council used its standard lead-in times and delivery rates to effectively estimate what the contribution of the site would be in the 5-year period. Having put this evidence together and were the appeal to be allowed, I would expect the council to put all 92 dwellings in the next iteration of the 5-year supply, because the evidence of Mr. Heathcote is that there's a 3-year development programme. So even allowing for time to discharge conditions and sort of 278 out and what have you, we would expect all 92 dwellings to be delivered within the next 5-year period. So that would be base dated of the 1st of April 24 to 31st of March 29.
Yes, and I was just trying to explore whether it was a little bit of a technical argument, really. That the most up-to-date available evidence to me is CD 6.3 with the update in the inquiry document that I asked for to take account of the framework. And yes, acknowledge that we're past the 1st of April, so in theory the start date of the next document, we're in it.
Yes.
But the publication is typically in November every year, so
yes, there or thereabouts.
So there is an inherent uncertainty to it.
Yeah.
But the most up-to-date evidence available to me is CD 6.3.
It is, and it's the agreed position that we found with the council, and of course, either the authority has a 5-year supply or they don't. It's a binary position, and there's no dispute between us and the council that there is a 5-year supply here.
Yes, and my understanding, and you can correct me should you wish to do so, is that if we were to monitor it live, that position likely would be different.
Yes.
But it wouldn't be so different that it would mean that the position of having a deliverable 5-year housing land supply would change because of the margin that's in the previous figures.
That could well be the case.
Yes. I'm not going to ask you to draw uncertainty, but
the uncertainty of that calculation, sir, is what is the supply as of the 1st of April 24.
Yes.
I simply don't know.
No, and I'm not asking you. It's for the simple purposes of what we are, where we are.
Of course,
the agreement is what it is, and,
Yeah.
and correct me if I'm wrong. Is 6.7.
Yeah.
That's quite a margin above
Yes,
the
it is.
5-year
Yeah.
supply position.
Yeah.
So something significant would have
Yeah.
to happen in the year
It would.
for that
To
to
drop
alter.
out. Yes.
Yes.
Yeah, no, I accept that, sir. I think the point I would just ask you to take away is about delivery and the number of units to be delivered within a 5-year period from this plan-led site. That being all 92, not 30 odd that the council had it as. 39.
Yes, and in theory that would add to the position.
It would,
in principle.
yeah.
Yes.
It would, yeah.
Yes.
Yeah.
Thank you.
Yeah, and that's a good thing.
Yes. No, I appreciate you're asserting that as a benefit. Thank
So,
you.
In that context, could I just ask you to note that the council is required under the NPPF, paragraph 76, to identify a supply and update annually. As you've observed, it takes a while to be in a position to update annually. I mean, if we were all sat here in December and the council had not yet produced its 1st of April annual update, then we might be in the position of somebody saying, well, have they actually updated it annually? It is now the 1st of April 2023 such a base date ago that we should now regard the council as not having updated annually?
Yes,
Whereas
I
we
hear
both
what you're
agree
saying.
at the moment that we are still within the window for updating annually, and therefore we are doing what the NPPF says.
Yes, I appreciate what you're saying. I was only exploring a technical point, which is important for ultimately where I end up in terms of whichever decision I reach. That position may be important. So it was just exploring that point that I don't say something that isn't a point of agreement between the parties or a point of contention that might be of significance. So I think I've explored it and I'm happy. But thank you for your contribution on that one. The other one that I had was the land at Dinting Road, Glossop. We have explored the 2-for-1.
Yeah.
I don't propose to go there in any more detail other than just explaining your views in terms of the extent to which the proposal is similar or comparable to the appeal proposal before me, because it talks about viability and it's obviously striking me that you say there was no viability constraints and that could deliver affordable housing. So if you're drawing comparison in that, what's the difference between the two sites that means those position? Was that not subject to such abnormals in the same way, as far as you know? You may not know.
So in that instance, sir, just for your note, para 3.5 of my proof, at Dinting Road, the council had accepted a 1-for-1 replacement. But then they said that wasn't acceptable when my client's application came before it some months earlier. And it just seemed to me that the two positions were wholly inconsistent. And that's the only reason I drew attention to it in my evidence.
Yeah, and presumably you don't know the full detailed development appraisal of that site.
No, but it was providing what was required of it in terms of contributions. There was no viability.
Yes, and sites are different. And,
of course,
I have a lot of detail before me on the viability case in terms of this site. I don't have very much at all in terms of what the inputs, and assuming even the study was done, if they were actually providing for what was required in that particular circumstances.
I think I drew attention to the officers' reports, and there was no reference to viability, so I could only conclude that viability wasn't an issue there. But it wasn't really that point I was trying to make. It was more a consistency decision-taking point with regard to the whether it should be 2-for-1 or 1-for-1.
Okay, and then final one, and this is a without prejudice to your position, but in just in terms of the planning balance required, and I've heard your evidence on that, but without prejudice to consideration of the evidence before me and the outcome of the appeal in due course, if I were to find harm, and that's not saying I've reached the finding, it's a theoretical outcome arising from the proposal in conflict with the development plan. Could you explain your view in terms of the approach you consider should be taken for the purposes of paragraph 11 of the framework in those circumstances?
Yeah.
And that's not representing your view.
No.
It's your understanding if I were to
Yes.
reach that alternative outcome.
Yes. So one would then look at the positive effects of the proposal before you, table 3, page 57 of my evidence. And I believe, sir, it would be perfectly legitimate for you to identify the harm, if there was theoretically found to be any. Not my position.
I fully take it. And again,
just for the benefit of people watching.
Yeah, people shouldn't be reading into a snippet of that.
Yes,
as an accepted. It's
yes.
my question.
Yes.
That's asking about a theoretical
yes.
proposition. And you know, it's because I have a witness here to ask that
yes,
question
of course.
of it. It isn't
Yep.
in any way point that I've made my mind upon it.
No. And were there to be harm identified, one would turn to table 3 of the proof of evidence and look at the benefits. And I think it would be perfectly legitimate in decision-taking terms to weigh that harm against the benefits and come to a conclusion that the benefits outweigh any harm, depending on what scale of harm it is, that you may find, sir.
Yes, so it's the paragraph 11 approach, the alternative approach. If
or the 38.6 approach.
Yes,
have you favoured?
Well, there's effectively 2 balances in that case. So.
Yeah.
It would be a 38.6 approach because we're both agreed that this is not a tilted balance case.
Yes, agreed.
So it would be a flat balance.
It would be a flat balance in accordance with the framework because the tilted balance is not engaged on anybody's case.
Yes, because there's no 5-year supply. That was my next question. Yeah. There's no 5-year supply issue here.
No.
And presumably because of that outcome of it going to 38.6, in your opinion, you consider that the policies insofar as identified are out of date and not those that in terms of as a basket, those most important for determining the application are not considered to be out of date.
That's correct, sir.
No, that was helpful to clarify for me. Like I said, it's theoretical, but it's understanding the path that I need take, and that there's agreed pathway from legal representatives of where to go, because quite simply it can be an area of
it's in nobody's interest for you to go down the wrong road.
Exactly. It wasn't my intent to go down the wrong road either, but I need to know the roads that I need to follow, and that those are agreed between the parties, and seemingly they are. So I can take that away. Thank you. I don't have any further questions on of Mr. Hurrigan, so just thank you for your evidence and the time that you've given. I think it is probably time for a break now. The options in terms of taking a break are we could go to 15 minutes, but we're probably going to need a bit more time after 5 o'clock, or we can have 10. And we might have a fair wind of getting through my questions by 5.
I'm agnostic. Whether we finish at 5 or 15:15, it doesn't.
The question really is: are the parties content to proceed after 5 in the interest of getting through the timetable today, with a view to the closings and the costs tomorrow virtually?
But so we do need to have a quick chat about the evidence proposed to be submitted by Mr. Pape and Mr. Miskell that you wanted us to agree on before it was submitted. So maybe it would be a good idea to do 15 minutes.
Yes,
we'll do 15 in that case, as long as the parties are happy to proceed after 5. Should we need to do so?
Yeah.
I don't anticipate that it'll be much more than half. 5:30 may be more achievable.
Can we just be clear that there's no problem with the room availability?
Yes, just check on the room.
I don't think we're being booted out.
Okay. Thank you.
Okay, in that case, I'll adjourn. It's just approaching 20 past. We'll resume at 4:35. It's now 25 to 5, so 4:35. It's time for the inquiry to resume. Just before we get into the roundtable session on planning obligations, housekeeping in terms of documents received?
Yes, sir. On your left hand
Yep.
are the hard copy documents we promised you.
Thank you.
The update on the other two is that Mr. Pape's desensitised statement has been agreed and will be with you in due course.
Was that 22, just for completeness?
Yes. It is indeed.
22.
22.
And I'm not expecting anything further.
No, so far as the petition is concerned,
Yes.
we have decided that it would be best if you had an agreed statement that said the petitioners were signing to the following statement, and there were, I think the answer is 1,070 something signatures. That way we don't have any data issues. But Mr. Bruin and Mr. Mallow have been agreeing that. I know you said Mr. Nile, but that sounds too much like.
If we can put it in IQ20, that'd be inquiry.20. That'd be helpful to me. That agreed statement between the parties that you've seen the petition with the signatures, and this is what was agreed.
Yeah, no, that's great.
Okay. I'll accept it on the basis that that's what's going to come, and just expect the parties to add to it, and then obviously any electronic copies just need to be sent through to Mr. Brown.
Yes.
Okay. Right. Anything else on housekeeping matters or procedure before we move on to planning obligations? Just to confirm, it is a roundtable session. It does mean that both the planning obligations and planning conditions, the fact that we're discussing this doesn't mean that I made up my mind. It's just standard procedure for me to consider both the planning obligation and any suggested planning conditions when making my decision, and it's necessary that we discuss them so that in the event that planning permission is granted, that I can both give the appropriate weight to the planning obligations should they be necessary, or make a judgment as to whether they're not necessary, and in terms of the planning conditions to ensure that they meet the respective tests. So it's a without prejudice discussion. It doesn't prejudice any party in terms of their respective position by discussing it today. It is inspector led, so I'm going to focus on the questions that I have. That means that there's some areas that will have been covered in evidence that I've heard already that I don't want to get back into discussion on, because it would likely just end up with hearing the same thing. It's purely in terms of what I think the remaining queries I have that need to be resolved for my consideration. Now, there is an opportunity, Mr. Bennett, should you choose to ask a question about one of the conditions on that I may draw attention to. Just raise your hand if you do want to do that. But for obviously efficiency of inquiry time, it's not my intention to run through every condition or planning obligation, because I've heard plenty of evidence during the inquiry on all of those matters. So it's basic. A lot of it's focused on specific wording or what wording means, rather than evidence of itself. We will touch upon evidence, but it's more points of clarification at this point rather than detailed testing and scrutiny of evidence.
So just so you know, for your purposes of your decision letter, to my immediate left is Mr. O'Brien.
Thank you.
And to his immediate left is Ms. Nicola de Bruin, who is the council's solicitor, and you've probably seen her name spelled correctly in email traffic from Kerr Brown.
I have used it. The only question I had was if there's any qualifications that you wanted to be recorded on the decision letter.
I'm a solicitor.
That's absolutely fine. Thank you. Okay. Anything from the appellate side before we start? I'm assuming Mr. Mellon, you'll need to be added because you weren't called as a witness.
Yes, Niall Mellon is going to contribute to the conditions session, so Mr. Hurrigan's going to deal with the obligation element.
Thank you. And I do have the attendance list from the appellants.
Yes,
is Mr. Mellon included on that?
I certainly put him on my appearance list, but I don't think I put his qualifications down. Let me just have a look at my appearance list.
You did put his qualifications down. BA1's
Yes, thank you very
MSc
much.
MRTPI.
Yeah, I did.
So it's just to make sure, BSc ONS, MSc.
BSc MSc MRTPI.
Well, that's easy to remember because it's the same as mine. Okay, we move on to the planning obligations then. So the first question that I had was for the council, and it's on the health contribution. So we're on page 4 of the planning obligation. I think it might be IQ 9, and it's the same comment that I had in my feedback, just in terms of the health contribution. So the question that I had for the council just on the health contribution just is, for the purposes of this session, I'm taking the SIL compliance statement as read. So and I'm not going to ask questions that are answered. I believe are answered in that. So I'm taking that away and considering it in that context. It's only where I think there may be a bit more clarification required that I'm going to ask a question. And the health contribution was one. It was just wondered whether there's any specific projects, because in the SIL compliance statement, it was a little bit vague in terms of how the money might be spent if it were received.
We actually had 2 consultation responses by NHS Derby and Derbyshire. The first was in respect of 100 units and was subsequently revised to 92 units. And when we were drafting the 106 agreement, I noticed that, in fact, they'd asked for the contributions to different places in those 2 responses. So for that reason, it was drafted relatively widely in the section 106.
Okay, and so I need to go back to the consultation responses.
Yeah, and I'm not aware of any particular scheme. I'm guessing that they've suggested 3 particular medical practices in their last response to 92 units. So I'm guessing it will be to one of those practices. Obviously, the amount of contribution probably isn't going to be sufficient on its own to wholly fund, say, for example, an extension. So it may well be that they will need to do further work if and when they get that contribution to decide where to spend it.
Thank you. And anything from the appellants on that particular point?
No, sir. Thank you.
Okay. Next question that I had was on the definition again. So it's page 5. The proposed off-site offsetting area in Chinley is located close to and partly accessed via an existing construction site. The question I had, and this one was just from the appellants, is just to confirm that the 2 parcels in question are free from any legal obligations or impediment associated with, or alternatively contributing to mitigation for that development site or any other.
I can assist you with that, sir. The land forms part of a wider title, which is DY 347408. So my instructions are that it's not subject to any planning permissions or Section 106 obligations relating to the adjacent development. I can further confirm, sir, that on instruction the land is not relied upon for any mitigation relating to any other development.
Thank you. The next one that I had was the same page, description, off-site translocation timetable, and it said it has brackets, such approval not to be unreasonably withheld or delayed. And the question I'd had on that was whether it should be more time-bound than that.
It might be helpful if I respond to that, because There was some dialogue yesterday with the appellant solicitor as to how we would actually deal with the mechanics of that within the agreement. And the council's view was that if we were going to be time bound, we would have to put in a provision for the council potentially to refuse the approval of the timetable, even if the council were actively still discussing it with the appellant. So I think the feeling on balance was that it would be better to stay with the more flexible, not to be unreasonably withheld or delayed, on the basis that approval would be likely, but it may not be possible within a set time period.
Thank you.
Yes, thank you, sir. The appellant agrees with the position advanced by Mr De Bruin, particularly as specialist ecological advice may need to be obtained by the council.
Yes, so my understanding then is it's a matter of flexibility to allow, and that it's entered into by both parties in good faith.
Absolutely.
Yes, sir. Yeah, and for that reason we would like to keep it as drafted.
And then the next page, page 6, it's the definition in relation to open space. So I think the question that I had just is that identified with the planning obligation by reference to a plan? The distinction between the public open space and the publicly accessible open space and the one that's not the part that's not intended to be.
And so the feeling was that it wouldn't be helpful at this stage because the boundaries of the individual dwellings to be sold may well alter during the sales process. And I think the appellant was also of the view that once the open space scheme that needs to be submitted and approved, that may well include a plan if it's necessary at that point to cover off the location. But obviously, if there were ever to be an enforcement issue in the future, the council could very quickly ascertain whether or not the land had been sold to an occupier or to an owner rather of the site.
The appellant agrees, sir.
And then the next query was on page 7, and this shouldn't be taken to me presuming there will be any change. But I just wondered whether the specific reference to Secretary of State for levelling up housing and communities or any other minister or authority for the time being, whether those words were sufficiently precise in terms of future-proofing it for any change in departmental name or powers conferred to particular ministers. It just struck me for the time being. Well, what's for the time being as well?
Yeah. Could we suggest, sir, that it would read after any other minister, delete the remainder of the text starting or authority for the time being, and just put any other minister or authority with responsibility for determining planning appeals made under the Town and Country Planning Act 1990. And then the words for the time being were left in. So.
The council agrees that would make it more certain.
Thank you. And my assumption is any updates, and similar when we discuss conditions, that any updates will be provided by the deadline for the submission of the signed version of the Section 106, which I think at the start of the inquiry parties can confirm to me whether it's feasible. I typically say 1 week or the Friday following the close of the inquiry, and assuming we close virtually tomorrow, and that's without prejudice to the procedural matters that I said that I'm reflecting on, and the potential to reopen the inquiry should it be necessary in due course. Would be Friday of next week.
Yes, sir.
Yes. Okay, next one that I had was about the sustainable travel link, and I think the appellant has answered what the appellant's view is in ID 15, and I'm happy to take that as read and as the appellant's position, unless there's anything that you wish to add to it.
No, thank you, sir. No.
The only thing that I need ask is whether the council's got a view on what was said in on the appellant's position in ID 15 with respect to that sustainable travel link, and just an understanding of the mechanisms as the council see it that justify it as a planning obligation. If for example, the scenarios clearly where I have to make a judgment based on the respective positions in terms of that sustainable travel link, in terms of it being, in terms of whether it meets the test of a planning obligation firstly, and then an understanding of the justification in that context if I were to find that it meets the test for the cascade arrangements that seem to be in place for how the contributions will work if that link cannot be agreed with the county council.
Well, so the starting point for your thought process would be paragraph 9.3, which is on page 21, which is the blue pencil clause. So if you decide that any planning obligation in whole or in part is either not a material planning consideration or can be given no weight in determining the appeal, or doesn't constitute a reason for granting planning permission in accordance with the Reg 122. Those are the three. Either of those things, then, and then it says, then such planning obligation shall cease to have effect within this agreement, save as set out in the decision letter. So then going to the definition of the sustainable travel contribution, which is where the cascade is. It's the sum, and you've seen the provenance for that particular figure, towards the creation of a new pedestrian path between the site and Gamesley sidings, or if such new pedestrian path is not considered deliverable by the council. So in that situation, it can be used to upgrade others. Now, if you were to consider that it was not considered to be deliverable by the council for whatever reason, which you've had explored, the county council's attitude, so on and so forth, then the other cascade measures would apply. Further, you know that the pot available for Section 106 contributions is capped. And you know that insofar as off-site tree planting is concerned, that the council's policy of 2-to-1 has not been met because it is not possible to do so for viability reasons. If there was some more money about, say 61,920, then it would be possible to do more tree planting. And therefore, in the absence of being able to use the sustainable travel contribution for travel purposes, under the first two elements of the cascade, the third element of the cascade is justified. The background to this position, just for your note, was set out at paragraph 10F in our opening statement.
you, Mr. Richards. Anything to add, Mr. Hurrigan, on that particular point, on particularly the third cascade? Because I think I've got plenty on in ID 15 on the first two components.
Yes, of course. So there is a dispute on the application of EQ9.
Yes.
Which you've heard the evidence on. Don't think there's anything else we want to add.
Just one additional point. So you remember that we looked at paragraph 8.5 of Mr. Hurrigan's evidence, and there's some headroom for additional off-site works that we didn't contribute to the full request of the tree officer, who was seeking 130,000. We're providing 72. We didn't provide that for viability reasons. Now, if that sum comes back into the equation, then there's no good reason why we couldn't deploy that sum to the trees which the tree officer had requested.
Yeah, no, that's my understanding, but because of that dispute over the interpretation of policy EQ9, there's a matter of judgment for me.
Absolutely.
In that, and the value of that potential contribution if it were not applied to. And I'm not saying I've reached a view on that.
No, there's a judgment call for you as to appropriate and possible.
Yes.
Those are the two words that we looked at in EQ9.
And in terms of the cumulative value of the tree planting contribution and that, if the third cascade were going to hit, would that be still within the remit of what was requested by the tree officer, even notwithstanding the dispute?
Yes, it would, sir. The figure is in 8.5, but I'm just thinking it's the difference between about 70-something thousand and 138,000.
Yeah.
So.
Of course, I should have prefaced all of this discussion by saying, which you know from the evidence, we think the starting point is it's still compliant anyway.
Yeah.
The link, the payment towards the link, but you've got that from the evidence.
Yes, I assume that was I assume that was a point of dispute, which was the reason why
exactly right.
Why IQ 15 was prepared, because the council, because the appellant has a different position. It was helpful to me to understand the difference in positions. I could reach a judgment, but I just wanted to understand the technicalities of how that cascade would work in the different scenarios. I think I've got an understanding of where it is now, and the judgments that I need to make, and what the outcomes of those judgments may be should I be granted planning permission. Just on that related point, though, it struck me, because there's a cascade arrangement and the tree contribution, that the next question that I had was in relation to the next definition, because it talks about a tree planting contribution. It refers to the sum that's agreed, but there's a cascade arrangement. It was whether there needed to be a brackets there to take account of the cascade arrangements.
The answer to that, sir, is no, because the tree maintenance contribution the tree maintenance contribution and the tree planting contribution, they are triggered at a certain point of time. If there is to be a further contribution to trees under the cascade, that still counts as the sustainable travel contribution. It's just it will be applied to trees.
Thank you. Yes. So the division between the two is necessary because of the relative triggers are different.
Correct.
In fact, yeah.
So I would just point to the actual wording on the sustainable travel contribution, which is that the sum shall be applied towards the purposes of, which was deliberately drafted in that way, sir, so that the definitions of the tree planting contribution and maintenance contribution didn't need to be changed.
Thank you. Yeah, I just had a quick. Next one was page 9. I just had a query on the title, whether it's unchanged from the version appended to the SIL compliance statement. I take that's a factual point.
So we've refreshed the searches. The difficulty with the Chinley site is that title's backdated for the reasons that Mr. Hurrigan's just explained, due to the plot sales off. But what we have in the agreement is also a catch-all warranty as to title, which just covers off any risk to the council by ensuring that there aren't any other persons with a legal interest in the site that need to be party to the agreement.
Thank you. It was just an update because I understand there was an issue of probate as well on the site.
Yes, it hasn't changed, sir, in respect of the appeal site.
Yes, and then again, it was on the sustainable travel contribution. Probably don't need to go there in too much detail. It was paragraphs 229 and 2210. It was just the reason for the triggers. I think I've had an answer in terms of the original question I had, which was in terms of the county council position and delivery of the link and where that was at, and I'm presuming that hasn't changed. No. So it was just an understanding of the specific reason for the trigger of the 20th dwelling.
I think that's what came out of negotiations with the council, sir. But I don't have any more.
I think we would. I think if it's a contribution towards a capital outlay, such as a health contribution, we'd seek to have it up front because there's there will be a lead-in time for the expenditure of that money. But in respect of that particular contribution, it was felt that they didn't need such a long lead-in time. And obviously the appellant are putting in the access first. So in terms of their cash flow position, that is usually the reason why contributions are pushed back in the development process on occasion.
Yes, and I've already heard about how the development would be built out, and
yes.
Obviously there is a significant infrastructure outlay at the offset.
Yeah, and by the time we get to it's quite a long way to get to the southwest corner of the site in terms of the development programme, sir. Yes,
understandably, it's the very last part. So
yeah.
Yes, it was just exploring that point that there was logic to it, and clearly there is. So, in terms of moving to on-site biodiversity, so it's paragraph 2.8, so that's page 16. Just a very minor point about from time to time, it's legal language, but I was just wondering whether it's sufficiently precise to secure the notification of the council of such a change, and alternatively, whether it should be time bound or not.
Yeah,
which it may apply similarly to the rationale that was given when I suggested about time bound on the previous one.
Yeah, for this one we'd suggested within 30 days.
Yes, so it's going to be, there'll be a minor amendment to clause 283 and also 325 to inform the council in writing within 30 days. And that's been agreed, sir.
Can you just give me those paragraph numbers again, please, just for certainty?
283.
2.8.3.
Yes.
2.8.3, yes.
And 3.2.5.
Yes, and that's agreed, and it'll be in the final signed version.
That's correct.
By the deadline. Okay. And then turning to access to adjoining land, so that's paragraph 3.3 specifically. I'm assuming is that now covered by the change to 3.25, or does that need a change of itself? Let me just have a look. No, sorry, I was caught up with an old comment. Just whether the question I had on the access to adjoining land was with respect to the trim trail, seemingly abutting the shared boundary, but I believe IQ 15 has given me a response to that where potentially that could be broken through.
Yes,
it was just a question of feasibility,
yes.
Looking at the layout. So I'm happy, unless there's any comments on that and the ability to do so. I understand that obviously it will be the development of the adjacent land, should it take place, will be subject to a future planning application, and I don't want to preempt any judgments or decisions that may take place on that, notwithstanding any judgments or decision that take place on this particular case. But I had to understand the feasibility of it, and I understand some work will be needed to understand how that link will be provided if it was necessary. But the appellant has drawn me to areas of the shared boundary where potentially that may be feasible and achieved. And I'm assuming the council that I don't have any specific concerns in that respect.
No, sir. The council didn't have anything to add to that, but also, sir, just for your consideration, that if a commercial agreement were entered into for access to the remaining part of the allocation, that it would be subject to a commercial agreement, and that may well have an agreement regarding movement of the equipment on the trim trail, and if necessary an alteration to this 106 agreement if required. In other words, even if it were to present an issue, it wouldn't be an insurmountable obstacle to delivery of the remainder of the allocation site.
Thank you.
Sorry, sir, if I could just add
Yes,
a couple of
sorry.
points to that for the appellant. Chapter 3 of ID 15 is where you'll find our submissions on where one might break through to access the land to the east.
Thank you. Yes, that's helpful.
Obviously, it's a forward-looking obligation. I'd say there'd need to be a permission in place. We don't know when or if the council would bring the land forward, so it's been covered in the 106 to assist.
Thank you. That's all the questions that I have on the planning obligations. So unless there's anything anyone wishes to raise, I'll just expect a revised version to be submitted after the inquiry closes, and obviously without prejudice, as I said, without prejudice to procedural matters that I go on to consider. So it'd be next Friday. So for certainty, that would be Friday the 5th of July.
Thank you, sir.
And I assume that's feasible for both parties to continue working on the changes that have been discussed today. Thank you. Okay, if there's nothing further to add, we'll move swiftly on to conditions. Obviously, as mentioned this morning, there was a further document that the council and the appellant were working on, where they've given me the respective positions on certain matters that I'd raised just as a query to direct this discussion, similarly to the planning obligations roundtable. It's inspector-led, and I'm not going to cover every condition. It's just queries that I've got on particular areas of wording and precision with respect to the compliance of the conditions as set out in the framework. So, first one, the first thing that the council and the appellant had done was to correct some of the references in the plans conditions. So that's condition number 2. The one position on conditions that didn't seem to be in agreement was with respect to the biodiversity net gain strategy and 30-year management plan being included within condition. The appellants contend it shouldn't be because it's in the 106. At the council, any particular response to that position, that whether it needs to be in the condition or not in light of the 106?
Yes, sir.
I think we've added it. We've added it in. Sorry.
You've made the changes, haven't you?
Yeah.
Yeah, it has been included.
Okay, and that's the agreed position.
Yeah, it's just the most recent version, revision 4, was added. That was the one that was appended to the statement of case.
Thank you. No, I've noticed that in this version that it's in there. I'm just checking that it wasn't a matter of dispute that you wanted me to reflect upon. Happy to move on that. Sorry, I may take a bit longer because it's on a Word version, this one, rather than PDF. Yeah. So it takes me a while to scroll down the screen. So, condition 4. So, condition 4 relates to selective removal of permitted development rights, and the comments on that are noted from the parties suggesting that submission and approval of details are not necessary. I don't have any follow-up questions, and I'm happy to move on. I think I may have written the wrong thing. I think it was obscure glazing, that one.
Yes. Condition 4 is obscure glazing.
Sorry, condition 4 is
PD.
obscure glazing. I was picking up the wrong one. Condition number 4 is obscure glazing. Parties, I had suggested the possibility of providing of a submission and agreement, because there's obviously different factory-based specifications, but the parties are happy that it will be sufficiently secured, so I'm happy to move on unless there's any questions on obscure glazing. It was condition 5, which related to permitted development rights, and it seems to me that there's now agreement between the parties on condition 5 in terms of the addition of plots that I identified where I considered that they were comparable to ones where permitted development rights were being removed, and would it be necessary? Those seem to be added, and it seemed to be agreed. So unless there's any further comments on condition 5, again, I'm happy to move on. The next condition was condition 6 in terms of acoustic fencing on selected plots. I note the revised wording of the condition. I don't really have any further questions on that point. The only point that I had, and it arose from observations on the site visit, was whether there's any boundary treatment to be secured with the two adjacent properties off Adderley Place, Woodside View, or the Avening, because at the minute they have there's sections of post and rail fence that's separating that, and just understanding whether there's a particular view from the parties as to why why a condition isn't considered to be necessary in that particular location to secure some form of shared boundary treatment between the site and those properties.
So you will have seen in the evidence, particularly with regard to Mr. Wilson's property. I'm sorry, I can't remember what it's called.
It's Woodside View in Avening, I think, are the two. But I can't
remember which way. Forgive me.
The first one's Avening.
Thank you.
The one that's sat behind is Woodside View.
Yes, of course, right. Woodside View. In the Council's report to committee, you will note that submissions had been made by the occupants of that property to the effect that the appellant should be providing a fence. It was noted that that dwelling, there was 2 permissions. One was granted on appeal and the other one was granted locally. Both had a condition requiring the developer to submit details of a fencing detail to the authority for approval. As I understand it, the authority has received no such details. And as a consequence, given that that was a requirement of the Wilsons' permission for their house, it was incumbent upon them to provide their own fence under their own planning permission. I think I also picked that up, sir, in my proof of evidence responding to third parties.
Yes, I may have seen it, but it may have slipped my mind that I've seen it before. It's probably helpful to address it during the inquiry in any case, to understand the position. So my understanding is that obviously there's an existing permission in place that has provision for a fence, and in your view, basically you don't want to get involved in any provision of that fence if it's necessary as part of an alternative provision.
Yes, which they were due to comply with. And just also to add, so there is obviously a landscaping strip between the boundary and the estate road.
Yes, I have seen that on the plans.
And then, of course, we went into the property to the north, Avening, where there was a boundary.
I think there might have been a gap. There might have been whether it was part of a post and rail and a fence wasn't added. I seem to remember that there was a view through. Whether there may have been a boundary in the past and it's been taken up at some point, I don't know. But
Yeah.
yes. Okay. Anything from the council on that before I move on?
Yes, so condition 6 is specifically for acoustic fencing for
Yes.
3 and 8 between Dinting Vale, so we don't see that would be necessary.
Yes, it's not related to the question wasn't related to acoustic fencing on this. So yeah, I understand the difference. It's an acoustic issue for those particular plots that lie closest to the A57. I understand that. Thank you. Okay, moving on to condition 7. So that relates to importation of topsoil. Again, I note the comments from the appellant in terms of the potential delays arising in restriction on importation of topsoil. The only concern that I've got is if there isn't some form of pause if contamination's found, does it mean that the validation evidence is worth the approval of validation evidence is worth the paper it's written on because the soils are already brought on? So is it preempting an agreement by not having a pause? The way I saw it is potentially marking your own homework for want of a better word on that.
Yes, sir, I think that it should be analysed beforehand, and I've suggested following that analysis and prior to importation of any topsoil to the site, validatory evidence shall be submitted to and approved in writing by the local planning authority.
Yes, noted that, Mr. O'Brien. Just if the appellant's got any particular views, it was the, like I say, for want of a better word, the marking your own homework kind of principle that concerned me a little there. That there wasn't a trigger to make the works actually stop on site if a problem was found, which is typically is what I would have expected. I understand the concern about having to stop, but I think the issue is if you import contaminated topsoil and you're marking your own homework on the validatory evidence, if you bring them onto the site and they're contaminated, well, then you've got the work to deal with the contamination at that point. So I don't see. I think an approach that takes a precaution in preventing it coming to the site in the first place, there's actually benefits for the developer in that context. But you may be able to offer me a different view in that context.
I think if it was going to stop, the appellant would want it to, stop in, a specific area.
It's not going to stop development on site. It's going to stop the importation of the topsoil.
Yeah, it's not stopping. What I wasn't requesting that all development stop. It's just the importation of that topsoil before it's tested can't happen.
That we used.
Yeah,
For the decision.
yeah, that was in relation to.
So if I might add, this is a pre-importation condition and not to be conflicted, as was first suggested, with condition 8, which is to stop works if contamination is found during development. So they're two different things.
Yeah, they are two different things. Yeah, this is about bringing topsoil onto the site rather than what's happening with the site in effect.
And condition 8D, so has been amended accordingly.
Yeah. Just anything on 7 before I move on to 8. Is it something that I can leave with the parties to try and find an agreed position to put to me in the suggested conditions by the same deadline as the planning obligations?
Yes.
I don't necessarily need an answer on it right now because I understand that it may need discussions to take place outside of the room to assess the implications. But As long as there's an agreed position between the parties submitted to me by the deadline, that'll give you a little bit more time for those questions to take, for those discussions to take place.
As Ms Milne says, the concern is delaying the timely development of the scheme, but we take on board the points and we'll sort it out.
Okay, then moving on to condition 8, we just briefly touched upon it, relating to contaminated land. Just to assist my understanding, is the intention agreed between the parties to remove Part A, retain Parts B and C, and replace D with the alternative wording suggested? Just so that I understand what I might receive in due course, because obviously it's a work in progress in terms of the comments. It seems like there's agreement that there's no further investigation works required at phase 2. It says matters in relation to conditions 8, B and C are agreed, so I was assuming that they may sit there. And then condition D, that was the alternative wording for if contamination is found, that again seemingly agreed between the parties. So when I get a revised version next week, presumably, that's what I'd expect to arrive. Yes.
And that was taken from a previous appeal decision letter, that condition?
Possibly one of mine. It does look rather familiar, I've got to say, that wording, but it may not be one of my own. It maybe someone else's.
From memory, so I think it was one by Inspector Christina Downs, but it may be that she's taken one of your conditions as a precedent in that decision.
It's certainly very similar to one that I've imposed fairly recently on a development scheme. So yeah,
it's a very recent decision.
Yes. Those type of conditions are fairly. Inspectors take a fairly consistent line on those matters to do with contamination. There are variations to it, but it struck me that the wording was very similar to wording that I feel like I've used previously in a condition. Condition 9, surface water drainage. The revised wording suggested by the appellant is to provide in response to my feedback, was to provide an implementation clause, and the council response to it is noted. I don't have any further questions on it. The agreement of a timetable seems to me to be a reasonable solution to the concerns that I previously expressed. So unless there's any further questions on that, I'm happy to move on and for it to be revised in the later version.
Yes, so I think we're going to try and merge conditions 9 and 11.
Thank you. Well, I'll obviously let the any merging. I'll let the parties work together to come up with some agreed wording to put before me. I do encourage reducing the number of conditions. That's what we're meant to do in accordance with planning practice guidance. So any removal of duplication or making things more precise and streamlined, covering the same ground, then that's helpful rather than having conditions doing multiple elements of the same thing broadly. Yep, and condition 11 was drainage matters, so we'll cover it very briefly again. Comments noted, including the acceptance of the needs for the details of foul drainage. That was a comment of my own because based on the evidence that I'd heard, obviously there will need to be works around Adderley Place. So whilst I completely understand the appellant's position with respect to a statutory right to make those connections, I think in the particular circumstances of this case, given the relationship to other conditions that might be imposed, it's reasonable details for us to have as part of a condition. Like I said, I just suggest that the parties work together on 11 and 9 to make sure that the essence of what's in there is retained, but if they are merged. I assume there's nothing further on 11. Thank you. And condition 13, it seems like it's relating to piling and vibro impact works. It seemed originally it started out as a rail protection condition, and now it's been repurposed to buildings and structures on nearby buildings. Presumably that's because the distance to the railway was significant enough that it wasn't reasonable to impose that condition.
Yes, sir. I think following a site visit on Friday and making a judgment there on the distances, but then I took into consideration the other houses in Adderley Place as well, and there is to be some piling on the site, so I just suggested this condition. However, it is just a suggestion, and we're willing to accept a condition or some wording similar.
Yes,
although I did discuss this with the appellants earlier, and they are happy with a condition to that effect.
Thank you, Mr. O'Brien. And just for the avoidance of doubt, because obviously we are being recorded and live streamed, and people may view this either now or at a later date.
Yes.
When you refer to having observed it at the site visits, those were your own observations. There was no discussion that took place between any parties on that particular matter or any other matter in terms of the merits of the case.
Not at all. It was just through walking to the west of the site and making my own judgment.
Yes, it's just for clarification, because as you may note from the procedural matters, the planning inspectorate has had to write about the site visit procedures in response to an inquiry that was received over the weekend after the visit, and it was just confirmation, because you said as part of the site visit that we did not discuss those matters. There was no discussion that took place on site about any of these matters, because that position of not being of the rules for a site visit were made clear throughout.
That's correct, sir. It's just that during my previous site visit, I hadn't walked as far to the west as we did on Friday, and I was able to gauge the distances better between the proposed development site and the actual railway, and the height of the railway as well, and the structures.
Thank you. No, I just had to clarify that, because obviously I don't want any implication that we did not follow the rules of a site visit. Thank you. Anything from the appellants on the piling, vibro works impact on surrounding buildings?
No, we did have a discussion, and we're happy to accept a condition on that.
Thank you. So I just expect that those revisions to be taken forward into the revised version. Condition 14. Sorry, we are running a little bit over than when I anticipated. Everyone's happy to continue. Thank you. Yep. So that relates to provision trespass for fencing. Proposed to be removed by agreement between the parties. Again, just for my understanding, I'm assuming that's because of the absence of a shared boundary with the railway. Thank you. And then we're on to the construction management plan. So that's condition 15. The party's suggestion addressing my concerns with respect to the need to maintain access along Adderley Place for existing residents are noted. I've nothing really further to add on that matter. The only thing that I'd ask the parties to reflect upon is just the point that was raised in my questions to Mr. Hurrigan earlier, was whether, in terms of the construction timings, whether there's any possibility of preventing the construction movements via the access road during pick-up and drop-off times, and whether that meets the necessity of a condition. I'm not asking for an answer right now because there wasn't an answer earlier, and I assume that it'll need discussion between the parties as to whether it meets the test of the condition. So I'll let the parties reflect on that, and I'll see what I receive next week.
Yeah.
Yep.
Well, just on that point, sir, our revised wording on condition 15, we specifically say that there shall be no access to the site for construction vehicles from the junction of Adderley Place and Simonley Lane.
Yes, noted that.
Yeah.
Yes, but by routing all of the traffic along the A57, the concern is in terms of pick up and drop off time because of the on-street parking along the A57 at them particular points. Now, I haven't made up my mind in terms of the impacts in that respect in terms of movements in that location, but it was just seeing if there was anything that was feasible through the construction management plan, should it be necessary to address that. Again, if wording was put to me and I didn't consider it to be necessary, I can easily strike it out. But if you don't consider that it's necessary at all or feasible, then whatever I receive with respect to the construction management plan, that is what I'd need to consider.
Yeah, I think the appellant's current thoughts on that restriction would be that it wouldn't meet the test of necessity, and that Mr. Horgan's evidence about banksman, that would be a more appropriate method.
Thank you.
So I'll do a view on that. The way I understood Mr. Miskell's comments were that he was more concerned about the construction traffic leading from the new access across Adderley Place and people walking along Adderley Place from the dwellings in Adderley Place. And that's where a banksman may be required. And I think to reduce or restrict the times of construction vehicles crossing Adderley Place would probably make the position worse, because my knowledge of construction sites is that you get vehicles turning up at all different times, and they may be waiting on the A57 rather than pulling off if they were restricted at certain times, which could exacerbate the situation. And I would say a banksman is probably a better idea there.
Yes, so potentially banksman on Adderley Place and a banksman at the access, trying to deal with that, and that could be secured through the word in the construction management plan. I say I'm happy to reflect on solutions that are offered to me in that context. I'm just exploring what would be feasible, if at all possible, in that location.
Yeah, it's the enforceability point as well. So
I agree. It's very difficult. It's very difficult in terms of enforceability on those things in terms of traffic movements, etc.
Whereas in the alternative, if we have a banksman, obviously that person will be there during construction times and can ensure people's safety.
Thank you. And then, so moving on to condition 6. Sorry, Mr. Bennett, I didn't notice. Go ahead, Mr. Bennett.
If I could just clarify whether the construction management plan would include a description of how the actual A57 would be managed during the construction phase for the access road. I would envisage that it may require temporary traffic lights to reduce the carriageway by half, perhaps, to actually allow the construction to take place on that frontage, and whether or not the point that you made about school drop-off and pick-up times would be taken into account if that was the case, because it would obviously mean that a section of road would be restricted to one carriageway if there were temporary traffic lights, and that would mean that any people who wish to park up to collect their children would have to park that much further away from the site of the school.
Thank you, Mr. Bennett. Is there anything in terms of the wording that might secure those details for approval, or whether something can be added in terms of, because we've got parking of vehicles for site operatives and visitors, whether there's something to do with the arrangements for access to the construction site, and whether that'd cover the banksman as well?
Well, there is criterion 8, proposed temporary traffic management restrictions.
Yes, I'll leave it with the parties to consider that point in terms of what would need to be approved in the site-specific circumstances of delivering the access onto A57 should the development be allowed. Condition 16, so that relates, it's a restriction on times to piling, so it's back onto piling again. Now, I appreciate why it may have been separated because it has restrictions on particular hours. The question is whether it could be merged or not at this particular point. It may become overcomplicated, condition 15, if it has that component. So I don't have any particular strong views. It was just an idea. So again, happy to leave it to the parties in terms of condition 15 and 16. Now condition 17. Relates to timing of construction and demolition works by agreement between the parties. It seems that it's proposed to be deleted, so unless there's any questions, I believe it was because the construction management plan deals with that. We'll move swiftly on in that case. Condition 18 relates to the highway improvement scheme on the A57. I note that the parties in seeking to address my previous query have agreed to remove the flexibility associated with the pre-commencement component and revise the implementation clause to first occupation of a dwelling. Is my understanding correct? And if so, I presume the proposed wording will just be included in the final version. Okay. '19 is travel plan. So the response to me in terms of an implementation clause is just in terms of the monitoring review for a period of 5 years. So again, I'm assuming that position is agreed on condition number 19, and therefore it's just a case of the revised wording being put to me in due course. Next condition with a query was condition 22, and that relates to submission agreement of details of the turning heads and footways. The parties have seemingly agreed an implementation clause to address my previous comments, and I just again presume that that's just going to follow in the revised version. Thank you. Condition 24, relocation of the bus stop. Note the comment from the parties that because it relates to off-site works, and I'm assuming it's going to be secured by either section 38 or 278. And if so, is the separation from condition 18 necessary to ensure both conditions are precise and not overcomplicated?
Yes, sir, I think condition 8 deals just with the access, doesn't it? And 18 rather. It's just to do with the access, and this is for a wider programme of works, and that's why I've suggested they remain separate, unless you want to see us try and merge them.
Anything from the appellants on that point? Happy for them to be kept separate or not?
I think it was the appellant's view that that would be covered by the section 278 works, and if a condition did have to be there, could it just be merged to condition 18?
I'll let the parties work on that then. Have a look if there's a way of merging it, and in that case, and then we'd I'll see what I receive in the revised version by the deadline next week. Condition 25 seemingly duplicates elements of the construction management plan secured by an early condition, and it's proposed to be removed. I'm assuming that's correct, and it'll just be taken out to the next version. Condition 28 relates to 26. Sorry, relates to delivery of the new estate streets, footways, and cycleways. The parties have suggested some revised wording following my previous comments to reflect the submission and agreement of a timetable as part of the implementation clause. I don't have anything further to add unless there's any comments on that. I'll just expect to see the revised version. (27) similarly proposed to be removed. Relates to highway matters otherwise addressed in the 106. I presume there's nothing further to add and it'll just be taken out. Condition 29 relates to EV charging. The question I previously been put, and it was based and taken account of evidence provided, was that there was a duplication with building regulations, so it's proposed to be removed.
Yes, sir.
Yep. Now, condition 32, that relates to the scheme that we've heard quite a bit of evidence on in terms of the Adderley Place vehicle discouragement scheme. Now, I note the evidence that I've heard that it's effectively the conditions in place to allow further work to take place on it, and obviously I'm going to reflect on the evidence that I've heard with respect to it, so I haven't reached any judgment in terms of the scheme of itself. But notwithstanding that, the question that I had in terms of the technical workings of the condition was that it seemed to me like it was in the wrong order, and I believe that the parties have noted that and agreed it, and they'll provide me some revised wording that will secure it in the ability to submit and agree details and then its implementation. Mr. Bennett?
If I could perhaps just qualify, under the reason given for the condition, that actually it should not only facilitate the clear and safe retained vehicle use of Adderley Place for occupants of the dwellings to the west of the application site only, but also dissuade unauthorised vehicles from using Adderley Place and the unadopted road as an access. Just to make sure that it's understood it has two purposes.
Happy for that to be included in the reason that you put to me. Yeah, I'll just expect that to be updated in the revised version. Thank you, Mr. Bennett. Condition 34, relating to landscape and ecological mitigation and management plan, seeking to address my previous comments and not proposing amendments to the suggested condition, and instead has cross-referred to where the interventions based on Ms. Kerr's proof of evidence, where they're otherwise dealt with in the condition. So it's a point of clarification in the ID 16 document. I'm happy to take that away and reflect on it. With no further changes considered. That reflects the council's position. Your view is that if it's dealt with elsewhere, it doesn't need to be included in that condition. Thank you. It was just a clarification where it was dealt with, but I think that's been done now. Condition 36. So this relates to tree protection. Parties have seemingly suggested that the condition could be revised to just include relevant components of the implementation of the arboricultural impact assessment, so that's CD 265. Is my understanding correct in that respect, and should I just expect a revised version that will just secure those measures?
Yes, sir. We're happy for it to be carried out in line with the IMA.
37, implementation of a planting plan. The seemingly agreement between the parties that street tree planting would take place in accordance with agreed timetable. I'm assuming my understanding is correct. So again, just a revised wording. Condition 38, existing shrub, tree and hedge retention. Again, it seems like the parties have reached agreement on removal of reference to off-site tree planting. So I'm assuming that'll just be removed in the next version to be received.
That's correct, sir.
Condition 39 relates to tree monitoring and is seemingly to be deleted. Alongside that, those amendments to the AQIA. The next one was condition 43, where there were queries. Was related to implementation of the trim trail and the leap. The appellants suggested a revised trigger of the 75th dwelling, with the council adding flexibility for a revised timetable. Just my understanding for that threshold, is it similar to the rationale given previously for triggers, the site-specific lead-in times, the investment in infrastructure?
It is, yes.
Thank you. I'll just expect a revised version then. Then condition 44, which is archaeological investigation. The parties have suggested some wording changes to address the approach to works taking place along or across Adderley Place. Just for my understanding, is there agreement to that revised wording, or is it something that the parties are still working on?
I inserted that, so because it wasn't very clear the condition, it said along enabling works along the line of Adderley Place. So I've tried to leave it a little bit more flexible in including any works that may take place along or across the line of Adderley Place.
Any comments from the appellant on that suggestion?
Yes, sir. The appellant suggested taking that out because there was no intention to do any enabling works along the line of Adderley Road.
Yeah, I think it doesn't say enabling works. It's any works.
Okay. Yeah. Well. Yeah, I think that's fine then.
Yes, I was thinking more about the crossing and the crossing of Adderley Place more than anything else.
Yes, if that's agreed, then I'll just expect a revised version. And then on condition 46, I believe it just updated a legacy typo, so we don't need to go that as long. That's been picked up there, and I'm assuming it'll follow through. I don't have any further questions on conditions at this stage. The only thing that I'd say is obviously there's potential revised wording changes to pre-commencement conditions in there. So obviously you've provided a written agreement at every stage, so I'm assuming the final version will include that same written agreement for pre-commencement conditions to avoid, in the event of planning permission granted, me needing to go back to the parties to ask for your agreement to pre-commencement conditions. The only other matter that didn't seem to be addressed was just whether the conditions need reordering in accordance with the planning practice guidance. I don't know whether that's something that the appellant and the council will be willing to do or not.
Yeah,
but if you do look at that as part of the revised version, just make sure that any cross-referencing of conditions between, because there are occasional one, particularly towards the end, that those cross-references are updated so that we don't end up with the conditions there, and then me having to come back again if it affects a pre-commencement condition in the event that planning permission is granted. Obviously, I'm assuming you'll want a decision as swiftly as possible, so anything that avoids delays in the event that planning permission is granted is obviously helpful to the appellants, and in any case I'm assuming that a swift decision would help all parties, irrespective, so I don't need to wait for anything. That's why the deadline is given for next Friday.
Yeah, we've seen your note on the ordering, and we'll work together and we'll produce a new list in that order.
Thank you. I'm sorry for keeping everyone a little bit longer, but I thought it was important to get through today's programme, and we were held up a little bit this morning with the unforeseen procedural matters that I'll continue to reflect upon, and also the number of statements that we needed to take to give a final opportunity for parties. But we have got through the programme, so my expectation is that we move on to virtual closings tomorrow and the costs to finish.
So if I may say so, I think it's been very welcome that we've actually got to the position that we have today, so that we've covered a lot of ground today, leaving just the closings for tomorrow now.
Thank you. Anything from the council just before I adjourn until the morning?
No, sir. My client suggests we will not be making a closing submission tomorrow. We made our submissions in opening, and we stand by them. We don't have a right of reply to the appellant's closing unless we wanted to point out some factual thing that we would like you to check or anything like that. I don't know when my learned friend is thinking of sending the council his closing, whether it will be just before he delivers it or whether it might be available a bit before that.
In view of the discussion that we had earlier, I'll send it you later this evening if
that would be very kind.
I was going to say a deadline to curb round for 9:30 to give me the chance to have it before me to hear the closings.
So do you want it to your?
I'd like an electronic copy by 9:30 a.m. in the morning at the very latest.
Definitely so. That won't be a problem. I'm saying 9 o'clock this evening, so my learned friend has the opportunity.
Yes, and then if I wanted to ask Mrs. De Bruin to point anything out tomorrow, she could do so. We might even alert the appellant in advance of that. It would just mean that, frankly, they wouldn't have to pay a fee to me to attend tomorrow to do very little other than listen to my learned friend, which would no doubt be a delight, but would not be a good use of council resources.
No, I understand the whether you want to make a closing or not is entirely at the council's discretion in the particular circumstances.
So what I'm saying is, if you don't see me in the morning, we intend no discourtesy, and thank you very much for the way you've conducted this inquiry. But I'm expecting that you will see Mrs. De Bruin on the screen to represent the council, and very probably not me.
Yes, and the representation for the council will be needed because in case there's anything relating to costs, in terms of the update. And I appreciate what was said at the start of the day, but we have covered a lot of ground since, and it may be the case that verbal updates are needed. So I will need a form of representation. It doesn't have to be Mr. Richards though, as long as the council's happy to be represented alternatively for that session.
We will make sure that somebody, whether it's me or Mrs. De Bruin, is there able to represent the council fully. I have the link details in case even as late as 9:30 I'm asked to jump on the screen. So that's not a problem.
Thank you. I have the meeting link, so unless there's anything else, I'm happy to adjourn the inquiry until 10 a.m. in the morning. Mr. Barrett's aware of the deadline, and you've notified me that I won't be receiving closings from the council, which is helpful, so I won't expect it or chase it. And then we'll resume at 10 a.m. and immediately it will be your closings, Mr. Barrett, at that point. Thank you very much. And then we'll deal with costs thereafter. Right, thank you very much. The time is 5:55. Apologies for keeping everyone long, but we did need to cover that ground. The inquiry is adjourned until 10 a.m. tomorrow morning, online, virtually, via the meeting link on the inquiry website. Thank you.